he needs them, I guess.
I think there were a few others.
There's the one with the book, isn't that one?
Yes, but we have the, oh, thank you, Your Honor. Just going down the list, I picked them up. 212 is a rider release form suggesting that my client requested to ride in a police car on 3/15 of 2010. I don't find any relevance in it. It simply is somebody interested in riding along with the police. He did it once. He did it 2 years before the event. And I would suggest to the court that there's absolutely no relevance whatsoever to what he did as a rider with Sanford Police Department. And again, I know you don't want to go too far into the Martin side of it, but as to the Zimmerman side of it, certainly if information like this is going to be admissible, I think we're going to open up a panoply of information.
You keep telling me that we're going to open up different things, and right now I would like to keep focused on this exhibit, these 5 exhibits. If and when another argument comes up about something else, that's the time I'll listen to that argument.
But I just want to make sure the court's aware that I'm not waiving anything, because I want to make sure that, in my opinion,
I want to make sure that we focus on this issue. So your objection to 212, proposed exhibit 212, is relevancy.
Yes, Your Honor.
Okay, response.
Your Honor, I actually have an argument prepared to go through that'll address all of them.
Okay, well then let's go on to the next exhibit. What is the number?
There is 211, which purports to be a business record from Prince William County Police Department. We would object on a number of hearsay grounds, and I understand it purports to be an unsigned letter with a acknowledgement, but it acknowledges that basically there is very little information available concerning Mr. Zimmerman's application, and then has some summary that suggests the reasons for it. In effect, what it seems to suggest is that Mr. Zimmerman's application for that was not allowed because he had credit issues, because he was unemployed at the time.
What is your objection to this document?
Irrelevancy, and also that there's not proper foundation for authentication. And unfortunately, the problem that we have is this is sort of a summary of an exhibit that doesn't exist. So we would demand the actual application, the witnesses who reviewed the application, the more of a reason why, whether or not any interview occurred, not a summary from somebody who was not there and did not talk to Mrs. Zimmerman and actually hasn't even reviewed the application. So that's the authentication issue.
Okay. Next exhibit.
Seminole State College.
What's the exhibit
I'm sorry,
number?
I have my copy of this one. Give me just a moment, Your Honor. It is part of 209, Your Honor. So let's go through that because it's a composite exhibit. First one being entire transcript.
Actually, we had agreed yesterday.
Okay.
Only the 2 pages that we have submitted for redaction to the clerk is going to be part of that exhibit. The remainder of it, I agreed. After the court reviewed it and didn't want to consider other classwork, take it out.
Right. Do you have the redacted copy to show?
Well, we'll just take this out because this is the entire transcript.
Okay. I think that there's a redacted copy that you should probably
The
look
clerk
at.
provided it to me this morning.
It is not the redaction of the transcript. The transcript is removed completely. There's a redaction of another statement that I'll talk about in a moment.
Okay.
There is both the official transcript and sort of a summary. I think the state's acknowledging that both of those are removed from Exhibit 209. that leaves redacted two statements. One is a diploma certificate application, and one is an acknowledgement of a grade change in what the state perceives to be a relevant relevant class, criminal litigation. Again, the same argument as mentioned earlier, simply about the relevancy, both distant in time and no connection between my client's appearance at a course, or at least signing up for the course, and what actually would be presented to this court. And again, we request a proffer that information to see if the state can tie it together. Similarly, with $210, it is a...
You had said 209 was a composite. Were those the only things that were in the composite, those two documents?
Those two, yes, that's
Thank
all
you.
that's left.
So now you have 210.
Yes, and 210 is also a composite, so I need to go through those sort of individually. There is one that suggests that my client did a homework in a case dealing with such things as, I guess, answering a question, a man in his wife's absence drinks a lot, they get home.
There's scenarios.
There's scenarios, and none of these scenarios would have any relevance to anything, second-degree murder, self-defense.
So your objection to that is relevancy,
Yes, Your Honor.
all right?
And
The other part of the composite?
then there is a final project from my client talking about the Fourth Amendment. Similar objection as far as relevancy unless it can be tied together. And a moment, Your Honor. The other part of this composite exhibit is an excerpt from a book on page 228, the book identified as Criminal Law and Procedure by a man by the name of James McCord and his wife, I guess, Sandra McCord. And this chapter 7 has about 3 pages on the term self-defense. Again, the relevancy without the connectivity between the state and the actual evidence. I think they may have the witness here. I would ask for a proffer to suggest that my client was even present rather than just having signed up for the course, and or that there was some discourse between my client and some witness acknowledging that he in fact did know about this or even read this. And then I presume that this is the same witness who may say that at some lecture, some point, he may have discussed or did discuss Florida Stand Your Ground issues. But again, without any particular relevance, the overall objection to these, again, being that it's sort of a 403. If there's no relevance, then the suggested relevance would be far outweighed by any prejudice, because I do not think that the jury should properly consider my client's past and his knowledge and what he may have known and what he studied, again, for the issue that I mentioned earlier, that I think we're going down a very dangerous path for history. The last one is 201, which I believe is a same excerpt from another book for another class, for another professor, and that seems to be identified. I look at page 196, which is one page on psychological or criminal profiling and geographical profiling. It's actually one page?
It is one because the remainder of the next page talked about racial profiling, and I deliberately left that out.
So again, same relevance argument, unless the state can present that my client had this book, got this book, read this book, interacted with the professor about this book. I think it's purely speculative and would be dangerous for the jury to be asked to consider such evidence for whatever purpose, unless it's properly proffered to you, not only as to the theory of the case and how this would be relevant to that.
So your objection to 201 is relevance. Okay, thank you. Response?
And what's
Those were the 5 exhibits. So on Exhibit 212, your 212, 209, 210, 201, and I guess to some extent 211 are all relevancy. 211 is also authentication. 209 is distance and time, and those are the objections. state respond?
And also, of course, we would want a Richardson inquiry. We did receive these on June 21st in the middle of trial. So as to that.
Well, are those documents that were in the possession of your client?
No. No.
His handwritten homework assignments, his
Absolutely not.
application?
Absolutely
Well, they're his
not.
documents, he knew of them.
I'm sorry?
They're his documents, he knew of them. He wrote
sure.
the applications, he
I'm-
wrote the homework assignments.
And I'm certain that he wrote Valentine's in first grade, but he didn't keep them.
Okay, let's stay on point. Mr. Manti?
Let me
Response?
address just a couple matters first. As Exhibit 201 goes, there is not just the profiling excerpt. There are also chapters on preparing for and presenting cases in court, strategies for excelling as a witness, and testifying under cross-examination. That is all as it relates to Exhibit 201. And I want to make sure that I'm also being clear that Exhibit, I believe it's 210, yes, contains not two, but I think there are 3 homework assignments. The other one being a description of why the defendant is electing to take the course in the first place. I would also note as to 210 that at Mr. O'Mara's request, I have appended the entire course book to proposed Exhibit 210, although I had not originally done so. I don't know that they want that to be part of, if it is admitted, if they still want that to be part of it, but it is there for that reason. Let me start with the idea that we are here on a basic relevance objection. In order to be relevant, the state's, there are more than one theory of this case. There doesn't have to be married to only one theory. There are a number of matters which can be relevant for the jury's consideration, and the state isn't bound to only consider one possible thing or one possible theory. So to say that the state must, for some reason, tie things to a specific matter overstates what the actual law is as it relates to the concept of relevancy. In this case, the court has heard, and I believe will hear further, that part of the theory here is that the defendant's ambitions and frustrations are part of what's going on here. You don't get to consider each one of these things in a little vacuum. We sort of plowed some of this ground the last time we had this type of argument as it relates to his prior phone calls to the non-emergency number, beginning with his creation of the Neighborhood Watch program and for the 6 months thereafter between that and the shooting. I'm going to give a few examples of what we've already heard as far as this trial is. Neighborhood Watch training, his argument that this shows care of the community versus a counter-argument that it could be seen as simply him wanting to play police. He has had a desire to be an actual police officer, and I will point out that Mr. O'Mara has on a number of occasions, and so has Mr. West, cross-examined various people, including Officer Tony Raimondo, about when they decided to become a police officer, why they decided to become a police officer, what they had to do that, and their motivations, and the fact that police officer is, in fact, a noble calling, a good thing. So I think they've already sort of made the idea about becoming a police officer and how strongly that motivates people and that sort of thing relevant by their own questioning. I think the fact of the college coursework is these are courses the defendant elected to take in pursuance of his legal studies criminal justice degree. The relevance of the application for the degree is that he submitted that application in the fall of 2011, and it indicates on his face that he wanted the degree to be conferred after he finished taking more courses in the spring term of 2012. The spring term of 2012. His coursework, at least some of these, already has focused on criminal justice and police issues. His extracurricular life sort of mirrored that interest, that desire that he has stated in a number of forums. The Neighborhood Watch, the Parking Committee, the calls and reports, and again, despite his vigilance in the community, what resulted in the arrest of a burglar in that community was the Stucco Man. He profiles and does follow, and profiling used in the sense that it is a investigatory type tool. He speaks, especially in his written statement so far, in written police jargon. And he tells Officer Serino, well, you have justifiable use of force or homicide. He indicates that. And he also, in that the written statement he made for the police, he uses such phrases as, I unholstered my firearm, not I pulled my gun. So the idea that we haven't already heard things about this to make this prior history and prior training as to why these sorts of things are out there is indeed relevant. And I'm going to talk about general relevance, but I want to go through some of the things that we've already heard in this case as to why these things are relevant. And then we heard the cross-examination of Detective Serino, where we had umpteen mentions of this is a police tactic. I think whether the defendant would have knowledge of it or knowledge of the law itself was brought up. As I said, part of the video that was played for the court, he referenced self-defense or justifiable homicide versus homicide. I think Mr. O'Mara actually said, I'm not trying to discuss trade secrets, but that's the phrase he used. So anytime we're talking about the defendant and tactics being used upon him, I think his knowledge that they were in fact tactics or potentially tactics, and his ability to understand the context of A, criminal investigation, and B, criminal litigation, and those are the titles of the two courses in question, is certainly relevant. I'm going to point out that jury instruction 7.4, this goes back to my point about nothing exists in a vacuum, is an act is a series of related actions. Its relevance shows why the defendant took a particular series of steps, exhibited certain behavior or attitude. 90.401 and 402 define the burden of relevance. It's anything tending to prove or disprove any material fact. It doesn't have to be a specific notion of or theory. It doesn't have to be, it can be. Anything that's material fact. Also, relevance has been defined as a tendency, and here I'm going to go into the cop show case, which is the first case in the stack that I provided to the court and counsel. Render a proposition and issue more or less probable. To be probable, the evidence gets viewed in the light of logic, experience, and accepted assumptions concerning human behavior. In the cop show case, the defense argued a state of emotional distress, which led to the killing. Therefore, they have placed the defendant's emotional state in issue, said the court. And in this case, the evidence in question was an affair that the defendant, cop show, was having. Not a, I'm sorry, that's KOPSHO.
Thank you.
It's 84 Southern 3rd 204, and I'm going to put the site up on the screen in just a moment. And the record here supported, and the court approved and admitted that the evidence of this affair was probative of the emotional state and the credibility of the defendant. I will also point out that on page 8 of that opinion, at the very top, the court discusses that this was put in issue by the defense's second-degree murder theory, and the state also argued that the evidence was relevant to impeach cop show's videotaped statement. So we have a number of purposes for which this is relevant. This isn't impeachment about something merely collateral. It is simply a fact that the jury ought to know. When they hear one assertion on videotape, they deserve to hear the rest of the story. Relevance can pertain to any of the elements of the crime. The defendant's state of mind here, the ill will, the spite, is an element of the crime. That is documented in the Wimberly and Hart cases, which are the next two cases in the stack that I provided to the court. Relevance can pertain to any element of any defense. The state also in this case has the burden to establish that this is not a self-defense case, and that includes whether the defendant might have provoked the incidents, or to use the phrase in the Billode case, which is 578 Southern 2nd 343, and that's Billeaud as indicated on the screen. The theory in that case, and I'm reading from the bottom of page 2, tended to prove a material fact central to the appellant's, in this case it was the defendant wanting to introduce this, that it was the straw that broke the camel's back. This particular camel, if we stick with that metaphor, has been carrying an ambition or a desire to be a police officer and to act in certain ways and behave in certain ways, and I think that's relevant to explain his behavior on the night in question, or at least assist the jury in having a fuller depiction. As far as being relevant to theory of the case, it can show the context of the defendant's behavior. This is a segue into the Holmes case, which we discussed pretty extensively before, which is 91 Southern 3rd 859. It's the next case in the stack. Continuing chain of, and I'm reading from page 3, continuing chain of chronological events. And even though it was prejudicial, almost all evidence introduced by the state is prejudicial to the defense. Credibility is at the heart of the case, and it prevents the state from fairly and adequately making the case against the appellant if the evidence is excluded. In that case, it was evidence of drug dealing. More John is a similar thing, and that can be found on 394 Southern 2nd, 1100, also on page 2, and also, again, evidence of even actually other not-so-good activities. The state isn't asserting that these are bad acts. The state is simply asserting that these are acts by the defendant and things that he has elected to do which are relevant to help the jury understand his actions on the night in question. Continuing on the point about theory of the case, in the Samuels case, which is 11 Southern 3rd, 413, the next case in the stack, and I'm going to read, I think, beginning on page 3 at the bottom, starting around headnote 8. The court in that case admitted a couple different things. First, they admitted evidence that the defendant hid assets in the Cayman Islands in other people's names, and that was relevant to the state's theory of the case. In that case, the state was proceeding on the theory that the defendant committed murder because he didn't want to have to pay child support, and he was hiding assets to do that. Second thing the court admitted was documents from the child custody case that were relevant to the state's theory that the shootings were the culmination, in that case, of an ongoing battle. Again, we're back to the sort of straw that broke the camel's back type scenario. And that citation, again, is 11 Southern 3rd, 413, Samuels. Familiarity, and we may hear this again as it relates to other evidence, but evidence that shows familiarity with or proficiency in certain tactics. In the Marquard case, that's M-A-R-Q-U-A-R-D versus state, it was martial arts and military tactics. But familiarity with tactics, police tactics in this case, is not by itself evidence of bad character, nor is it similar fact evidence of another crime. It's just relevant evidence. Familiarity, in fact, can be a valid reason for a lot of things that wouldn't ordinarily necessarily be admissible. And this is the Rhodes case, which should be the next one in the case, and I'm reading page 9 of 11 of the court's copy, 638 Southern 2nd, 920. In that case, the court held that evidence of actually the defendant in that case being familiar with police procedures because he'd been arrested before several times was familiar, and in that case, to show that he'd voluntarily waived his Miranda rights. So the idea that someone is familiar with police procedures is not an unheard of or uncommon concept in the history of the law, and it's not something that's necessarily inadmissible for any reason. In fact, it's been admissible for, I would submit, far more significant and serious reasons. You're talking about now here supporting the idea of whether somebody waived their Miranda rights. Moving on from theory of the case for a moment, if it is relevant to other facts in issue in a case, any fact in issue, the defendant's motive, the defendant's state of mind as to whether he's profiling or not, according, again, referring to the Hart case, those are classic jury issues. Defendant in his opening statement portrayed himself as simply a concerned neighborhood individual, and there's a question about whether he was concerned or exhibited hostility. Did he observe or did he profile? The impact, and I'm going to move on to the next case in the stack, which should be Eugene versus State, which is 53 Southern 3rd, 1104, and I'm reading from page 4 of that opinion. In that case, the evidence in question, and they were statements and emails that the defendant received, showed they were relevant to show the sudden deterioration of his relationship with the victim, demonstrate their impact on the appellant. And so it's the impact of these prior things that have gone on in his life that can be a fact in issue and is relevant. Other facts in issue. There was ample implication during cross-examination of these witnesses that he only followed Trayvon Martin, that the defendant only followed Trayvon Martin. And this is in the cross-examination of Mr. Nofke, that there was some kind of supposed suggestion in how he interpreted the words. I think the testimony of even Mr. Osterman yesterday sort of indicated, well, I think maybe he just interpreted it some way, but here's what he said. So actually, whether or not the defendant knows better or would have any reason to know better is relevant. cross-examination, again, Mr. O'Mara's cross-examination of Detective Serino about the trade secrets sort of thing. The statements in the interview, especially his written statement. The idea that he has been exposed to materials on and taken a course that covered how to be a good witness. And this is all, again, the coursework intertwined with the other evidence of his ambition and his activity. And not that there's anything wrong with that ambition, but it certainly goes to the defendant's state of mind. He has applied to be a police officer before. He still wants to be one, according to some of his homework assignments. The homework assignments are relevant because that's the sort of thing that he did in the class he was involved. This isn't sort of some passive non-thing, especially the one that tells you why he wants to take in the class in the first place. The idea that he wants to go ride along with police, that he wants to be an affirmative participant in what's going on. Again, not that it's bad, but it's relevant. I will also point out that there is a relevance as to the defendant's particular knowledge. The state argued in a case as part of its identification theory, and I'm now on to the Williamson case, which I think is the next one, that the evidence demonstrated in that the gunman had knowledge of legal forms. The killer in that case had legal forms. And as proof, the state sought to submit that the defendant had actually filled out and knew how to fill out other legal forms, and the court held that that was admissible. Relevant to the issue of, in that case, the identity, and they agreed that the introduction was not 90.403 material. And I will point out, I want to address 403 for just a moment. Rule 403 says the danger of unfair prejudice must substantially outweigh any probative value. I have yet to hear how any of these documents are supposedly prejudicial, let alone unfairly prejudicial to the defendant to that kind of degree. They have asserted none. They are clearly probative of his experience, his desires, his state of mind as of the time of this killing. And so, Your Honor, as it relates to each exhibit in particular, State's Exhibit 209, which is simply the fact that he had completed enough coursework to be applying for a degree at the very term that he would have been completing when this homicide occurred. Two of the particular courses he took, criminal investigation and criminal litigation, which bear in a number of ways on his behavior in this particular incident, as well as his behavior in other contexts, and the fact that he would know, and there's nothing secret about this, the idea is that he, if he were ever involved in this kind of situation, he would know what there might be asked of him, done with certain pieces of evidence, what he might be asked about, the type of questions or the way that they might be asked. He would know these things, or at least would have reason to know these things. Again, as it relates to the prior application for the police force, as well as the application to ride along with the Sanford police force, it just, again, it shows his continuing involvement, and this is over a period of time. This is not some Johnny-come-lately to this idea. This is a person who has decided that he wants to not only do this, but he wants to receive a degree in it. And there's nothing wrong with any of that, but it certainly tells us a little bit about the defendant's state of mind when he encountered this individual that he automatically, the first words out of his mouth were, a suspicious guy. So the state believes that all those 5 exhibits are relevant for not just one reason, but a number of them. None of them are conceivably more prejudicial than they are probative. And we've made efforts to redact the personal information so none of that would get out.
There's none of the bad credit or any type of good credit or any personal information that would...
The personal information we took I screened it first, I asked the defense to screen it too, and the clerk finished the job, and I think between us we pretty much have got everything. The thing that Mr. O'Mara referred to was a summary as to why the application was denied, which does cite COLL credit history. If that would need to be redacted.
I'm
fine if the defense wants that. Again,
if they want to avoid the implication that he was denied for any other reason, I understand that as well. So it is there, but I have no objection if that particular part of it gets redacted. And as far as the authentication of it, it is the letter actually, the research was done.
Just for the record, that's part of 209? No,
I'm
that's
sorry,
part of 211.
It's part of 211, Your Honor. The letter in question and the research was done by Lieutenant Scott Kearns of the Prince William, Virginia Police, and he is the witness who would be testifying about it. They do not keep the full application for any more than their statutory required period, and so the record as to the application doesn't exist, but the record that he applied and was rejected does, because Lieutenant Kearns wrote the letter. As far as whether the defendant had to, I want to address the argument that he somehow had to, we have to establish that he particularly knew about or was present in a certain class when a certain subject came up. I believe, again, that overstates the idea of relevance. The idea of relevance is that the defendant expressed an interest in this type of course. He paid for it. He took it. He was seeking a degree in it. And the notion that a college guy never misses a class, and one of them was even an online course where you'd have to interact in a chat board forum and things of that nature. The idea that you have to establish that he read a particular word in a book, I think, again, way overstates the idea of relevance here. The fact is he sought out and then, of course, had access to and was obliged to get a grade about, and he got an A in litigation, I think a B in investigation. That he had to do all those things and that these were his choices. So I don't think the state has to necessarily prove that the professor put eyeballs on him and had him sitting in the seat in order to make his choice of course and the material that would be covered in that course relevant to the state's theory of the case.
Thank you. Mr. O'Mara?
First of all, of course, they're calling this witness for some type of impeachment, but beyond that, Your Honor, having just been given 10 or 12 cases from the state, I would ask for a couple of hours to actually,
Sir, I gave you all night last night and a half hour yesterday, and I told both sides I understood your arguments, and I needed you to be prepared to come with the case law to support your arguments. So
May I finish my request? May I finish my request? So
may
that it's
I
on the
finish?
record?
I will let you finish, of course. The purpose of having this argument this morning at 8:30 was to give both sides the opportunity to provide to the court case law that would support their position. I have a jury sitting back there. This issue, I spent the night looking at it. Both parties spent the night looking at it. Let me hear your argument.
My request is for a continuance for a couple of hours because I've just been given about a dozen cases from the state that seem somewhat instructive to the court, but I've noticed already, just as Williamson and other cases, just in the moment I've looked at it here, that there are distinguished characteristics to those cases that I need to have an opportunity to present to the court. So, to the extent the court is going to rely at all on the state's argument and the case law that I have not had a chance to review, then I would ask for some time to do that on my client's behalf. First,
Well, again, Mr. O'Mara, in all due respect, we started this issue yesterday afternoon. I had the jury out for a half hour so you could have time to research this issue. You came back and told me that you needed overnight because it wasn't enough time. Recessed early yesterday, provided counsel for both sides overnight to research this issue, and I will listen to any cases that you have to support your position. But I'm not continuing this matter.
with that in mind, Your Honor, the state's cases to date seem to show, first of all, I would think that it is in fact a 404-2 argument, because if in fact they are trying to bring in acts that they are then going to argue the relevancy to the jury, then they are in fact 404 attack on my client's credibility, and they can't slide past their requirement to give us notice of these prior acts 10 days before trial by suggesting, well, that they're not really bad acts. We're just going to argue that they're bad acts. Well, actually what they're going to argue is that they suggest, as the state has now acknowledged, that these acts somehow support their theory of defense for second-degree murder. So they can say to you that they're not really bad acts because they don't want to have a 404-2 analysis of it, but that's exactly why they're putting them in. They are putting them in so they can turn them into seething bad acts, subtle but seething bad acts of my client. So they can't color it one way to bypass 404-2 and then color it another way in their argument to the jury. If, in fact, they are going to argue to this jury that these are evidence of knowledge, of forethought, of knowledge which was the foundation for his ill will and hatred, that he had this available, then it is, in fact, a 404-2 analysis. They violated their requirement under the rule to give us 10 days' notice ahead of time. That then demands a Richardson inquiry as to that issue. So in that sense, they can argue to you that it's not 404-2, but it in fact is. And let's look at why. The case law that they have suggested to you to date, today, is all, in effect, prior bad acts under 404-2. An affair to show anger and hostility towards a person, the wife, ex-wife he ended up killing. Hiding money in the Cayman Islands to avoid child support. A bad act to show what he was doing to presume the ongoing battle between the two. The sudden deterioration of the relationship between the defendant and the alleged victim. Again, the bad act information, 404-2. What they're saying is, well, it doesn't look bad on its surface, Judge, so ignore 404, but we're going to argue that it's bad. We're going to argue that he was a seething cop wannabe and argue that to the jury. They can't slide, I would suggest to the court, they can't slide by the evidence code and suggest to you that this isn't exactly what they're going to do. So I would ask again that they somehow relate this to some theory of the case factually. What does the state say happened on the night of February 26th that makes this information relevant to prove a fact? Do they say that he ran after him? Do they say that he tracked him down? There's no evidence to support that, not to date, certainly, and I don't think that they're going to be presenting any more factual evidence in that regard. So in effect, what they're doing is trying to subtly present evidence through you, through this argument and your ruling, that they will then turn into 404B evidence to the court, and that's not allowable, which is why we have 403, to look at it and say what it is that they're trying to do and what purpose is. So if, in fact, they're going to bring in prior good acts of my client, which they can't do either, by the way, unless they show a connectivity, a relevance to some theory of their case, and I would again ask that they proffer both the theory and further they proffer the actual evidence, because it is still my position that if, in fact, they're going to say my client knew of stand your ground, and that's somehow impeachment, again, on, I believe, a collateral issue, an improper impeachment, but if they're going to say that as a foundation bringing in this evidence, then at least they should proffer it to you for you to make a primary or threshold determination that this is, in fact, relevant evidence, that he was in the class, that he did know about it. What they're doing, and I was only half kidding when I said Valentine's in first grade. There's an enormous amount of information that we carry on with us as adults. But we're not held to know it completely and fully in a criminal courtroom in a second-degree murder case unless you can connect those dots, unless you can say without question, yes. In all of the cases, including Williamson, and I just had a chance to look at, the court looked at it and said, as to that particular issue, where they connected up, this form he filled out is very relevant to this fact, and there is a connection, we will allow it. The problem here is that we do not have any connection. We do not have any from the state. We have great argument that their theory is he wants to be a cop. And somehow, the fact that he wants to be a cop and actually went to a class, we should be able to argue that he wants to be a cop. Well, if in fact they're going to limit themselves before you, that they're only going to argue he wants to be a cop, then it's not relevant. If in fact what they're going to try and argue is he's a seething cop wannabe, then they have to show that there's a connectivity between the two to make it relevant, and they failed to. And I renew my request for the proffer of the evidence so we can see actually what these professors are going to say before a jury hears it, because if in fact it gets to the jury, we can unring that bell, and again request more additional time to address this.
Okay, thank you very much. Did you have something further you wanted to say?
If I could, Your Honor, I just want to refer back to two cases, and that's Marquardt and Holmes, and I'll quote briefly from Marquardt. Evidence showing familiarity with or proficiency in tactics is not by itself evidence of bad character, nor is it similar fact evidence of another crime. In that case, again, that was the martial arts type tactics. So, and Holmes, of course, we covered very extensively when we covered, but this is inextricably intertwined evidence to various things. As far as proffering the evidence, well, I videotaped one of the professors and gave the defense that. As far as a Richardson inquiry goes, they've had certainly access to all the college materials and everything else. They've had the records custodian and his transcripts and everything else have been listed for months. In fact, the defense was so on notice of all this stuff that they filed a motion in limine before this court seeking to exclude any mention of the phrase wannabe cop or anything like that. So to now come in and say, oh, we're surprised by all of this, we have no idea, these people have been listed for a long time. The only exception to that, really, is the homework assignments that when I followed up with Professor Jackson, he provided, it was either a week or a week and a half ago, somewhere around that, and I provided them the day I got them. That's really the only thing that hasn't been, and I will point out, Professor Jackson's been listed for quite some time and has never been elected to be deposed. So I simply say that the effort here to now, and I'm glad I brought the picture along, is being, as we expected, to try to shoehorn this from 401, 402 to relevance to 403, more prejudicial and probative, to now we're at 404. And what that tells me is that the defense doesn't really know what the proper objection is because there isn't one.
Okay, thank you. I have reviewed the evidence code. I've reviewed case law after listening to the arguments by the counsel today. The court makes a determination that the testimony bears directly on an issue in this case. Therefore, testimony is substantive and the objections are overruled. Do you need a few minutes to get your first witness ready?
There was an issue regarding the redaction of the
Credit
application.
As well as I just needed to know whether the course book still you want that included or not.
The concern with the redaction, Your Honor, is though it is distasteful to have that information before the jury, taking it out will simply allow speculation that there was some other reason why, rather than just the fact that he had bad credit. So in the Hobson's choice of having to allow the jury to know that my client had bad credit, which I think is completely inappropriate.
Does it say the words bad
Yes.
credit? What if we just took out bad and just put
Let me
credit?
add one other to this. The lieutenant will say that that is the reason that was listed, and that could mean one of two things. It could mean there was in fact a credit problem, and it could mean that the defendant was not candid about his credit reporting. Either one of those I don't think is an inference the defense wants drawn, but I'll defer to their wishes on that.
I'm in a Hobson's choice. I need to decide
Well,
between.
what if we took out the word bad and just put credit as an issue and left it there?
It says the same thing to the jury. Your Honor. I mean,
Could be they weren't able to verify the credit. Doesn't mean it's bad or good or indifferent.
Actually, if they want to strike the whole last page of it, that's also
Well,
fine.
There you go. Then the last page will be stricken.
I have a
Issue
moment to review it.
not an issue. They're figuring that out. We'll take a 10-minute recess. The court will be back in 10 minutes. Please be seated. Court is in session. Okay, we ready to bring the jury in? Did you make the decision about the redaction for the exhibits?
Yes, we did.
And based upon knowing your objection to those exhibits, but based upon the court's ruling, are the exhibits in the order that you think are appropriate?
Yes, Your Honor.
Okay, thank you. Let's go ahead and bring the jury in.
I'm not asking you to rethink it. Are you letting in all the homework assignments as well, the whole?
All
shenanigans, so to
exhibits,
speak?
those are exhibits 212, 211, 209, 210, and 201, as agreed to be redacted. Let's go ahead and bring the jury in.
Jury is present, Your Honor.
Please be seated. Good morning, ladies and gentlemen. I hope you had a good evening. Before we get started this morning, I'm going to ask my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. State, you may call your next witness.
Thank you, Your Honor. State would call Sonia Bolos-Melvin.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor.
Ma'am, please do me a favor. Spell your name for us and tell us who you are, where you work, and what you do.
Sure. My name is Sonia M. Bolos-Melvin, and it is spelled SONJA-BOLES-MELVIN, and I am the registrar for Seminole State College of Florida.
What is a registrar?
The registrar is responsible for all of the educational records, academic records of the institution.
And I assume that your institution keeps academic and institutional records.
Correct.
I'll show you what has been marked as State's Exhibit 209 for purposes of this proceeding. Do you recognize that document?
I do.
And is that the type of record that is ordinarily kept in the course of your institution's business?
Yes.
And does it pertain particularly to the defendant, in this case, George Zimmerman?
Yes.
Now, there are two sort of sections along with this, if I may, Your Honor. The first is what I'll call a grade change form. You see that?
I do.
Okay. And this was actually submitted for a particular course in a particular department. What is that department, ma'am?
It is legal studies,
Okay. And it is course of which title?
criminal litigation.
Okay. And the second is a diploma or certificate application, also in the name of the defendant. Can you tell me, is this something that, when would a person fill out a form like this?
When they are ready to be awarded a degree from Seminole State College.
So they fill this out to ask to apply for a degree?
Correct.
Right. And tell me when, A, when this form was filled out, and B, if you can tell when the degree was actually supposedly going to be conferred or was being requested for.
Okay, it looks like Mr. Zimmerman applied for graduation during the term of fall, which would have been our fall commencement. And he applied on October 17, 2011.
Okay, so that was when he submitted the application. Does it tell us when he was requesting or thought he would have the degree?
Yes, he thought he would graduate by spring 2012.
Okay. Thank you, ma'am. No other questions, Your Honor.
Thank you, Cross.
No, thank you very much.
May Ms. Bolos-Melvin be excused?
Yes, Your Honor, thank you.
Thank you very much, ma'am. You are excused.
And I would move at this time State's Exhibit 209 into evidence.
Based upon the court's ruling, it's submitted into evidence as State's Exhibit 209. Call your next witness, please.
Thank you, Your Honor. Lieutenant Scott Kearns.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May proceed.
Thank you, Your Honor. Morning, sir.
Morning.
Would you please go ahead and spell your name for us? Tell us who you are, where you work, and what you do.
Lieutenant Scott Kearns, Prince William County Police. Last name spelled Kearns, first name Scott. I'm currently assigned to operations, Prince William County Police, Prince William County Police, and prior to that I was the bureau commander for the Prince William County Police Personnel Unit.
Okay. Prince William County where, sir?
In Virginia, sir.
Okay. And does the Prince William County, is there a particular name of that agency? Are you the city police, the county police? What?
It would be county police.
And does that agency normally keep records of people who apply for jobs in that agency?
Yes, sir.
Jobs, both civilian and as a police officer?
With the police department, yes, sir.
And in your capacity as the manager of the personnel unit, would you be the person who would normally be, I'll call a custodian of records of that type?
Yes, sir.
How long does the Prince William County Police Department keep the actual applications of records?
Well, in accordance with the Virginia Records Retention Act, what we do is we keep them for the mandated 3 years, and after which time it's standard practice for us to destroy the records after that period.
Were you asked to investigate whether you had any records as it relates to an application to become a police officer in Prince William County by the defendant, in this case, George Zimmerman?
Yes, sir.
Were you able to locate the actual application?
No, sir, it was destroyed.
I'm going to show you what's marked as State's Exhibit 211. And do you recognize this exhibit, sir?
Yes, sir.
Okay. What is that?
That's an extract of what we do is after we destroy, you're talking about this, the first document?
Governor.
Okay. After we destroy the records after the period of 3 years, we create a very cursory amount of information on the record that was to be destroyed. Basic information, name, address, date of applied, et cetera. And additionally, we also send out a letter for those individuals that are not considered further into the process. We send them a dated letter with my name at the bottom regarding their status, and then they're not going to be considered further.
Okay. And in this case, what was the date of that letter?
The date was July 8th, 2009.
Now, Lieutenant, I'd imagine you get a lot of people who apply.
Yes, sir.
So is there anything unusual or sinister about just people not getting the job as an officer?
No, sir.
Okay. Thank you. No other questions, Your Honor.
Thank you. Any cross?
And I would move at this time State's Exhibit 211 into evidence.
It'll be admitted. State's Exhibit 211.
Morning, Lieutenant Kearns.
Morning, sir.
Your position in the police department is because you're a sworn police officer and have full privileges as such?
That's correct, sir.
Are you currently serving in any kind of investigative capacity?
No, sir.
It's more administrative?
I just recently changed assignments just over 3 days ago. I'm now the watch commander for the Western District Evening Squad. But prior to that, I was with the Personnel Bureau.
So it's not uncommon, I take it, within a given police department to change hats from time to time?
No, sir.
Maybe patrol, maybe investigator, maybe behind the desk.
Yes, sir.
How long were you in the administrative position prior to your current assignment?
6 years, sir.
So you were the administrator then at the time Mr. Zimmerman applied?
Yes, sir.
Do you have any, you have no copy of his application, I take it?
No, sir, it was destroyed.
And you couldn't tell me, for example, who he used as a reference on his application?
No, sir.
You don't have a personal memory of the contents of the application itself?
No, sir.
Because, as Mr. Vanta said, you get a lot of them.
Yes, sir.
A lot of people want to be police officers,
Yes, sir.
as did you, obviously.
I did.
So, if I understand the process then, there is an application, obviously, and then under your records retention policy, after a period of time, the actual record is destroyed and there is a brief extract or excerpt from the application, or from the process, rather.
That's correct.
In this exhibit, which is marked as 211, you are certifying here that you are the records custodian.
Yes, sir.
And that what's attached to it is a business record.
Yes, sir.
I notice, for example, that it's not on letterhead and it's not signed, and it doesn't have any more information on the document other than the actual written contents of it.
That's correct, sir.
This isn't a copy then of the actual letter that was sent in the mail.
It's not the actual copy that was destroyed. That's the document that was used to create the original, in terms of later my signature was placed on it along with the letterhead.
This would have then basically been the word processing document that was printed,
Yes, sir.
and you don't have a specific memory of reviewing or signing this?
No, sir.
This is just one among other documents that are kept in the system?
Yes, sir.
And then this other page of the document, if you can see it well enough from here, just to help me know what it is this the extract you're talking about?
Yes, sir.
And in this extract, it includes, of course, Mr. Zimmerman's name and social security number and his address at the time. That would be the address at the time he filed the application?
Yes, sir.
It would indicate ethnicity.
Yes, sir.
It would indicate gender.
Yes, sir.
Is that what that means, G?
I'd have to, some of them were rather abbreviated and cryptic. Yes, sir. That's correct.
G would be gender, and then Mr. or would be Mr.
Right. Yes.
A guy.
Yes, sir.
Spanish,
That would be any languages spoken other than English.
so that it would indicate that Mr. Zimmerman's bilingual.
It would indicate that he stated that he knew another language other than English. In other words, we didn't confirm that, so this is all self-disclosed information on the application, and we just transpose it onto the spreadsheet. So we didn't validate anything in terms of his Spanish-speaking skills. That was self-disclosed.
I see. Well, as would be the birth date, the social, and everything else. Right?
Well, some of those things can be confirmed up front through driver's licenses, et cetera, but Spanish would be an actual test that would be performed later in the process.
I see. Gotcha. And then at the end, there is a column that says COLL, comma, credit history.
Yes, sir.
Do you take that to mean that Mr. Zimmerman had a problem with his credit?
Yes, sir.
And that would be a reason why you wouldn't be accepted as a police officer?
That's the reason why we did not consider him further based on that record. Yes, sir.
It makes sense if you think about it, doesn't it? Because a police officer who has credit problems would be vulnerable to criminals, wouldn't they?
Possibly.
They could be put in compromising situations where they may make a bad decision because of their financial concern.
Yes, sir.
So if somebody has bad credit because of their age and not having a clear established work history or any number of other reasons that shows up as bad credit, he would be, in fact, was rejected.
Yes, sir.
So that would mean, I take it, that when his credit got better, or he was able to fully address that issue to the satisfaction of the department, he could reapply.
It's possible, sir.
In fact, you know of people that have applied once, been rejected, maybe applied again, even with other agencies, and ultimately gotten on.
Yes, sir.
May I have just a moment, Judge? Thank you.
Yes, sir.
Thank you. Any redirect?
No, thank you, Your Honor. Ask to be excused.
May Lieutenant Kearns be excused? You said yes?
Yes.
Yes. Thank you very much. You are excused. Please call your next witness.
Captain Alexis Carter, Your Honor.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Captain Carter, if you would, please introduce yourself to the jury. Tell them who you are, name, rank, serial number, where you are.
Roger that. Captain Alexis Francisco Carter, United States Army, assigned to 3rd Infantry Division, Fort Stewart, Georgia. United States Officer, JAG Corps.
Tell me what JAG Corps means.
Stands for Judge Advocate General. I'm basically a military prosecutor in the Army.
So you're yet another lawyer.
Yes, yes.
Captain Carter, do you also teach courses?
I did at one point, but not currently.
Okay. Would that have included back in spring of 2010?
Yes, I taught a course, yes.
Where did you teach that course?
Seminole State College.
And what was the name of that course?
Criminal litigation.
Do you remember the defendant, George Zimmerman, being a student in that course?
I do.
Okay. And actually, do you remember what kind of grade you gave him?
I give him a name.
All right. Tell me a little bit about what type of course that was.
Well, when I got the book, or when I got wind of the course, criminal litigation, I automatically assumed that I'll be teaching it from a more practical standpoint, trial advocacy, things of that nature. But the way the course book was set up, it wasn't really like that. And the time frame in which I had to teach the course, I couldn't really teach it from a trial advocacy standpoint. So it was mostly like a crim law, crim procedure course. We talked about the law, elements of the law. We talked about criminal seizure, the constitutional rights, 4th and 5th Amendment, things of that nature.
Did you almost do any kind of what I'll call mock trial sort of thing?
Not really. Not in that course. We didn't have the time for it. Again, it just kind of focused on the elements of the crime, and we would go through hypotheticals where we would ask the students certain questions regarding certain cases and things of that nature.
You mentioned your course book.
Sure.
I'm showing you just what's, is that your course book titled Criminal Law and Procedure?
Yes.
Okay, and I'm showing you what's in evidence now is, or been marked as State's Exhibit 210. Is this a sort of subsection, very small section of this very big book?
Yes.
Okay, and that's a chapter specifically pertaining to what?
Self-defense.
Okay, and the second part of State's Exhibit 210 is what?
It's a email homework assignment from George. It was the first homework assignment that I gave to all the students.
Okay, and is that the rest of it actually additional homework assignments?
Yes.
Your Honor, I'll move State's Exhibit 210 into evidence at this point.
Are you moving the book or the excerpt?
Just the excerpt and
Okay, they'll come in as a composite exhibit 210.
thank you, Your Honor. Talk to me a little bit, Professor, about what kind of student you remember the defendant to be.
You know, as you always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
You mentioned that, and we talked about State's Exhibit 210 as an excerpt from the book about self-defense. Obviously, you were teaching this course in Florida, so tell me what sort of things you addressed as it relates to the law of self-defense in Florida.
Right. So, you know, the way the book is comprised, obviously the publishers aren't from Florida. They didn't really put Florida-specific things, but I wanted to teach the class from a practical standpoint where these students can really relate and take something from it and apply it to their own lives. You know, with Florida and other states, they have what's called the stand your ground law, which evolved from the Castle Doctrine through case law.
And did you cover that specifically?
Yes.
Did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
And did you address the particularities of... Strike that question. Bad question. Professor Carter, what can you tell us about how long you spent as part of that course covering ideas like self-defense and standing?
Right. You know, self-defense is a affirmative defense. It's a big self-defense. It's not one of those things that you're going to just whisk through in a day, or after you teach it, you're going to neglect from bringing it back into the classroom. So it was something that I constantly iterated. I was the type of professor that before I gave any tests, I gave a review for the test. And it was something that I think the students really wanted to know about. It was so practical that they were very much engaged in class discussion regarding the issue. So I remember, you know, talking about it, you know, quite a few times, not just on one particular occasion.
Thank you, Professor. That's all the question.
Okay, thank you. Cross?
Excuse me a second.
Sure.
Good morning, Mr. Carter.
Good morning.
My name is Don West. I'm one of the attorneys for Mr. Zimmerman. You see George over here?
How you doing, George?
And Mr. O'Mara's co-counsel on the case.
How you doing?
How long have you held your current position in JAG?
October would be 3 years.
And you taught at Seminole State College, was it beginning the semester of January 2010?
Yeah, so it would have been from January 2010 timeframe to probably, I don't know, May.
Was it just the one term?
Yes, I only taught one class, and that was it.
Mm-hmm. And what did you do after that?
right around that time, well, I was also working as a PD. I was at the public defender's office during that time, full-time as Orange County Ninth Circuit. So I went back to work, and I left for the JAG Corps for training October 2010. So I went back to work full-time to the PD's office, and then went off to the JAG Corps.
Were you working for the public defender's office in January of 2010 while you were also doing the adjunct professor?
Yes.
I got you. Okay. Do you remember when you started with the PD's office?
So that would probably be November 2009.
Was that shortly after you became admitted as an attorney?
Yes.
Admitted to the bar?
Yes.
So that was your first job
It was.
as a lawyer, was with the public defender's office?
It was.
And then you took on the responsibility of the class as kind of a side job?
Yeah, you know, I hopefully one day I could be a law professor, and I like teaching. And you know, the cool thing about that job, teaching, was that a lot of the things that I have to know or had to know every day from my job as a PD was reinforced by educating others.
So when you made the comment that your approach to the class was really from a practical standpoint, you were talking about how this stuff works in real life?
To the extent that you can, you know, it's been said that there's law on the books and law in action. You know, anybody can tell you what a recipe is, but if you get in the kitchen and don't know what you're doing, you're going to mess up the recipe. So understanding the law and how it's applied, especially when you're dealing with crimes, is so different than anything else. Any fact or change in fact can change the outcome, you know, so that's what I meant.
So even though there might be thousands of individual facts, it could be just one or two that may have significance?
Well, no, all facts have significance. You generally look at things from the totality of the circumstances, but there's certain things that, you know, through case law have been seen to give more weight.
Sure. The totality of the circumstances is you look at the sum total of the evidence, I take it, and then also apply common sense.
Right. A reasonable person standard is what that's generally referred to.
In fact, interestingly, it's the reasonable person standard or the reasonable belief standard which squarely is part of self-defense.
Yes, you can say it.
And we'll talk about that more in a minute, but the work that you're doing now,
Yes.
are you prosecuting or defending?
Prosecuting.
Just prosecuting?
Just prosecuting.
Do you have the opportunity to defend?
No, I do not right now in this position that I am, but the way the JAG Corps is set up, they put you in a certain position, and throughout your career, you move on to different things. Before being a military prosecutor, I dealt with administrative law, federal regulations, interpreting of regulations, giving legal reviews, things of that nature. So as you progress, they move you on in almost like a little circuit.
So that would include defending at some point, perhaps?
Possibly, if I chose it. The Army sometimes cares about what you want, and then sometimes it's just the needs of the Army. So wherever you're best suited, your skill set, and wherever they need you is where they're going to put you.
Is this your career?
I'd rather not comment on that right now.
Fair enough. Let's go back, though, a little bit to the class that you taught.
Yes.
You commented that the course book that you used, well, first of all, you didn't write the book.
No, I did not.
It was a book that was suggested or?
Suggested. I think the previous professor used that book, and when I spoke with the director of the legal department, they said, hey, this is the book that we normally use. You know, take a look at it. It seemed pretty straightforward, standard book that you would see in a criminal law course.
But it was not Florida law.
No, not specifically. I think they probably maybe reference majority, minority of states, but I don't think they ever probably talked about Florida specifically in that book.
Oh,
I
I was
ha-
just looking for the other exhibits for a
So
second.
I have them.
Let me take a look and see.
Sure.
what we got there. So the textbook that you used, thank you,
Sure.
was not specifically focused on Florida law as much as it was sort of a general discussion of a great many topics within this broad subject of criminal litigation and procedure.
Yeah, but then, you know, I try to supplement that with other materials and things of that nature, discussion to focus them on Florida distinctions, because I felt it was important, you know, even with respect to other criminal procedures and things of that nature. I felt giving the students some sort of focus, concentration on Florida law was important, so I did that.
So, for example, in part of Exhibit 210, it's an excerpt from the book that says self-defense. And I'll have you just
Sure.
take a look. Just that this isn't a specific discussion of Florida's self-defense statutes or what has been characterized as stand your ground.
Negative.
So that's true, it's not.
Yes, that's true. It is not.
Okay. So your discussions then that would be more focused on the laws in Florida would have been in the class,
Yes.
not in the textbook.
Correct.
Okay. As a member of the Florida Bar, then you took the bar exam and
Yeah.
had to learn Florida law in addition to the more broad general principles.
Yes.
So you had an understanding of Florida law as it relates to self-defense, specifically because of the Florida statutes.
Yes.
Just for the jury's benefit, a statute is a law that's been passed by the legislature and
Codified.
codified. So
Right.
when we say a statute, that's what's written in the law book.
Yes.
So the law of self-defense is written in Chapter 776, Florida statutes.
I'm not sure the chapter and verse, but if you say so, yes.
Do we have it? Just to take a look. This is not a trick question.
No, it's fine.
Is it on your? We'll come back to that
Sure.
in a second. But the idea is that the laws that are passed by the legislature and then usually signed by the governor and then become law are known as statutes, and they're in the law books.
Yes.
And that then becomes the law of the particular state where the legislature has acted.
Yes.
And you are familiar, generally, again, I won't ask you the specific wording, but you're generally familiar with the law of self-defense in Florida.
Yes.
You talked a moment ago, for example, how the stand your ground had evolved from the castle doctrine.
Yes.
Stand your ground is sort of a nickname for the statute. The statute itself isn't titled Stand Your Ground.
No,
or such
I don't
thing.
think any legislator would write that such a way, but it's a nickname.
So the is the word codification? The codification of the castle doctrine became Florida's stand your ground law insofar as the use of self-defense.
You can say that, yes.
The castle doctrine is the notion that if you are in your castle, in your home, and you are attacked, you have no duty to retreat, even if you can. You have no duty to retreat. You may meet the force with force to defend yourself.
Yes.
Am I right generally on that?
Yes.
And then by the evolution of that doctrine into what's been generally characterized as stand your ground, what it did, basically, was allow someone to defend themselves outside their home if they are attacked,
Correct.
without the duty to retreat.
Correct.
Before that, if you weren't in your home and you were attacked, before you could use deadly force, you had to retreat if you could.
Yes.
If you safely could. So in other words, if there's an attack outside, you have to sort of assess the situation, decide.
Let me hear the rest of the question, and then you may approach.
Under the old law, with the duty to retreat, if you weren't inside your home and you were attacked, you would have to assess the situation and make a decision at that moment whether or not you could safely get away before resorting to force.
Yes.
You may approach.
Thank you, Mr. Carter. We're back. The discussion that I'm having with you now about the Castle Doctrine and this law that's become known kind of by the nickname Stand Your Ground was the part of your classwork that wasn't contained in the book. Is that right?
Yes, it was not contained in the book.
Because of your training as a lawyer, having passed the Florida bar, been admitted to the Florida bar, and indeed working in the public defender's office, you were using that information and your understanding of Florida law to talk about these issues with your classes.
That is correct.
Okay, so what we were talking about then was the evolution of the Castle Doctrine into what the legislature did some, like 7 years ago, 6, 7 years ago, something like that, into what's been known as Stand Your Ground. So
Right.
that's sort of the focus.
Right.
Okay. The Castle Doctrine was this idea that if you were in your home,
It's actually, yeah, same objection.
I think a clarification needs to be made if his answers to these questions are based upon his personal knowledge in his profession, or it's what he taught the class. Can you make that distinction?
Say again, ma'am?
Whether or not your answers to these questions are based upon your knowledge as an attorney in your practice, or are they also something that you taught the class?
The evolution of the Castle Doctrine?
That's the question.
Yeah, that would be something that I hit on in the class.
Then you may proceed. Objection overruled.
so what that means basically is that when you are at the Castle Doctrine, when you're in your home and you're attacked, you don't have to worry about whether you can get away. You may meet force with force.
Right.
Sort of a. And then what happened when the statutes changed a few years ago into this what's been known as Stand Your Ground, basically the Castle Doctrine of no duty to retreat was simply authorized in locations other than your own home.
Right. I think what happened is the presumption changed. You know, if you're attacked in your home, there's a presumption that you're in fear of your life. A lot of times attacks happen at night. You're scared. You've been woken up by something. So there was a presumption that you were in fear of your life. So that's how that came about. And then it extended outside of the home. But there wasn't that same presumption. That same presumption doesn't exist outside of a home. It's dwelling, residence, I think your vehicle is where that presumption is. But outside of the home, there wasn't that same sort of presumption. I hope that makes sense.
Well, I know you're taking us to school, so let me clarify a couple of things. You're suggesting that when the attack occurs in certain locations, in addition, is there no duty to retreat, but there's sort of a presumption that if it happens, that you will be in fear for your life.
So yeah. So if you're in your home, that's in your home. There's a greater indicia that that person had a reasonable fear of death or grievous bodily harm.
Okay, but if you're in your home and I don't want to go too far away from why you're here testifying today, but I want to clarify, though, that part of self-defense is, under any circumstance, the reasonable belief that you have to act to avoid imminent great bodily harm.
Oh yes, no question to that. So
There's an objection.
I'm sorry.
My objection is that the framing of the question is counsel's version of the law. And
I'm going to sustain the objection, and and state to the jury, at the end of the conclusion of the evidence of this case, this court will give you instructions on the law that you are to follow and apply to the facts as you find them. Your questioning needs to be as to what he taught the class, not a general discussion on what the law is.
Yes, ma'am. Thank you. So when you taught the class, what is the core concept of self-defense when you can use deadly force?
When you have a reasonable apprehension of death or grievous bodily harm. And the term reasonable is obviously has two components. So there's a subjective component, meaning that I feel like I'm in fear. In my mind, I feel like I'm in fear of death or grievous bodily harm. But when stuff hits the fan, you're judged by jurors. And your actions have to meet a reasonable standard objectively. So whether or not a reasonable person in your position would have felt the way you felt.
All right, so what you would explain then to anybody that was there that day would be that on the issue of the reasonable fear, it's both subjective and objective. The subjective part is crawling inside the person's head to see what they were thinking and would it be reasonable to them that they would fear for their life.
Right, and that's why the totality of the circumstances are important.
Mm-hmm.
For example, if you approach me right now in broad daylight, whatever the case is, I probably wouldn't have that much fear. But, you know, the lights are out, I don't know what's happening, I feel someone grab me. Those are circumstances you need to consider and whether or not someone had a reasonable apprehension of fear.
So the first part then is trying to understand as best you can from the totality of the circumstances whether that person was in fear in their own mind. Did they think that serious bodily harm was about to happen?
Right.
And then you're saying then there's a bit of a shift. And then in order to see if that's reasonable, then the trier of fact, if you will, the jury then looks at this idea. Does it make sense that somebody in that person's situation, with all of the circumstances, would fear that they were facing imminent great bodily harm?
That is correct.
Nowhere in the discussion of self-defense is it required that the person being attacked actually be injured. It's really the issue of what they think is going to happen, not what's actually happened. Is that right?
I'm going to object again.
Okay. The court will instruct the jury on whatever the law is at the end of the case, and that is the law that you are to apply to the facts as you find them. Your discussion today is limited to what you have taught in the course.
Yes, I understand.
Mr. Carter, the presumption is that any question that I ask you today is either to clarify an answer that you've given, to explain the legal concept, or connected directly with the way you would explain these things to your students.
Right. I understand that.
I'm not going outside the scope of that.
Understood.
So what you just explained is how you would explain this self-defense concept works in Florida.
Right. And it's fluid. You know, the law as it applies isn't static. Like I said, any change in a certain fact can weigh differently in terms of whether someone acted reasonable. And, you know, to illustrate that, I would put up examples on the projector. I would have YouTube videos and pause it frame by frame. Okay, what's happening now? You know, what is this person justified in doing? What are they not justified in doing? And so you can see that, you know, things can change in a matter of moments.
An encounter that doesn't appear to be deadly can turn deadly pretty quickly in your mind.
Oh, yes. Yeah.
On the issue of injuries, though, when you talk about that with the class and your understanding of the law, is that the focus is what's going on in the person's mind, not whether they have actually been injured. It's the fear of the injury, is it not?
It's imminent injury, imminent fear. So the fact alone that there isn't an injury doesn't necessarily mean that the person did not has a reasonable apprehension of fear.
Mm-hmm.
The fact that there were injuries have a tendency to show or support that that person had a reasonable apprehension of fear. But the fact that there wasn't an injury at all doesn't necessarily mean there was a reasonable apprehension of fear. You know,
You don't have to wait until you're almost dead before you can defend yourself.
no, I would advise you probably don't do that. Yeah.
And I take it, when you're under attack, you never really know where that moment will be.
No, unfortunately, you don't. And that's not even something from our. That's something that I think a lot of the students grasped. You know, I think we've all, and they have all probably had situations where, you know, a tussle maybe became more than just a tussle. So things can change.
For example, things can change that a situation that may not have appeared to be deadly or the risk of great bodily harm at first can develop into that.
Yeah, and we also talked about imperfect self-defense, where you may have started out being the person that was attacked, but for whatever reason, you took it a step forward, and now you're the aggressor. So that dynamic between, you know, two people involved in a fight or a scuffle, that could change.
You use the term imperfect self-defense.
Right.
Is that the notion that sometimes the tables can turn?
It means that, or also means that the person acted unreasonably in countering the force that was applied to them or approached with them.
Hypothetically speaking, this discussion that you started, if I'm approaching you,
Right. So if you're approaching me,
and let's say that I push you.
yeah, it'll be a little extra if I picked up a video camera and knocked you upside the head. That'll be a little extra, and that would probably be an imperfect self-defense.
So let me see if I'm clear. What you would explain then would be, for example, I'll use the hypothetical that we started here. So if you and I were facing each other, and I pushed you or bumped you, and you reacted in great disproportion to what I did, then it turns, and you could put me in fear for my life, and then I would have the right to defend myself at that point, even though, under the hypothetical, I may have started it.
Yes.
So in that situation, I would be trying to figure out what's going on. How far are you going to go?
Yes.
How much danger am I really in?
Yes.
And under that scenario, would it be reasonable that if I were screaming for help and you didn't stop over a period of 10, 20, 30 seconds, that I screamed for help, making it clear I wanted no part of this, then I would have then an appreciation that you weren't going to stop.
Judge, I'm going to object to the continuing and the specificity of that hypothetical.
Sustained.
Without the specific details that I'm talking about, that's what you're talking about, in a sense that it really doesn't matter. The focus of the self-defense is at the point that the force is used. And it's only really a relatively minor consideration as to what actually started it.
Objection again as to counsel positing things.
Right, if you will rephrase your question, because you began it with the former hypothetical that this court sustained. So if you'll rephrase your question, please.
I will. I'll try. Thank you. When you're talking about what you call the imperfect self-defense. What you're really talking about is when you're involved in a situation with somebody, even if you start it, but the tables get turned, and then all of a sudden you're the one that's being attacked with far more force than you used. That's the scenario I'm talking about.
All right, so let's repeat back what you're asking. So, basically, in a sense, if someone initially feel that they were being threatened, and they countered that threat with a force that was disproportionate to the force that was directed towards them,
Right.
yes, that would be an imperfect self-defense claim or imperfect self-defense scenario.
So even under that scenario, the person that may have started it with some lower level of force, and the table turns on them and there's a great level of force, a disproportionate level of force, they have the right to defend themselves.
Right.
So actually, yeah. We're continuing number one, the same hypothetical. Number two is too specific to.
I'm going to overrule on that one, and the answer was given.
I didn't hear the answer. Would it be read back? You agreed?
Yes.
May I have just a moment? Thank you, Your Honor. Captain Carter, thank you.
You're welcome.
Any redirect?
Captain Carter, did you discuss in the context of all this, is when you're talking about the self-defense law, the idea of claiming it when you, yes, Your Honor, the idea of claiming it when you have provoked the action, that enter into the discussion?
Objection, Your Honor. May we be heard at the bench?
Yes. You may proceed.
Thank you. If I could, you're talking about the imperfect self-defense. Is
Right.
that discussion of sort of provoking use of force? Is that included?
Say again?
In your concept of imperfect self-defense.
Right.
Where you talked about from starting as an aggressor to moving to something else. Is that sort of provocation? I mean, is that the concept you're underlying with that, or is that not what you're talking about?
What I'm talking about when it comes to imperfect self-defense is a situation where you do not meet the force that, or the force that you are encountering, you meet that force disproportionately. It's excessive force.
So I guess then the ultimate level of force in these scenarios is deadly.
It's deadly force,
Like a gunshot.
like a gunshot.
No other questions, Judge? Thank you.
Thank you, Captain.
Thank you. May Captain Carter be excused?
Yes, Your Honor.
Thank you very much, Captain Carter. You are excused. I'll call your next witness, please. Anybody need a recess? No. Call your next witness, please.
Call Jim Krinsky, Your Honor.
Raise your right hand. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Thank you.
You may proceed.
Thank you. Mr. Krinsky, would you please go ahead and spell your last name for us? In particular, tell us where you are, or I'm sorry, where you work and what you do.
The spelling of my last name is K-R-Z-E-N-S-K-I. And I'm the Administrative Services Manager for the Sanford Police Department. I basically oversee all the administration of the police department and report directly to the Deputy Chief.
And by administration, does that include the records that the department keeps and maintains?
Yes, I have 4 records technicians that report to me.
Okay. Sir, I'm showing you what State's Exhibit 212. Is this one of the types of records that you just referenced kept by the Sanford Police Department?
Yes, sir.
Okay. And you've seen records like that before?
Yes, sir.
And what is it?
This is the Sanford Police Department writer release form.
When does a person fill out a form like that?
When they request to ride along with a police officer.
Okay. And was this filled out by a particular individual?
Yes, sir. There is a particular individual here.
And who was it?
George M. Zimmerman.
And when was it filled out?
It was filled out, according to this, on 3/15/2010.
Okay. And does the person indicate whether or not they have a reason for wanting to go on these ride-alongs?
Yes, sir.
And what is that reason?
It states here, solidify my chances of a law enforcement career, I believe, a career in law enforcement.
Thank you.
You're welcome.
Your Honor, I'd move State's Exhibit 212 then. No other questions.
Okay, we'll come into evidence of State's Exhibit 212. Cross, please.
Very briefly, Your Honor, thank you. Morning, sir, how are you?
Good morning, sir.
You, of course, reviewed all of your available records to come up with the one time that Mr. Zimmerman sought a ride-along with a police officer, correct?
Yes, sir. We searched for this record. We have literally hundreds of these, yes, sir.
Sure, and there was only the one where Mr. Zimmerman did that back in 2010,
Yes, sir, to my knowledge.
never requested it again.
To my knowledge, no.
Were you aware at all in your records that Mrs. Zimmerman had responded after that ride-along, talking about the officer that he had rode along with?
Not directly, sir, no.
Not in any of the records that you keep, that when you were looking for that record?
No, sir.
Okay.
I didn't find anything related to this ride-along other than this form right here.
Okay. Then I have no further questions. Thank you, Your Honor.
Thank you. May Officer Krasinski be excused?
Yes, Your Honor, please.
Okay, thank you. You may be excused, sir. Call your next witness.
Could we approach, Your Honor?
Yes. Ladies and gentlemen, the next witness that is going to be called is going to be appearing by Skype, and that's not scheduled to happen till 11 o'clock today, so we were a little ahead of schedule. So instead of just sitting in the courtroom or starting with another witness and stopping at 11, we're going to take a recess from now until 11 a.m. So if you'll please put your notepads face down on the chair and follow Deputy Jarvis outside the courtroom. Please be seated. Court will be in recess until 11 a.m. Please be seated. Court is back in session. Are we ready to bring the jury in a moment?
We're having an issue with the audio, Judge.
Okay.
I know this shocks everyone. Mr. Pleasance, can you hear me?
Yes.
Yes, I can hear you.
Because I cannot hear you.
Let me try this. How's that? Not working? Okay, I can hear
Can you
you.
hear me?
Yes.
Okay, I cannot hear you.
Try that. Speak again. Can you speak again?
Testing, 1, 2, 3. All right, I can't hear you though. That's the issue. Let me get with them, see if we can work it out. I'll keep the phone on. Lou, they can hear me. I try now.
All right, can you hear us now?
Well, it sounds like a joke. Yeah.
Sounds like what?
Exactly like it. Can you sing a Christmas song? If needed, maybe I can hook up my iPhone to make that as well.
I do have a proposal. We can leave the phone on for the audio that way.
Yeah, as long as we can hear him, if he can only hear you through the
We'll do that.
phone.
I'll do that.
think
They're get their pull up my laptop and see if that works better.
well, I have an alternate solution. You can hear us fine, right?
Yeah, I'm on the phone.
Well, we
Okay.
can hear him.
We can speak to you this way, and we can hear
But
you
we
fine.
can hear him. He can't hear us, is that
Yeah, we can.
You can't hear us through Skype, you can hear us through
the phone?
It's just their speaker system with that.
I understand. We can actually just ask our questions through this phone call. Go ahead and have a seat at the camera.
Okay, we can do that. We're just gonna. Oh, okay. I'm gonna turn this off.
No. Don't turn that off.
Oh, he's turning off the sound.
That was just my volume.
Leave your volume on so we can hear you, and you will hear us through the phone. Got it?
Yeah, I was turning down my volume.
Okay. We'll proceed like this. That work for you?
Yeah.
Okay. Thank you.
Okay, let's go ahead and bring the jury in.
Jury's present, Your Honor.
Please be seated. Mr. Manti, call your next witness.
Thank you, Your Honor. We call Professor Scott Pleasance.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Professor Pleasance, would you go ahead and make sure you spell your last name for us, please?
It's Pleasant, P-L-A-S-A-N-T-S.
And I understand you are testifying remotely at the moment. Where are you at, sir?
I'm in Delta, Colorado, on the west side of Colorado, Delta County District Attorney's Office.
Let me get that fixed. And Professor, can you still hear us okay?
Yes.
Professor, where do you teach courses at?
Seminole State College of Florida,
How long have you been a professor there?
3 years.
Okay. And do you teach a course that is variously entitled Criminal Investigation?
Yes, I do.
I'm holding up a green and blue book. Can you see it?
Yes, I can.
Is that a copy of the course book that you routinely use in the course?
That is one of the books, yes.
Okay. And I've previously shown you what's State's Exhibit 201. Is this just a packet with some excerpts from that textbook?
Yes, it is.
Okay. Do you remember teaching the course in terms of 2010?
Actually, it's 2011, summer of 2011.
Summer 2011, is that when you had a student named George Zimmerman?
Yes.
Okay. And specifically, simply as it relates to the course, what sorts of things do you cover?
We cover various aspects of criminal investigations, the duties of a criminal investigator, some of the constitutional issues surrounding criminal investigations, and basically different aspects of different types of crimes.
Okay. Your Honor, I would move State's Exhibit 201 into evidence.
Okay, 201 will come in as State's Exhibit 201.
I made the previous objection where we just renewed that, Your Honor.
Yes,
403
pursuant to the
inquiry.
court's order.
And Professor Pleasance, the course that you teach,
is that sort of an in-classroom course, or is it a different type?
No, this is a distance learning course where we teach it online and requires activities by the student and that's based on the coursework in the book.
I'm sorry, would you go ahead and repeat that starting from the beginning?
Yes, is it coming across?
Go ahead.
Okay. Could you repeat the question?
Sure. Is this a in-room course, or is it a different type?
No, this is a distance learning course where the students are online and I facilitate the class, do the textbook discussions and a workbook exercise.
Okay. And how do you facilitate those types of discussions?
Basically, we have a discussion forum that is.
Start again, please.
And,
Start that answer again.
we have weekly discussion forums starting with an introductory discussion where each of the students introduces themselves, what types of needs they're going for, what their career goals are, and then each week we have discussions.
Okay.
Those weekly discussions are based on different topics.
Okay, and as I understand the excerpt in State's Exhibit 201, there are chapters on how to testify as a witness, as well as on psychological or criminal profiling?
Yes, sir.
Okay, thank you. No other questions, Your Honor.
Okay, Cross. Is that his phone that's getting
It's,
those messages?
it's someone calling the destination, Your Honor.
I get it. Just hit decline.
I have no control over this computer.
That's all right.
Hold on, I'm just declining.
I gotta tell you, there's now a really good chance that we're being toyed with, just so you know.
I can do that. Nope.
Is there another phone that we could call into?
It's gonna take just.
That's not a cell phone?
That's-
Is there a
I have somebody
landline
trying to call in on this.
there? Okay. Turn down the volume. Is there another phone that we can call into that is a landline that we will not have the pop-ups of people calling?
Well, the pop-up that they're calling on
Okay,
is the landline.
hang up the phone.
Yes, Your Honor.
It's off now. It's not hung up, but it's off. You take,
No,
hang up.
I don't want those up on the
Yes, Your Honor.
screen. Let's find another phone number that we could call Professor Pleasance on.
Okay.
Let me just get rid of the whole thing.
Professor, we are going to call you on a different line, okay? Can we call you back on the cell line? Okay, because it's the Skype that's the problem. It's the landline you're using. Okay, thank you. I will leave you on the phone with him.
Great.
Sir. There's a speakerphone function if you want to use it.
We just hung up. We
Call him
can
back.
call
That's fine.
We can use yours, right?
Sure.
Just get out of Skype completely.
It's out.
Yes, Professor, hi, this is Mark O'Mara. Can you hear me?
Yes, I can. It looked like somebody was trying to call in this computer.
It looked like about 4 dozen people were trying to call in once they realized what number they can call and get on TV, I think. But hold on 1 second, okay?
Could you put that up to a microphone?
Would you go ahead and just tell me your name again?
Gordon Paul Pleasant.
Okay, we'll try it again. We're just trying to set up some audio problems. I'm going to try that again and ask that you tell me, and just hold on 1 sec. Say your name again.
Gordon Paul Pleasant.
Is that working on?
Yeah, thank you.
Just have a second to get reorganized.
He said his name. Pleasance. Pleasants.
have other options. If this doesn't work, I have a speaker I can hook up to if I'm going to try this. So we'll see where we go. Because I'm afraid of feedback with my voice. Again, just to check and make sure that the audio is now working okay. Tell me again how long you have been working for at Seminole State College.
Approximately 3 years.
Is that acceptable? Okay. And if I might first quick
Yes, you may.
Again, good morning, Professor. My name is Mark O'Mara. I represent George Zimmerman in this case, and I have a few questions to ask you, okay?
Okay.
Great. You mentioned, I think, that this, in fact, was an online course, correct?
Correct.
And there was no classroom appearance, correct?
There's no required classroom appearance. I did have a mock crime scene where students could voluntarily attend, which Mr. Zimmerman did.
Great, and we'll talk about that a bit more in a second. There was also a course book that was identified, correct?
Correct.
But in order to take the tests or the quizzes you gave, was there a need to actually read that book?
There weren't actually tests for this course. We actually had a workbook where they would investigate a homicide from the beginning to the end, and the textbook was to assist with that and the discussions.
Okay, so when I look at State's Exhibit 201, which is an excerpt from that textbook, you could not give testimony today that this was even covered in class, correct?
Yeah, I can't guarantee that that was discussed back and forth with the students.
Well, yeah, and again, we may have some audio difficulty. I'm going to ask you to repeat that last question when I asked you that you could not even tell us here today whether or not this was even discussed in class, correct?
Yes, or if he read the material.
Or the, excuse me?
Or if he read that material.
Or that they read that material. So
Right.
it cannot be your testimony here today that, for example, Mr. Zimmerman, being a class participant, even read any of the book, correct?
That's correct, and we do have students that do that.
And this portion that talks about profiling, geographic or criminal profiling, there was no coursework that even touched on that subject, was there?
No, there was not.
There's also another one talks about strategies for excelling as a witness. Was that discussed in coursework at all?
Let me check. That might have been a discussion topic, but give me a second.
The second half of that question again, sir?
Yes, sir.
Answer?
I said I need to check. That might have been one of our discussion topics.
Okay. And can you testify here today whether or not George Zimmerman was even present for any of that discussion on the online course?
He was participated in all of the different discussions that we had.
And how is that documented, just so we know?
It's through the Sakai management system, and any of the discussions that we have, since they're in writing, they're maintained, and I can pretty much go back at any time and look at those.
And I'm sorry, the last half of that answer, sir?
I can go back at any time and look at those discussions that the student participated in.
Okay, and now are those records somewhere available to you?
Yes, they are.
Okay, you don't have them with you today, though?
I actually have printouts of the discussion. That's what I'm looking through right now to see if we covered testimony.
Okay, well, maybe we'll take a moment to see if you can review those and then tell us about that. Just repeat that one more time, if you would, sir.
On review of the material showed that it looks like that was not covered in discussions.
Okay, so the issue concerning strategies as a witness or testifying under cross-examination were not covered in your coursework?
Is more than one. The book was
I'm sorry. I'm going to ask the question again because I couldn't understand your answer. Understanding again that we have some audio difficulties. Was there any discussion about testifying or acting as how to be a witness in your coursework? Yes or no?
like I said, it was part of the required reading, but we didn't address it in the discussions or the actual course.
Okay. It was in the book, correct? Sir, it was in the book, correct?
Yes, it was.
Okay. But it was not discussed in any of the coursework. Is that also correct?
It does look like it was not discussed.
Okay, thank you. And in preparing, in applying for the course, you actually had the students fill out an initial information sheet, correct?
No, we did have an introduction discussion the first week of class.
Okay, and in that introduction discussion, what did George Zimmerman tell you was his career goal?
He said that his goal was to become an attorney and eventually a prosecutor.
He wanted to become an
An attorney and prosecutor.
attorney and eventually a prosecutor.
Yes.
And that was his career goal that he gave to you back in 2000 and I think 11, you said, in summer?
Yes, he posted that on June 23rd of 2011.
Okay. I'm going to have a moment, Your Honor.
Yes, you may.
I don't have anything else. Do you have any?
No, Your
Okay,
Then I can just-
Mr. Pleasance, you are excused. Thank you very much, sir.
You're on speaker. Did you hear that the judge just excused from further testimony in this case?
No, I understand.
Yes, you are excused by Judge Nelson. There are no other questions. Appreciate your time.
Thank you for your assistance. State, call your next witness.
Amy Siewert.
You want to ask you to come in and approach for just a moment?
Yes, you may.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Good morning, ma'am. If you please tell the members of the jury your name
I'm Amy Siewert, Siewert.
and how are you employed.
I am employed by the Florida Department of Law Enforcement, Orlando Regional Crime Laboratory.
How long have you been with FDLE?
11 years.
And your current position is what?
Crime Laboratory Analyst assigned to the Firearm section.
Explain to the members of the jury what your duties are as a crime laboratory analyst in the firearm section.
Sure. My duties as an analyst are to examine submitted firearms for safety and function, to examine fired ammunition components that are submitted as evidence to determine if they've come from a particular firearm, as well as distance determinations on clothing.
And how long have you been an analyst in the firearm section?
I've been an analyst for 3 years.
How long total, or you said you'd been in with FDLE for 11 years. What did you do prior to being an analyst in the firearm section?
I was a forensic technologist for 5 years in the firearm section, and previous to that, 3 years as a forensic technologist in the toxicology section.
And what did you do as a forensic technologist in the firearm section?
I performed function examinations on firearms.
If you would share with the members of the jury, please, your educational background.
I have a Bachelor of Science degree in chemistry.
And what training have you had to prepare you for your duties as a crime laboratory analyst in the firearm section?
As a forensic technologist, I completed a 6-month FDLE training program, which enabled me to perform function examinations on firearms. And as an analyst, I had an additional 14 months of structured hands-on training in firearms identification. And this included units on firearm operating systems, cartridge case and bullet comparisons, as well as muzzle to object distance determinations.
Have you ever been qualified as an expert in the courts of the state of Florida in the areas of firearm function and identification?
Yes, I have.
How many times?
17.
At this time, I would tender Amy Siewert as an expert in the area of firearm identification and function.
She may testify as such.
Have you had an opportunity to analyze any evidence in the state of Florida versus George Zimmerman under the FDLE case number of 12-05-01890?
Yes, I have.
And specifically, did you examine a firearm and holster in this case?
Yes.
May I approach the witness?
Yes, you may.
Ms. Siewert, let me ask you to look at 154. Just ask you, do you recognize that?
I do.
And what do you recognize that to be?
This is the firearm and holster and magazine that I received as part of this case.
All right, would you open the exhibit then?
Yes.
How do you recognize it to be the same firearm that you analyzed in this case?
I recognize it by the FDLE case number, exhibit number, and my initials.
And what type of firearm is it?
It is a 9mm Luger caliber Keltec model PF9 semi-automatic pistol.
And what do you mean by semi-automatic?
In very basic terms, semi-automatic means that a pull of the trigger is required for each shot to be fired.
And what do you mean specifically by 9mm?
9mm refers to the caliber of ammunition that the firearm is designed to fire.
Are you familiar with that brand of firearms, the Keltec brand?
Yes.
How so?
I've had the opportunity to tour their manufacturing facility twice, as well as I have examined many of them over the course of my casework.
And did you examine the firearm to determine whether or not it was in working order?
Yes, I did.
How did you do that?
I did a general firearm exam. I took note of the make, model, and serial number, looking at the overall condition of the firearm to determine if it looked safe to test fire. After determining it was safe, I used laboratory and evidence ammunition and the submitted magazine to test fire the pistol.
And what did you find when you test fired the gun?
It was functional.
Your Honor, may she step down to demonstrate in front of the jury?
Yes, you may.
Ms. Siewert, if you would step down with, I'm going to grab the exhibit for you. Grab the whole thing. Your Honor, there's a gun lock on the exhibit. May I remove that so she can explain the function to the jury?
Yes, you may.
All right. If you would. Just.
Can you give to the deputy to clear the gun?
I was going to ask that, and
Yeah.
I was going to ask if I could move to a
You
bench
may.
where you see her.
You may do so.
Say it, Your Honor.
All right, Ms. Siewert, if you would explain to the members of the jury how that firearm and anything else you need is in terms of the magazine, how it functions.
Absolutely. I'm going to start real quick with a basic definition for you. Right here is what we call a cartridge. It's commonly referred to as a bullet, but it contains at the very top of the bullet the cartridge case at the head of primer and inside of it, gunpowder. Now, these cartridges are loaded into a magazine, which is essentially a container for these cartridges designed to feed into the firearm itself. So cartridges are loaded one on top of another in the magazine. The magazine is then inserted up the magazine well of the pistol, and then the user, typically this is closed, the user will pull back on the slide and release. And as they release, the top cartridge from the magazine will be removed from the top and loaded into the chamber, and the pistol will be ready to fire. In order to fire a shot at this point, all you need to do is pull the trigger.
All right. And is there a way to load the firearm so that you don't need to pull the slide back to chamber a round?
You have to pull back on the slide to load a cartridge into the chamber. That's the only way to get it in.
All right. If the magazine was full, could that be done?
Yes.
All right. Explain to him how that is.
With a loaded magazine with the capacity of this particular one is 7, you can pull back on the slide and release, and it will load that top cartridge. Then there'll be 1 in the chamber and 6 in the magazine. If you desire, you can release the magazine, load another one so the magazine would be full for a total of 7 in the magazine, reinsert into the pistol, so the total capacity between the magazine and chamber it'll hold is 8.
All right. Do you recall how many cartridges were with the firearm when you received it?
I received 7 cartridges total.
All right. And the magazine holds how many?
7?
All right. So if that firearm had been fired with 7 in the magazine, does that mean that someone had to place a live round in the chamber?
With the way I received it with 6 in the magazine and an additional 1, it would be consistent with the magazine fully loaded and 1 in the chamber at the time it was fired.
All right. And does that firearm have any features that prevent an accidental discharge?
Yes, it has internal safeties. It is double action only, which means that the firearm cannot be cocked unless the trigger is pulled. Pulling the trigger will both cock and release the hammer, which is located back here. It's also shrouded, so you cannot get to it to be able to cock it. It also has a hammer block, which is a mechanical piece that prevents the hammer from being in contact with the firing pin unless the trigger is pulled, and then that will drop out of the way and allow the hammer to hit the firing pin.
What do you mean by trigger travel distance?
Trigger travel distance is the distance that the trigger has to be pulled rearward in order to release the firing mechanism, or in this case, cock and release the hammer.
And what's the distance or relative distance of the trigger travel distance on that particular firearm?
This particular gun has a longer distance than most typical pistols.
Is that another feature that would help prevent an accidental discharge?
Yes. You have to pull back significantly in order to release the firing mechanism.
All right. Did you also receive a holster with that exhibit, with that firearm?
Yes.
All right. Would you show that to the jury and just show them how the two go together?
This is the holster. There's a clip on the back. Just inserted.
All right. So that would be the total size of it if a person were to wear that on their hip, either inside or outside their clothing.
Yes.
All right. Thank you, ma'am. You may resume your seat. Yes. Could I ask the deputy to do that? Thank you, sir.
While the course will, I'll be asking her some questions and using it with the lock off as well. I didn't know if you want to wait. Thank you.
All right. Ms. Siewert, what is meant by the term trigger pull?
Trigger pull is the amount of force required to release the firing mechanism.
And are you able to measure that with any particular firearm?
Yes,
Did you measure that with this firearm?
I did.
Explain to the jury how you did that.
I hung a series of known weights from the shooting position of the trigger where the finger will rest. And I kept adding weights until the trigger was pulled and the hammer cocked and released.
And what did you find when you measured the trigger pull?
It was between 4.5 and 4 3/4 pounds.
And is that within the manufacturer's specifications?
Yes, it is.
Did you also receive a fired cartridge case with this evidence?
Yes.
How many?
I received one fired cartridge case.
Your Honor, may I approach the witness? Ms. Siewert, let me show you states 147. Ask you if you recognize that.
I do.
And how do you recognize that?
F. Dealey, case number, exhibit number, and my initials.
And what do you recognize it to be?
It is one fired 9mm Luger caliber cartridge case.
When you receive a firearm in a fired casing, are you able to determine whether or not that particular casing came from that particular firearm?
Yes.
How can you do that?
With a submitted firearm and magazine, I will use laboratory and/or evidence ammunition to test fire that pistol. I will then collect the fired cartridge cases and compare those microscopically to the evidence cartridge case or cases that I've received.
And did you do that with the shell casing or cartridge case in this case and also the Kel-Tec pistol?
Yes.
And what did you find?
The cartridge case was fired in the pistol.
Did you also receive some bullet fragments in with this case?
Yes, I did.
Your Honor, may I again approach Ms. Siewert? Let me show you states 165. Ask you, do you recognize that?
Yes.
And how do you recognize 165?
Again, by the F. Dealey case number, exhibit number, and my initials.
And what is that? What's contained in that exhibit?
There is one fired jacket portion, two fired bullet jackets fragments, and one lead core.
And when you receive parts of a bullet or fragments of a bullet in a firearm, are you able to compare those to determine whether or not those fragments were fired from a particular firearm?
Yes.
Explain to the jury how you do that.
Similar to the cartridge cases, I'll use the bullets that I've test fired from the submitted firearm and compare those microscopically to the submitted evidence bullet or bullet fragments.
And did you do that with the fragments in this case and the Kel-Tec pistol?
I did.
What did you find?
The fired bullet jacket portion was fired from the pistol. The two smaller fragments were inconclusive, and the bullet core is not suitable for a microscopic examination.
All right. And when you say inconclusive, what do you mean?
I was not able to determine whether they were or were not fired from the pistol.
And why is that?
A lack of detail on them. They were very damaged. They had very small portions of rifling on them.
All right. Is it apparent that those fragments hit something, the bullet, and caused it to fragment like that?
Yes.
All right. Did you also receive some clothing in connection with this case?
I did.
And if you receive clothing in connection with a firearms case, are you able to determine or attempt to determine the distance between the muzzle of a firearm and the clothing at the time the firearm was fired?
Yes.
How does that work? How do you do that?
When a gun is fired, a cloud of partially burned and unburned powder particles, vaporous and particulate lead, as well as smoke and gases, will follow the bullet out the barrel. This cloud can potentially leave a pattern on an object, or if the firearm is in contact with a particular object, no pattern will be left, but other physical effects will be present.
All right, and did you conduct those tests in this case with the clothing you received in the 9mm pistol?
I did.
All right, Your Honor, may she step down again?
She may.
Thank you. Let's see, but let me ask you to stay right there if you would. You want to take that over there? Actually, let's put it down. Ms. Siewert, if you could join me over here briefly. Mr. Doriani, can you give me the exhibit number?
155.
All right. Let me ask you to examine the packaging from 155 and tell the members of the jury whether or not you recognize it.
I do.
And how do you recognize it?
F. Dealey case number, exhibit number, and my initials.
All right. And is this an item of clothing that you examined in this case?
Yes, it is.
And conducted distance testing on?
Yes.
All right. If you put that back in here real quick. Lift this up. All right. Explain to the jury first what this is, what you saw, and what you did.
was item of evidence that I examined for a distance determination. And what I did was I was looking at the area surrounding this hole. I was looking for partially burned or unburned gunpowder particles. I was looking for any type of sooting present around this hole, as well as looking at the ends of the fibers as to whether they were blackened or singed or melting.
And how did you?
Whether they were blackened or singed or
Melted.
Okay, yeah, if you would just stand back just a little bit so the court reporter has a visual of you, that would help. What did you do to test fire with this particular item? Did you take a cutting from it, or what did you do?
I did. I removed a portion of the back of the sweatshirt for testing purposes.
All right, and Mr. Trayvon, if we could turn this around real quick. Can you show the members of the jury where you removed the fabric to conduct your test?
Right in this area.
Mr. Trayvon, if we could go back that way, and this way. Thank you. Ms. Siewert, just from there, is this the fabric that you removed that we see on the exhibit on the back?
Yes, it is.
All right, is that having a test fire hole in it?
Yes.
Okay. All right, let me ask you, Mr. Durham, if you grab that packaging out. $156. You recognize the packaging?
Yes.
How do you recognize it?
At the case number, exhibit number, and my initials.
And this is obviously a sweatshirt that you examined in the case?
Yes.
And again, if you can show the members of the jury the area that you focused on as having a bullet that passed through it.
This area right here was where I was looking right underneath the Nike swoosh.
And as with the previous exhibit, did you make a cutting from the exhibit?
I did.
All right, and is that depicted on the back of the exhibit, if you would just come around and look?
Yes, it is.
Okay, both the cutting and then the area on the sweatshirt where it was cut out?
Yes.
All right, let's just show that to the jury real quick. And that's been displayed, again, with a bullet hole through it from your test fire?
Yes.
All right. You may resume your seat. In conducting the test fires, did you capture your analysis with photography?
Yes, I did.
All right, let me ask you to look then at States 122. Your Honor, if we could have assistance with the lights. And if I may approach the witness.
Yes, ma'am.
Give me this laser pointer. It works by depressing that button right there at the top. What is States 122 first?
This is a picture of the outer sweatshirt that I had examined for distance determination.
All right, and explain to the members of the jury just the significance of the items that you've marked on the exhibit.
Sure. This is an overall shot of the sweatshirt. I measured the distance about 9 inches down from the top shoulder seam and approximately 7 inches in from the side arm seam.
All right, in States 123, what's depicted there?
It's a little difficult to see with the particular color of the fabric, but what I was looking at here are a few gunpowder particles surrounding this, as well as some blackening right around the hole, as well as some tearing of the fabric and burning and singeing on the fabric ends that were torn.
And is that a close-up, obviously, of the bullet hole on the sweatshirt?
Yes, it is.
All right. States 124, what is that?
That is the inside of that same area. Right here, you can see a little better the blackening that I was looking at.
So that's a close-up of the inside of the sweatshirt.
Yes.
All right. In States 125, what's depicted there?
That was the distance test that I had made using a portion of that sweatshirt.
All right, and just take them through how you conduct the distance test, what ammunition you use, and why.
Absolutely. Using the submitted pistol and submitted ammunition, I test fired into portions of both garments that I received. And the reason for doing so is the pattern that can be left behind using a particular firearm or ammunition can vary greatly depending on the length of the barrel, the size and style of the bullet, as well as the amount, shape, and burn rate of the gunpowder contained within the cartridge.
So you actually used one of the 7 live rounds that you received with the exhibit to conduct this test?
Yes.
All right, States 126, what do we see there?
That is a close-up of the distance test that I had made. The arrows are pointing to diagonal tear that occurred in the fabric.
And when you conducted the distance test with the Kel-Tec pistol and the hooded sweatshirt, what did you determine about the distance between those, the muzzle of the gun and the material at the time the gun was discharged?
The clothing displayed residues and physical effects consistent with a contact shot.
Meaning the muzzle or the end of the barrel of the gun was up against the sweatshirt when it was fired?
Correct.
All right, let's go to States 127. What is that?
This is the other sweatshirt that I had received to do distance determination on.
And again, you made measurements of where the hole is relative on the sweatshirt?
Yes.
All right, incidentally, if both of those sweatshirts were being worn in their intended fashion, that is, forward, do the 2 bullet holes line up?
They do.
128, what do we see there?
With this, we are looking at the tearing of the fabric. You can see there are a few gunpowder particles, which are not easily depicted in this photo, as well as some light sooting and burning and singeing of the ends of the fabric.
In the reddish-brown staining, that would be apparently blood?
Yes, it is.
All right, not something that you applied?
No.
States 129, what is that?
The inside of the hole that was in the previous photograph, and again, you can see a little better the sooting, the blackening surrounding the
Can you
hole
circle
itself.
that for the jury as best
Yes,
you can?
sorry.
Okay. All right, in States 130?
And this is the test that I had generated using a portion of the back of the garment.
And when you conducted that distance test, did you also use the 9mm firearm as well as the ammunition that was present with the firearm?
I conducted that simultaneous to the first one. I had layered the darker sweatshirt over the lighter sweatshirt and fired one shot through both. So this is from the same
Just so we're clear, the hooded sweatshirt you would have put on the outside, the lighter sweatshirt would have been on the inside?
Correct.
All right, and what did you find distance-wise when you conducted the test with this particular sweatshirt?
This as well was consistent with residues and physical effects of a contact shot.
So again, evidencing that the end of the gun was against the material when it was fired?
Yes.
All right. And finally, States 131.
Generated with the lighter color sweatshirt, depicting a little better that you can see the tearing and the blackening of the fabric right around the hole.
All right. Are your findings consistent with the muzzle of the gun having been pressed into the dark hooded sweatshirt and then fired through both the dark hooded sweatshirt and the lighter colored sweatshirt?
It is consistent with the muzzle of the firearm touching the the outer sweatshirt and the inner sweatshirt being in direct contact with that outer one, yes.
All right, thank you, ma'am. Judge, that's all I have. Thank you.
Okay, thank you. Do you want to break for lunch at this time, or you're
Your
going to?
call, Your Honor.
Well, I don't know how long you think it'll be.
I think I can probably get through it, so we'll get this witness off the stand. It might take me 15 or 20, but I can't imagine it's more than that.
Okay.
And if I get to 20, you can remind me where we are if I don't notice, but I'll get through it.
Okay.
Thank you. If we really do hit a snag, I may ask that we break for lunch. Good morning, ma'am. How are you?
Good.
Good. I'm going to try and do it sort of the way that you went through it in your direct examination. Obviously, what you've told the jury, you do in a lot of cases where these issues may be in contest, correct?
Yes.
Where you're trying to determine, for example, that the cartridge found came from the gun. Right?
Correct.
You know that's not an issue here, right?
Yes.
And you do a lot of analysis to make sure that the bullet came from the gun in many cases, correct?
Yes.
And you know that's not an issue here.
Yes.
Okay. And concerning the firearm itself, of course, you need to be able to testify to a jury, this gun can work and can fire a bullet, correct?
Yes.
You know that's not an issue here.
Yes.
Judge, I'm sorry, I'm going to interpose an objection as to the legal conclusions by the defense attorney as to what or is not an issue in the case.
Okay, thank you. That will be sustained if you can rephrase your question.
Sure, certainly. From a forensic perspective and from the workload that you needed to do, were you given any indication that there was an issue in whether or not this bullet came from this gun?
We're never given an indication whether there's an issue present or not.
Okay. So you would take it on and look at it and see what needs to be done to prove up matters, even if they may not be in contest.
Correct.
Okay. So in this case, you were able to document gunworks, fired cartridge, fired bullet. Correct?
Yes.
Now let's talk about the gun itself. And if I might approach the witness, Your Honor, with the firearm. That's in front of her. If you would, I'm actually going to have you testify from where you are right now, but I would ask you to take out the firearm and just hold it, obviously, as you know how to, pointing it nowhere near any of us, including the jury. And I think that you said you have a good history and experience in firearms generally, correct?
Yes.
And you know what different types of firearms are used for?
Yes.
Okay. And that is what's called a double action, correct?
Yes.
Meaning by that you don't need to you need to have a certain amount of weight and intent to fire that firearm, correct?
What double action refers to is pulling the trigger, cocking, and releasing the firing mechanism.
And the very characteristic of being a double action is a safety feature, correct?
Yes.
Meaning that there are some firearms, or they're not, some semi-automatics, where if you actually rack it, if you have a cartridge in the chamber, it is ready to fire with a very light, almost featherweight pull, correct?
Those are referred to as single action firearms.
In a single action, if I were to be carrying around a single action without an external safety on it in my hip, it would be quite dangerous, wouldn't it?
If the firearm was cocked.
Of course. If
Yes.
I've racked one in and it's only on single action now because it has a featherweight pull, right?
Yes. It has a lighter trigger pull than a double action.
So the double action characteristic itself makes it a safer weapon to carry in a ready to fire position, correct?
With it functioning properly, yes.
Of course, presuming for the next few questions that we're talking about firearms that act the way they're supposed to act, okay?
Yes.
And you know that some weapons are used particularly for self-defense, correct?
Yes.
To protect oneself, correct?
Yes.
And within that context, a firearm that's to be used for self-defense has to be ready to use, correct?
Potentially.
you would not want a firearm that has an external safety that would, on a double action, that has an external safety that would require an additional step to make it ready to fire, would you, for a self-defense application?
I can't really say as to whether that would be more of a personal preference, I do believe.
Okay, let me ask it this way. If, in fact, one was carrying a firearm and it had an external safety, what would have to happen before that firearm was ready to fire?
The safety would have to be disengaged.
It would have to take that extra step to disengage the safety, correct?
Correct.
This gun does not have an external safety, correct?
No.
What exactly then makes this firearm a safe firearm to carry in a loaded way?
It's a combination of the fact that it's double action, that it's never cocked until you pull the trigger, as well as the hammer block, as I had stated previously, that prevents the hammer from coming in contact with the firing pin unless the trigger is pulled. With both of these safeties functioning properly, the gun cannot be fired unless the trigger is pulled.
So the hammer lock itself is actually an additional safety device, and that basically is a little metal plate that goes between the hammer and the back of the cartridge, correct?
Back of the firing pin.
Firing pin. So, and if that metal plate is there, it is safe. It cannot fire, correct?
Correct.
And only when you start pulling on the trigger, which has a 4.5 to 4 3/4 pull, does that plate drop in order to make the gun active,
Yes.
correct? And the very nature of having a 4.5 to 4 3/4 pound pull is itself a safety feature, correct?
The trigger pull itself is not a safety feature.
I'm sorry, having to pull the trigger with that amount of force is a safety feature, correct?
No.
Well, then why don't you compare for the jury the pull necessary to pull a double action firearm as compared to a single action firearm?
Are you talking the trigger travel distance?
I'm sorry. I use, yes, the trigger travel distance.
Yes, in terms of the length that the trigger needs to travel backwards to release the firing mechanism on a double action, and especially this one, is much longer than, say, a single action firearm.
And would you agree that that also is a safety mechanism to be certain that that the firearm is not going to fire without someone deciding to make the full pull on it?
That would make it a lot less likely to accidentally pull. It would be a deliberate pull of the trigger.
And are you saying this is not a safety feature, or did I just misstate the word when I was using pull pressure?
It's a design feature of the gun.
To make it safer?
Potentially, yes.
So, is that an appropriate gun then to be carried, or is it a safe gun to be carried in a loaded and ready to fire position?
This gun, again, in working order, is safe in terms of it will not fire unless the trigger is pulled.
There are other guns, of course, as we talked about a moment ago, that have external safeties, which means you need to undo a safety before shooting the gun, correct?
Correct.
Are those more found in single action guns where the trigger distance is much less?
That will be found in single action guns and double action guns and firearms that do both single and double action. It's a mix all across the board.
You do agree that this gun without an external safety is a safe gun to carry loaded?
Safe is a personal preference in terms of loaded. I would say that, again, this gun cannot fire unless the trigger is pulled.
And I don't want to get into qualitative terms of safe or not, but is there anything with this particular gun that you found that suggested it was unsafe to carry in a loaded way, ready to fire?
No.
There are probably at least 2 guns in this room. Would you agree that all law enforcement carry their guns ready to fire?
I do believe they do.
Okay. They're not much use if they're not ready to fire, are they?
No.
You had mentioned even as to this weapon, you've had a chance to visit the the factory where they're made a couple times?
Yes.
It's right here in Brevard County, correct?
Yes.
And you've been there a couple times to see, do any concerns with the manufacture of that weapon?
No.
From your experience as to how it was utilized in this event, did it perform properly? Did it shoot its projectile the way it was supposed to?
The gun functioned, yes.
Okay. So it worked, correct?
Yes.
And it worked the way it was supposed to?
Yes.
There was no suggestion that the pull distance was malfunctioning in any form, correct?
No, there was no indication that anything on this pistol was malfunctioning.
And you had mentioned now talking anything that we haven't talked about with the gun and its safety features.
No.
You had stated in response to how you can load that is that you have to, and I call rack it. Is that the right term? When you pull back the slide?
Yes, that's
Can
a
we
term
use-
that's used.
Okay, can we use that so that both you and the jury knows that racking it means pulling the slide back to actually put a cartridge or a bullet in the chamber being ready to fire?
Sure.
Okay. And you stated that a person, Mr. Zimmerman, since we know it to be his gun, right?
Yes.
Okay. Would have then racked it to make sure it was in fact ready to fire and then put another bullet in the magazine and reloaded it. Correct?
Yes.
Is that a usual occurrence in your experience dealing with firearms?
I typically
Or
see
did you
a
just
wide
not see it?
variety of,
Okay.
of
You
what
did
I
not
receive.
sorry, I interrupted you.
That's
You did
fine.
not consider that to be an unusual occurrence, certainly,
No.
did you? Okay. Matter of fact, the two law enforcement officers here, and probably every other law enforcement officer gun that you had a chance to see, that is normal, that it is one racked in the chamber and a full magazine, correct?
Yes.
Military do that, correct?
I'm unsure.
It, in fact, is the way that you make that gun as capable as it can be for whatever the need may be, correct?
To have it fully loaded?
Yes.
Yes.
And then we've talked about the shirts themselves, and I'm not going to go into having you look at them just yet. You might be able to avoid that. But you had said that the two shirts sort of lined up, correct?
Yes.
And by that you mean, obviously, there was a hole through one and a hole through the other. And when you took the shirts and lined them up, they matched, correct?
Correct.
You're not suggesting that because of that the shirts are in any particular configuration on the body, are you?
No.
Okay. They were where they were, but certainly the bullet went through both shirts where they were lined up with the bullet hole.
Yes.
Okay. And let's talk about the action when you say contact. Mr. Guy suggested pressed into, and I think you corrected him to say it was touching, correct?
Yes.
There was no evidence, for example, that would show up that you would take the gun nozzle and push it into the shirt somewhere where the shirt would fold around it, was there?
No, it was consistent with the muzzle of the firearm touching.
It was consistent
The
with
sweatshirt.
this, correct?
Yes.
Shirt, firearm, wasn't
Yes.
consistent with. Right, because the fire then would have wrapped back around it somewhat?
Potentially if it was wrapped around it.
Correct.
Yes.
And matter of fact, any configuration that suggests something other than flat would have shown some different stippling potential or burning from the way the flame would then have bounced around, correct?
In terms of farther away or closer?
No, if it was in contact,
Okay.
pushed in to the extent that it folded the fabric around it, that would have shown a different type of burn pattern potentially, correct?
Potentially if the sweatshirt had gone over the top of the ejection port area there would possibly be marks from that, but otherwise, whether it was lightly touching or pressed in, it would be the same type of physical effects that I had seen.
And when you say touching, is that a term of art actually was touching, or in this case, when you saw a couple of, I thought you said, you saw a couple of little burn spots of maybe powder that had escaped, was that consistent with being an eighth of an inch away, or a quarter of an inch away, or what?
No, it's consistent with the muzzle touching the garment itself.
Okay. And that you can tell because there was some tearing itself. That is the way that a projectile at that range rips through the fabric?
Yes.
Did you do any examination to identify the distance that the bullet traveled before it hit Mr. Martin's chest?
No, I only examined the clothing for distance determination.
I might have a moment, Your Honor. Do you involve yourself then, ever during your experience with FDLE, to actually look at the injury or flesh wound occurring by a bullet entering it?
No, I do examination of clothing.
Okay, so whenever the bullet, before it gets to the body, is where you stop
Correct.
in your analysis?
Yes.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Just briefly, thank you. Ms. Siewert, you were asked questions about whether or not that firearm could be used for self-defense. Could it also be used to commit a murder?
The firearm can be used for any purposes.
Your Honor, I might, because that is speculation and would affect the ultimate fact before the jury, ultimate question before the jury.
Sustained.
You were asked about the trigger pull. Can you give the members of the jury an idea of whether or not 4 pounds or a little bit more than 4 pounds is a relatively light or relatively heavy trigger pull?
4.5 pounds is within the normal range of trigger pulls that I see in my casework.
So it's not a heavy trigger pull?
No, it is not.
And you were asked questions about the firearm being fully loaded. Can you explain to the members of the jury that if the magazine's full and there's a live round in the chamber, on that particular firearm, what must a person do to expel a bullet?
Pull the trigger to fire the gun at that point in time.
That's it. There's nothing they have to turn off or adjust. You just pull the trigger.
Correct.
All right, but they do make firearms with what you refer to as an external safety, right?
Yes.
Can you explain to the jury just briefly how those work and the purpose of those?
Sure. An external safety is typically a button, a knob, something that you physically have to engage to prevent the firearm from firing.
And where is that? Where are those typically located on the firearm?
More times than not, you will find them right back here on either the left or the right side. But those are typically referred to as thumb safeties, as all you need is your thumb to disengage it or engage it.
That firearm does not have any type of external safety?
No.
All right. With the firearm in the condition that it is right now, unloaded, are you able to demonstrate for the jury how to pull the trigger and to make that sound?
Yes.
Your Honor, may she do that? May she demonstrate pointing it into the wall?
Yes. I'll use my left just so you can see. One more.
And that's all someone would need to do to fire a shot if it was fully loaded?
Yes.
Thank you, ma'am. Judge, that's all I have.
Thank you. Any redirect?
Very brief on that one point. This gun safety mechanism requires that same amount of pull for every time you want to shoot the gun, correct?
Yes.
You agree that there are other semi-automatic weapons, a number of them, where while the first shot may be a double action pull, the ones after that are single action, correct?
Yes, there are some firearms designed that way.
And Sig Sauers are all that way, Colts are all that way, right?
Some of them, yes.
Okay. And what that means is while you can rack it and shoot with a 4.5, 5 pound pull or distance, every other one is featherweight, right?
A single pound trigger pull is going to be lighter than a double action trigger pull, but when you have a firearm that's both single action, double action, pulling back on the slide and releasing while you chamber a cartridge will leave the pistol in single action. So firing it that way will be the single action trigger pull, which will be lighter than a double. However, a lot of these firearms also have what's called a decock safety, which is essentially another thumb safety where you depress it and it will allow the hammer to fall without causing the gun to fire. And then by pulling the trigger at that stage, it's going to be a double action trigger pull, while all remaining ones, if you do not decock, are going to be at the single action trigger pull, which is lighter.
So with this gun, if I wanted to shoot it one time, 4.5 inch pull, correct?
4.5 to 4 3/4 pounds, yes.
Sorry, 4 3/4 pound pull, correct? And then
Yes.
the second shot, again, 4 3/4 pound pull, correct?
Yes.
If I had my Sig Sauer 9mm with me and I did the same thing, first one, let's say 4.5 pound, correct?
I'm sorry, I'm just going to
and-
take this to the relevance of a different firearm.
Well,
Sustain.
any other firearm that goes from double to single, I think you probably could.
The objection was sustained.
But now I'm moving on to the next question.
But we're still talking on firearms other than this firearm.
Well, she has now identified, if I might be heard,
I know, but the objection is relevance. That objection is sustained.
then this firearm's additional safety measures is that each pull has to be the full pull, correct? As opposed to shifting to single action after the first pull.
That's a design feature of a pistol that's either only single action or only double action, where
Which-
it has the same trigger pull for each shot.
Which means that even the second, third, and fourth shot require a full 4.5 to 4 3/4 pound pull.
Yes, each pull of the trigger requires the same amount of force.
And that is different than it would be if it was a single action, correct?
Yes.
Thank you. Nothing further on.
Any redirect?
No, thank you.
May Ms. Siewert be excused?
She may.
Thank you very much. You are excused. Deputy, so please put the lock back on the firearm and put it in the box. Ladies and gentlemen, we're going to go ahead and break for lunch. During lunch, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Okay, there's something different going for lunch today, so I'm going to give you some extra time. If we will be back at 1:45. Please put your notepads face down on the chairs and enjoy your lunch. Did you put the lock? Is there anything, please be seated. Is there anything else that we need to take up before we recess for lunch?
No, Your Honor. No, Your Honor.
Okay, court will be in recess till 1:45.
And we object to that schedule. We're
Okay.
available all
What-
day tomorrow. We would ask.
What is the scheduling issue with Mr. Blackwell?
We asked that Mr. Crump be available tomorrow because we knew that was a holiday, and we were told that neither he nor Mr. Blackwell, as I understand it, were available, and that they suggested that we begin at 6 p.m. on Sunday. That's not realistic or practical for us. While the deposition is relatively limited in scope, that doesn't necessarily mean it will be short because of potential objections, and there are indeed some new areas that may have come up as a result of Ms. Gentile's testimony.
What is it that you're asking for?
Well, the first thing I'm asking for is this. I would ask that the court recess on Friday so that we have that opportunity to take Mr. Crump's deposition. We also want to take the deposition of Steve Brenton with FDLE. We were provided with his report on June 4th, the one that's been the subject of many things, including the sanctions motion. We've had no opportunity since we started the Fry and other hearings and then jury selection, no opportunity to take his deposition and any follow-up there. So we need to do that. We need to take Mr. Crump's deposition. There are some other witnesses. If we had the opportunity, we would like to take their deposition.
Let me interrupt you for just a moment. What is the availability of Mr. Benton?
I believe he can be available almost any time, but I haven't checked with him recently. This is the first I've heard of this in terms of the need to do him right away. I know that in the past they had talked about wanting to take his deposition, but...
Because I know the state has said that they are planning on resting today, and this court intends to begin the defense on Friday, and that's what I had informed you yesterday. I have a jury that is sequestered. They're away from their home, from their families, and to have to take off for 4th of July, which everybody has requested and the court is obliging because it is a national holiday, to then also take off Friday and have them there Thursday, Friday, Saturday, and Sunday sequestered somewhere where they not occupied is just not reasonable. Mr. Crump has been available since we began this trial on June 10th until that was the jury selection process, until he was sequestered as a potential witness from the courtroom, but he was here for every day. I don't know what Mr. Blackwell's schedule is, but it has now been almost a month since we started jury selection or even our Fry hearing. I believe he was here on June 6th in the courtroom during those Fry hearings. The court recessed early on different days, so I don't know what Mr. Blackwell's schedule was, but to have this court continue keeping a jury sequestered without having court time because you didn't coordinate that deposition within a month's period of time, I find that very hard to do.
From a scheduling standpoint, we didn't know until late in the day on June 3rd that we would be allowed to take his deposition.
Well, that's a month ago. That's 30 days ago.
Your Honor, we've been somewhat tied up for the last month,
Well,
beginning with June 6th, 7th, and 8th in the Fry hearing and the sanctions hearing that we haven't even finished yet. On June 9th, we met with our jury consultant and Mr. Zimmerman to prepare for jury selection, which started June 10th.
And it's my understanding that you had taken there were some depositions that were 5:30 last night. It's my understanding there's more depositions scheduled for 5:30 tonight. There's not been a request from this court to conclude court a little earlier on any day for the purposes of taking any other depositions. So I want to start, if the state rests today, the defense has Thursday, which is a holiday, that you could utilize for whatever purposes you need to get ready, but it was always this court's intention that as soon as the state rests, that the defense begins their case. That's how it happens in every case I've ever had, and was my intention to continue to do that. And Friday would be the first business day after the holiday, so.
What we're asking for is a little more time, given the way this case has proceeded. As the court's aware, we were still litigating the admissibility of evidence after the jury selection began. We certainly couldn't have taken Mr. Crump's deposition during the trial day. The court doesn't expect either Mr. O'Mara or myself to leave the courtroom, I wouldn't think, to take his deposition.
You've left for other reasons, but I don't want to go there. I don't want to go there. And I don't want to get into a discussion back and forth about what times may have been available, but it's never been requested for this court to recess even a half hour earlier. I know during the Fry hearings, we recessed on a Saturday because your witness wasn't available, and the court had to continually ask when your witness would be available to finish it. I had to be the one who moved that forward. Neither side moved that forward because I wanted to get that matter finished because you wanted to know an answer about it before opening statements, and I accomplished that. And if there had been a request to recess even an hour earlier, I would have done that. But now I have a jury sequestered that are going to be off on Thursday, and you don't want court on Friday, that's Saturday, Sunday. I'm not doing that.
We asked the court
Okay, end of
to continue
discussion.
the case so that we could take Mr. Crump's deposition, so we could finish the Fry hearing just for a few days before we started jury selection. We have been, I think, asking at every opportunity for some additional time to finish these critically important aspects of the case. Likewise, I'm simply asking for some time now. I don't know if Mr. Crump's in the building today. The court could entertain ordering him to appear tomorrow.
We are taking up now time that I want to conclude this case. The state has indicated that that they would be finished with their case today. I would like to bring the jury in. You can continue to discuss this with me after the state has rested. Are we ready to bring the jury in?
Yes, Your Honor, and just for point of clarification, I know we've had some delays throughout, and I just want to, I'm still pushing for the end of the day.
I am too. That's why I would like to get started.
We may go into Friday morning, but it would be Friday morning at the latest.
Let's go. I'm prepared to go as long today as we need to get the state to rest their case so we can move on with the case.
No, just so that the court is
No,
aware.
please have a seat. We will discuss this after we have finished for the day. I would like to bring the jury in.
Yes,
You'll
Your Honor.
have an opportunity. Thank you very much. Let's bring the jury in.
Jury is present, Your Honor.
Please be seated. Welcome back, ladies and gentlemen. I hope you enjoyed your lunch. While you're getting settled in, I'm going to ask my questions. If your answer is yes to any of the questions, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. State, call your next witness.
I would call Anthony Gorgon.
Raise your right hand. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor. You state your name for the record and spell your last name, please.
My name is Anthony Gorgon. That's spelled Gorgone.
What is your occupation, sir?
I'm a crime lab analyst at the Florida Department of Law Enforcement in the biology or DNA section.
How long have you been working for, I'm going to refer to it as FDLE, but the Florida Department of Law Enforcement?
I've been with FDLE for a little over 7 years. I started in March of 2006.
Could you briefly tell us about your education and training regarding your occupation, sir?
Yes, I received a Bachelor's of Science in Molecular and Microbiology. That was from the University of Central Florida, graduated in 2004. I was hired by the Florida Department of Law Enforcement as a forensic technologist. In that position, I screened items of evidence for the possible presence of bodily fluids that may contain DNA. I was promoted to crime lab analyst in July of 2007. I underwent a 13-month training program for that position. The first half of that training program was background readings, written and oral exams. The second part of that training was supervised casework. That would be actual casework under the supervision of a trained analyst. And that training, that 13 months culminated in a mock trial.
And have you kept up with the latest information regarding DNA, sir?
Yes, I regularly read articles published in scientific journals, as well as I'm required to attend at least 8 hours annually of outside training. That's usually conferences and workshops and classes dealing with the field.
Have you previously testified in court as an expert in DNA, and does that also include the significance of your finding regarding population stats?
Yes, I've testified 28 times in different counties in Central Florida prior to today, and almost every time that deals with statistics.
All right, at this time I tender the witness as an expert in DNA and statistics regarding DNA matters.
He may so testify.
No voir dire, Your Honor. Thank you.
Everybody by now has heard of DNA, but can you briefly tell the jury what DNA is?
Yes, DNA, it stands for deoxyribonucleic acid. It's the genetic material that's passed down from generation to generation. Every person gets half of their DNA from their mother and half of their DNA from their father, and it's the genetic blueprint that makes each person unique. It codes for everything about you, everything from the pigment making up your eye color to the enzymes in your stomach breaking down your lunch right now.
And how is DNA used in a forensic setting?
Forensically, your DNA is found, a copy of your DNA is found in almost every cell in your body. Therefore, it can be left behind in bodily fluids that you leave behind, such as blood, semen, saliva, also sometimes hair and skin cells as well. And forensically, I could use those bodily fluids to develop what I call a DNA profile, which would be to analyze the DNA at certain locations on the DNA molecule, develop a DNA profile that can be used for identification purposes and comparison.
Are there other uses for this technology other than in a forensic or criminal setting?
Yes, several fields use the DNA, the same DNA testing that I use. It's used in medical and genetic research. It's used in organ and blood transplant donor-recipient evaluations. It's used to test any abnormalities in the fetus during pregnancy when they do the amniocentesis. It's used in the identification of mass disaster victims, as well as the Innocence Project and paternity testing as well.
Is the DNA profiling and comparison method using STR that you're going to talk about, that your lab uses, being accepted in the scientific community as being reliable?
Yes, it is.
And is your lab, FDLE, been accredited and been through all the hoops in terms of their accreditations or being findings that they're proficient, et cetera?
Yes, we are an accredited laboratory.
Okay. I want to talk about the laboratory procedures for a few minutes if we could. Do you all have an established protocol or methods in which an item comes into your lab where you make sure that there's no contamination and that kind of stuff?
Yes, we have a quality assurance program that says that we have documentation of all the quality procedures. We have standard operating procedures that give specific instructions for every test that I do so that every person working in the lab is on the same page and one person isn't doing one thing their way and another person doing another thing their way. So we have written protocols, and all of our quality assurance program is in writing.
And are there any controls within the testing themselves in terms of positive and negative controls to verify that what you're doing is accurate in terms of not getting any misidentification or contamination?
Yes, there are positive and negative controls at just about every step of the way. Before I even do the DNA testing, if I'm screening for the possible presence of blood, I need to test a positive control and a negative control of blood to make sure the chemicals I'm using are working. During the DNA testing, I have positive controls where I have a DNA profile. I need to get that expected DNA profile at the end of the process to know that not only that the chemicals and the instruments are working, but that my techniques are good as well. There are also negative controls at a few steps during the way, and those would be blank samples, and those samples need to remain blank the entire process.
In the lab, while you're analyzing evidence that's submitted in the lab, do you wear any kind of clothing attire to make sure that you don't cross-contaminate anything?
Yes, whenever I have an item of evidence open and I'm physically examining that item, I'm required to wear a lab coat, a mask, gloves, and sometimes a hairnet, depending on the item. When I'm actually working with the tubes and actually doing the DNA testing process, I'm also required to wear a lab coat and mask and work in chemical hoods with it's a sash that covers in front of my face.
And are all these procedures for quality control methods that you all utilize at FDLE, are they used by other labs in terms of being accredited?
Yes, any lab with a quality assurance program in place is going to have very similar protocols as far as quality control.
Tell us, if you could, briefly about proficiency testing in terms of testing yourself and also your lab to make sure that what you all are doing is working properly.
A proficiency test is a test given to me by an outside company. It's mailed in, and it's a set of samples that I have to work as if it were a regular case. And I perform that testing and send the results back to that company, and then they send a notice back saying, yes, you got the correct results, or no, you did not get the correct results. I'm required to take a proficiency test every 6 months. So I take one about May and about November of every year. And I've done that every year that I've been doing independent casework since August of 2008.
And is the entire lab also subject to proficiency testing, the DNA lab, or the lab, but the DNA department of the lab also?
Yes, every crime lab analyst and even the forensic technologists have to go through some kind of proficiency test twice a year.
Okay. Let's briefly talk about the exhibits themselves that would be tendered into your lab for analysis. In terms of making sure that you have the right exhibit in front of you when you're analyzing it, what kind of quality controls do you all have? Is there some numbering system or some cataloging of the items when they come in?
When an item is submitted for testing, we get items from outside agencies, such as local law enforcement agencies in the Central Florida area. They submit the items to our evidence intake section. The evidence intake section makes sure that that item is in a sealed condition, and they issue it an exhibit number for the Florida Department of Law Enforcement, exhibit number, and put a barcode label and a case number on it. And then that item gets brought up to me once I'm assigned the case, and then I also examine that item to make sure it's in a sealed condition, and we have that barcode label, the Florida Department of Law Enforcement case number and exhibit number.
Do you also document when you analyze something in terms of putting your initials or some kind of markings to be able to say, like you will have to adhere in court and say, yeah, I know I examined this item?
Yes, I mark the package that I Before I open the package, I mark that package with my initials, the Florida Department of Law Enforcement case number, exhibit, and the date that I'm examining that item. And then the actual item itself, unless there's a reason why I can't mark that item, I will mark that item as well with that same information.
Okay. Let's now move on to the DNA testing you did in this specific case. I believe you use STR DNA testing, is that correct?
Yes.
Okay. Tell us, when we talk about STR DNA testing, what we mean by that, or what you mean by that, I should say.
STR testing is short tandem repeat testing, and I'm analyzing short segments on the DNA molecule that are highly repetitive segments. They don't actually code for any physical characteristic or any kind of molecule inside your body that's doing a job. They are just repetitive, non-coding regions of DNA, and I can take advantage of that fact, the fact that those repetitive sequences vary from individual to individual. So I can use these short segments of DNA to develop a profile for that individual.
And if you could, I'd like you to break down in terms of the STR process, are there, I think, 3 or 4 steps that you have to go through in order to first determine whether you have enough DNA and to actually develop it?
Yes. Well, the first step would obviously be analyzing the item of evidence for the possible bodily fluids, the blood, semen, saliva, as well as hair and skin cells. Once I have that stain that I want to perform DNA testing on, I take a small portion of that stain or swab and I put it in a tube and use heat and chemicals to perform what I call an extraction. That breaks open the cells in that stain, exposes the DNA molecule, and then hopefully I can isolate that molecule and wash away all of the debris and all the other chemicals in that sample. The next step would be called quantification, where I take that sample and see about how concentrated, about how much DNA was I able to recover from that stain. And I use that information for the next step, which is amplification. I'm basically making Xerox copies almost of the DNA molecule, but only at these 13 or 15 different regions that I'm interested in testing to develop the DNA profile. I make millions and millions of copies of the molecule at these specific regions so that I can analyze these regions. The last step is called electrophoresis, where I actually separate out the DNA molecules that I was able to amplify by size. I get a data readout, I interpret that, and create the DNA profile, which is essentially a set of numbers, and I can use those numbers for comparison.
And when you're going, I'm sorry, do you need a minute? When you're going through the extraction process on a stain or what you believe is a stain, might you be given the actual exhibit itself, like if I gave you this pen, or may there be a swab from that pen that you're first looking at?
It varies. Sometimes I get an actual item, like a pen, and say, who was possibly handling this pen? And then I have to take a swab and swab that pen for any skin cells that might be left behind. Sometimes I get a swab that was collected from an item, and it was collected by the agency that submitted that, say Sanford Police Department or Orlando Police Department. They swabbed the pen themselves, put that swab in a box, and sent that box in to be tested. So then I just have the swab to work with. I take a cutting of that swab with a scalpel, put that in a tube, and perform my testing.
In terms of that second step, you talked about the quantification. Do you need a certain amount of DNA in order to even get a result? And what's the minimum you need?
Well, there's really no minimum. That step tells me about how much DNA I have in the sample, and I use that information for the amplification step. The amplification step, it's kind of like a recipe. Like you have a recipe that calls for 1 cup of sugar. Ideally, this recipe calls for about 1 nanogram or 1.5 nanograms of DNA. So I'd like to have that 1.5 or 1 nanogram of DNA to put in that tube in order for the reaction to work right, for me to get a DNA profile that I could use for some kind of comparison. But if I have less than that, I'm still going to go through with the rest of the steps to see, because sometimes I can get less information than the full, complete DNA profile, but it's still enough for me to make comparisons. And then there's plenty of times where I don't have enough DNA, and I don't get any results, or I get very little results. But I still go through with the step. There really is no minimum, or I look and say, okay, I don't have enough DNA there, I need to stop. I'm going to go through with it regardless of how much DNA I have in that sample.
And educate us, if you could, nanogram. What is that? How much is that?
A nanogram, it's a very small amount. If you take an index card and cut that index card up into 1 million pieces, that would be about a nanogram, I believe. It's not a quantity that you can touch or feel.
Now, you mentioned also that in the process you're looking for markers or allele or loci, and you mentioned that the test you do is either going to give you 13 or 15 possible. Is that correct?
Yes.
Okay. In terms of STR, you have 13 or 15. Did I get that right? In terms of markers?
Yes.
Okay. Do you always get 13 or 15?
No, like I said, sometimes based on the sample, the amount of DNA I have, or the condition of the DNA, sometimes I get less than the full amount of locations that I'm testing. That would be called a partial DNA profile.
And if you get a partial DNA profile, are you still in certain cases able to make or give an opinion as to the results there?
Yes, sometimes depending on the amount of information I have. There are times where I have so little information I can't make any comparisons to any individuals. But plenty of times with partial DNA profiles, I can make some kind of comparison.
So you get an item such as a pen, or you get a swab from the pen, you do all this process, and then do you end up comparing it to a known sample that you know somebody can testify has been taken from a certain individual?
Yes. Ideally, in every case, I'm going to have question samples and known samples. A question sample would be, say, a swab from a pen. I'm trying to determine who was possibly holding this pen. A known DNA sample would be a sample collected directly from an individual. It's usually either a swab collected from the inside of their mouth or some blood that's dried down onto a card to preserve it for future testing. I test those samples, those known samples, the same way as the question samples. However, they are processed at different times, and I develop a DNA profile for that individual, and I use that DNA profile from that individual for comparison to the question samples throughout the case.
And when you're comparing that in terms of an item or DNA or swab from a pen versus a known standard of an individual, if you go through the markers and one doesn't match, are you able to eliminate a person?
That depends on what my analysis of that sample is. If I test, say, a pen swab, and I determine that the DNA profile from that pen is from a single individual, then their entire DNA profile needs to match that entire DNA profile from the pen. So if there's one difference, then that person would be eliminated or excluded from being a possible source of the DNA on that pen. However, there are other times where I have mixtures of DNA, which I'm sure I'll be going into soon, where it's not a clear-cut, everything needs to match. It's a different comparison.
That was going to be my next question. Tell us briefly about mixtures. And are we talking about major and minor, and then possibly at certain points more than one person in terms of 2, 3? Tell us a little bit about mixtures and how it factors in a forensic setting versus a sterile environment.
Well, when I have a mixture of DNA, I have DNA from multiple people on a sample. So say I test that pen swab and I have an indication of 2 people or 3 people on the results from that swab. That would tell me that I have a mixture. What I need to do from there is try to separate out that mixture into the individual profiles that make up that mixture. And the way I can do that is sometimes one person contributes significantly more DNA to the sample than the other person or the rest of the people in that sample. And that DNA profile for that individual will stand out. And I call that a major DNA profile, if I'm able to resolve out a major DNA profile for that individual. There are times when I can determine a DNA profile for the lesser contributor, usually if the mixture is only of 2 people. But most of the time, I can't tell if a mixture is from 2 people, 3 people, 4 people. There's a lot of overlapping information in that data, and I usually can't determine any DNA profiles for the lesser contributors. But a lot of times I could pick out a major profile, at least from a mixture. In times where I cannot resolve that mixture into individual profiles, then I can still make a comparison to the known standards. I need to compare those known standards to the mixture as a whole to see if their DNA profile is represented in that mixture. And if it is, then they would be included as a possible contributor to that mixture. If they are not, if I feel there's enough absence of their DNA profile that they could no way have contributed to that mixture, then they would be excluded from that mixture. And then there are times where it's somewhere in between. I can't include them in the mixture and I can't exclude them based on what I'm seeing, so I'm not able to make any kind of determination for that person to that mixture.
Sometimes when you examine an exhibit, do you do a preliminary test to determine whether it's even blood?
Yes.
Tell us about that briefly, that testing, what that involves.
Depending on the case scenario, when I open an item and look at it, I could be looking for any of those bodily fluids that I discussed earlier. So if I'm looking for blood and I see a red-brown staining on the article of clothing or the swab or whatever it is, I'll take a rubbing of that stain, try to rub off a little of that material onto a small piece of filter paper, and I apply a series of 3 chemicals. And if I get a pink color change at the end of that series, that would give me an indication that that would be positive for the possible presence of blood.
Before we get into the heart of what you're here, I want to talk briefly about the significance of your findings. Assuming you get DNA results, I want to talk briefly about the population matters. And let me just ask you some questions regarding that if I could. When you examine the results, let's say you get an STR test, do you then determine the probability of a match in terms of what are the probabilities, is it? Tell us a little bit about that.
Yes, when I have a match, when I have a single source profile or a mixture and someone matches that DNA profile or they're included in that mixture, I need to put a relevance to that match. If I got a result at one location, at one of the 13 locations that I test, and it matches an individual, what is the relevance of that one location matching an individual? There could be, maybe 4 other people in this room that match that location. So I need to put a statistical relevance to that match. So when I have 13 locations, I perform what's called a random match probability. Or when I have any amount of locations that I get, I perform a random match probability, and it's the possibility that you would pull a random person off the street and test their sample, and that they would match that unknown DNA profile that I got, whether it's at 1 location, 2 locations, or all 13 or 15 locations.
And is there a database that you have as a baseline in order to compare it to determine, in terms of the percentage of the population, or how likely is that to occur?
Yes, the different results that I could get at these locations, they aren't evenly distributed in the population. Some results are more common than others. So I use population databases that were put together for the purpose of estimating about how rare or frequent these different results are in certain ethnic groups.
And are you familiar with the database that you all use?
Yes.
Okay. And has that been accepted in the scientific community being reliable in terms of, do you use the PopStats, I believe, or FBI, or what do you use?
I used 2 different databases during the course of working this case. For years, we used the FBI's population database. That is generally used within the scientific community. I did test a couple samples later on in this case where we had switched to a different database. We call that the Butler database because it was created by Dr. John Butler. And that's the one we currently use in our casework.
And has that been accepted in the scientific community as being reliable?
Yes.
Okay. And do you use the product rule in some way too in factoring that all in?
Yes.
Tell us briefly about the product rule.
The product rule, it's a simple statistical concept that says if you have a frequency for one event and a frequency for another independent event, and you want to see what's the frequency that both these events could occur at the same time, you can multiply the frequencies together. So for example, if you have a coin and you flip that coin, you have a 50% chance of heads, 50% chance of tails. Well, if you want to see what's the probability that I'm going to have 2 coins and I'm going to flip both, and they'll both land on heads, you would multiply that 50% for one coin, 50% for the second coin, and you would get 25% that they would both land on heads. This applies to the random match probability, the statistics I use, because these 13 or 15 locations that I test are all inherited independently. So once I determine the frequency that you would find the results at one of these locations in the population, I can then multiply it with the other 12 or the other 14 locations using this product rule to get a frequency that you would find that entire DNA profile.
In terms of some of the results that you're going to talk to this jury about, why are some of the results in terms of the numbers more than the actual population of the Earth, which I believe is now 6.5 or maybe 7 billion? Why is it higher?
I think it's almost 7 billion now, the population of the Earth. It really doesn't have anything to do with the population of the Earth. It's more about the frequency at which I see these results. It's similar to, if you think about it, sometimes you see it posted somewhere that the frequency or the probability of winning the lottery is 1 in a million. Well, that has nothing to do with how many people play the lottery or how many people live in the area. It just has to do with what is the probability that I'm going to match all 6 or 7 of these numbers and get them all right, based on what's the chance that a 1 is going to draw out versus a 44. It's the same concept with the DNA profiles. It doesn't matter how many people are on the Earth or in the Central Florida area or anything. It's just the probability based on how rare or frequent these results show up in these ethnic groups. It's the probability that this entire profile will be seen if you test a random individual.
And I believe the 3 ethnic groups or race groups you have is African American, Caucasian, and then you have what else? Hispanics, I guess, Southeast Hispanics?
For a long time, when we used the FBI database, we calculated the frequency of profiles for Caucasian, African American, and Southeastern Hispanics populations. Those are the 3 most prevalent in the Central Florida area. When we switched to the new database, when we're using our new system where we're testing 15 locations instead of 13, we do statistics for Caucasian, African American, and Hispanic, as opposed to Southeastern Hispanic.
All right, well, then let's talk about specifically what you did in this case, now that we've got the basic stuff out of the way. I believe you did 3 reports in this case dated March 26, May the 9th, and July the 26th of 2012. And it's under FDLE number 2012, and the last 4 digits are 1890. Your reports and your entire file has been copied and previously provided to defense counsel, so with the court's permission, may Mr. Gorgon refer to his report or notes at any time.
Any objections?
No.
Okay, thank you. Yes, you may do so.
It might be easy, Mr. Gorgon, if we start off with the standards. I believe you received 2 standards or 2 samples that you did some DNA analysis, and specifically a swab that was represented as coming from the defendant, George Zimmerman, and then also a DNA card or blood card taken by the medical examiner from the victim in this case, Trayvon Martin. Do you recall that, sir?
Yes, that's correct.
Okay, all right. And what I want to do is first, with the court's permission, may I approach the witness, Your Honor?
You may.
Sir, I'm showing you State Exhibit 186. Now I ask you if you recognize State Exhibit 186, sir.
I do.
How do you recognize State Exhibit 186?
The outer package has our FDLE barcode label with case number. It also has my initials and the date that I opened this package. The internal package also has my initials and the date that I opened and took a cutting from this sample.
Okay. And what do you understand State Exhibit 186 to be, sir?
This is a blood stain card from Trayvon Martin.
Okay. Let me show you State Exhibit 188, and I ask you if you recognize that, sir.
I do. The outer package has our FDLE barcode label, my initials, the date I opened the package. The internal packages with the swabs also have my initials and the date.
And what is that, sir?
This would be buccal swabs taken from George Zimmerman. That would be swabs taken from the inside of the mouth.
Okay. If I just show that to the jury, Your Honor. So all this writing that's on here in terms of, your initials would be on here, right here, right? I got it right. Where would your initials be on here?
Oh, right here.
Okay. And that would be true of all the exhibits, in other words, that you could verify that you actually did analysis on this?
Yes.
Okay. And it would have your FDLE number, and I think you said the yellow print card, or whatever you call this label, is also FDLE?
Yes, the yellow barcode label is from FDLE.
Now, those are what I think you referred to as standards, correct? Known standard from George Zimmerman and also from Trayvon Martin, is that correct?
Yes, those are known standards that were used for comparison to all the unknown samples in the case.
Okay. You do the process, you go through the extraction, quantification, et cetera, you get some results, I'm assuming, right?
Hopefully.
Okay. Did you get some in this case on both of those exhibits?
Yes.
Okay. Do you then prepare, and for the record, I'm going to show you State Exhibit 206, previously been shown to counsel and no objection. Well, I showed it to you. Okay. I'm going to show you this. I'm going to put it on the projector, but may I have personal witness, Sean? Let me actually show you the actual exhibit so you have it there. And I want you to talk about this and explaining, I believe there's 13 loci markers on this one. So let me show you State's Exhibit 206. Thank you, Your Honor. Tell us just, when you talked about all these markers, let's go, and you don't have your highlight thing, do you? I need Mr. Guy's assistance if I fit it back in. What's that? Right here. I'm going to give, may I first witness again, Your Honor? I'm going to give you this fancy pen, I guess, or whatever you call this. And I think the button's right. You see it? Okay. Let's talk about, you got 3 columns here. And let's, actually, I think I can do it here in red too. So you do green, I'll do red. But let's talk about this description right here. What are all these? I know they're referred to as loci. What does this mean right here?
This column right here is they are the names of the 13 locations that I tested for these samples. Their loci it's like a fancy scientific way of saying location. So I test 13 loci. Loci would be plural, and locus would be one single location. So these are their names, and they basically represent, about where these locations are located on the DNA molecule.
Who came up with D3S1358? Who came up with that fancy name for that?
I have no idea. They're basically representing where, on what chromosome. This would be on the chromosome 3, chromosome 8, and they represent about where on the DNA molecule that they are located, these locations that I test.
All right, and tell me the significance of this one right here that I'm circling.
Yes, the amylogenin location, it's in addition to the 13 location. It's a sex-determining location, and it gives me an indication of whether or not that individual has 2 X chromosomes, which would make them a female, or an X and a Y chromosome, which would make them a male.
Okay. If you could move to that middle column that's titled JR-2, Zimmerman JR2 is the number, I'm assuming, that was designated by FDLE or by the submitting agency?
Yes, that's the exhibit number, exhibit JR2, and that was from Sanford Police Department.
Okay. Under that column right there, you have, and it appears on each one of on each column, 2 numbers. Tell me the significance of that, if you could.
These numbers here, if you read down, this is the DNA profile for George Zimmerman. These numbers represent different size fragments of DNA that are found at that location. So that's my result at that location. These numbers are called alleles. And what these alleles represent are a different size fragment based on how many repeat units they have on those highly repetitive segments of DNA. And each person, like I said, inherits half of their DNA from their mother and half of their DNA from their father. So that's why at each of these 13 locations, you see 2 numbers. 1 came from each parent. There are times where you inherit the same size DNA at the one location, which is why there'll be 2 numbers that are the same.
Okay, now move on to the last column. I believe that's Trayvon Martin's, and ME3 means from the medical examiner's office. Is that correct?
Normally, when an exhibit comes from the medical examiner's office, it has an ME as the abbreviation, but it could be called anything. really, it's just a letter number designation that's unique to that sample in this case.
And in terms, you have the same on Mr. Martin, in terms of you have two numbers, obviously one from his father, one from his mother, is that correct?
Yes.
Okay. And while we're using this, if you had a mixture, can you just briefly tell us how that might appear in one of these two? I know you have a standard here, but if you had a mixture from an unknown sample, would you have another number conceivably in one of those columns?
Yes, these two DNA profiles are what I call single source DNA profiles. They came from one individual. These happen to be standards that are going to be used for comparison to the unknowns. If I have a mixture in a question sample, I may have a mixture, and the way I can tell is I'll have more than two alleles or more than two numbers at the location. So I may see 3, 4, 5, even 6, 7 numbers at one of these locations, and you'll see that consistently throughout the whole profile. That would give me an indication that I have multiple individuals contributing to that sample.
I want to now move on to the samples that you actually got here, and I want to first address, may I approach the witness, Your Honor? State's Exhibit 170, which are 4 swabs that were taken from a gun recovered from the defendant, George Zimmerman. And I ask you if you recognize said exhibit, sir.
Yes, I do. The outside container has my initials, the case number, barcode label, and the date I opened it. And all of the inside containers, the 4 swab containers, also have my initials and the date.
May I publish that to the jury, Your Honor?
Yes, you may.
So when you say swab, this is just basically a big Q-tip, I guess?
Yes, it's called a cotton tip swab. It's like a Q-tip, but there's only cotton on one end, and it usually has a wooden, sometimes a plastic stick.
So you've got, in this exhibit 174, separate swabs from different parts of the gun that's already been identified. But do you do an examination as to each one individually?
Yes, I open one exhibit at a time. So even though those 4 were found in the same envelope, they're all packaged separately and they came from different parts of the gun. So I would open one at a time and analyze one at a time.
And in terms of the DNA that you're attempting to get, are you actually, what do you do with the actual swab itself, or the cotton part of the swab? What do? You actually cut it, or what do you do with it?
Well, at first, if it's possible that blood may be present on that swab, I would do the chemical test for the possible presence of blood, and that's done by rubbing it on a piece of filter paper and then doing the actual chemical test on that filter paper. When I've determined if there's blood or no blood, or in this case I'm just going to take these on and do DNA testing regardless of the outcome of that test, I take a scalpel and I cut the cotton portion, whatever I feel I need to take from that cotton portion, and I put that cotton in a tube and perform the testing on it.
Sir, I'm going to show you, with the court's permission, may I approach the witness in a minute, but I'm going to show you State's Exhibit 203, which is a chart that is going to describe in greater detail your findings here, and I've previously been shown to counsel, to Mr. Romero. If you want to see.
Yes, you may.
formally introduce State's Exhibit 203. I believe there's no objection.
Being offered as an exhibit,
Yes, sir.
as a summary?
Yes, sir.
Summary
He's
exhibit?
gonna talk about all of them.
Oh, sure, okay, thank you.
Okay, we'll come in as State's Exhibit 203, thank you.
I apologize.
Yes, you may approach.
We're going to want to talk while we're at it about using, obviously, State's Exhibit 203. I want to talk about the 4 swabs that were taken from the defendant's gun. I believe the first one I want to talk about is the swab taken from the pistol grip. If you could, using that part of State's Exhibit 203, tell us the significance of your findings there, and just describe each part that is showing up there. Hopefully the jurors can all see that. It's got an FDLE number, right, exhibit number, and then you've got the description of what it is, swab 21A from pistol grip. Is that correct?
Yes. This is basically a summary of the testing I did, the results of that testing, and then the statistical analysis. So over here, this is the number that this exhibit got assigned when it came into the FDLE laboratory. I usually refer to them as the agencies, the Sanford Police Department's number, which is over here, which would be, it was DMS 21, and then since there were 4 swabs in the box, they got labeled A, B, C, D. So swab A here was from the grip of the gun, and I did the chemical test for the possible presence of blood on this swab, which gave me a positive result. So that's this column here, whether or not I did that chemical test. So that's this column here, whether or not I did that chemical test. The next column is whether or not that sample gave me an indication of a mixture of multiple people, or if it was a single source. So this one here, yes, meaning I got a mixture of DNA from the testing of that sample. I was able to resolve this mixture out. I was able to pick out or determine the major DNA profile in that mixture. And that's right here for the major. I got a complete DNA profile which matched George Zimmerman. And then the statistic here would be the random match probability. The probability that you would pick a random person off the street and that they would also, they would match that major DNA profile. So just to read that, the probability would be 1 in 11 quadrillion Caucasians, 1 in 1.5 quintillion African Americans, and 1 in 57 quadrillion Southeastern Hispanics. Okay. So going back to the mixture, also for the minor, which would be the lesser contributor or contributors, I was not able, not determined means I was not able to determine a profile for that minor or minor contributors. And the comparison of my other standard, which would be from Trayvon Martin, to that mixture, I determined that Trayvon Martin was excluded as being a possible contributor to that mixture.
So as to this part of the Exhibit 203, the swab or the DNA that you developed from the pistol grip of the defendant's gun, it was positive for blood, correct?
Yes.
And then there was a mixture. The major was matched the defendant, George Zimmerman.
Yes.
And you were able to exclude Trayvon Martin as having DNA on the pistol grip. Is that correct?
Yes, Trayvon Martin was excluded as being a possible contributor to this mixture on the grip.
I want to move next to the second part of the swab from the pistol trigger this time. On the previous exhibit that you examined, did you again perform or try to do the same testing, or tell us what that significance of that FDLE Exhibit 3 was, sir?
The 21B was a swab collected from the trigger of the pistol. I did not perform the chemical test for blood on that exhibit. The swab itself didn't give me an indication that blood might be present. There was very little staining on that swab, so I did not perform that test. I did not get a mixture of DNA, and the results that I got were so limited from that sample that I was not able to interpret those results. So when I get, when I get less than a complete DNA profile, like I said earlier, I could potentially get a partial DNA profile, but I could also get significantly less results than that. And if it doesn't meet a certain threshold, then I can't make any comparisons or interpretations with any of that data. It was too little data for me to make an interpretation on.
The other swab, I believe, was from the pistol slide. Tell us what your findings were regarding that, sir.
The swab from the pistol slide gave a negative result when I tested it for the possible presence of blood. The DNA testing result was not a mixture. It also gave me limited results. However, I was able to make determinations on this. It was too limited for me to match it to any one individual. However, I was able to make a comparison and potentially exclude any individual that I thought couldn't possibly have contributed to the sample. And as far as the comparison to the George Zimmerman and Trayvon Martin, I was not able to include or exclude either of those individuals to that limited sample.
There just wasn't enough there?
I just wasn't able to make a determination. There wasn't enough information of them for them present to make an inclusion, because I wasn't able to make an inclusion to the sample in general, and there wasn't enough of an absence of their information for me to say there's no way that they could have contributed to it.
I believe the fourth swab was taken from the holster itself. Tell us, and that's the last part of this slide that I've shown you, tell us if you could what your findings were regarding that.
The swab from the holster tested negative for the possible presence of blood. The DNA testing gave me a mixture of DNA. I was able to resolve out a major DNA profile for the sample, and that major DNA profile matched George Zimmerman. And the statistical analysis is right here. It's the same 1 in 11 quadrillion Caucasians, 1 in 1.5 quintillion African Americans, and 1 in 57 quadrillion Southeastern Hispanics. That would be for the probability of the major DNA profile. As far as the minor or lesser contributors, I was not able to determine a DNA profile for any of those minor contributors. And when I made the comparison to Trayvon Martin, I was not able to include or exclude him from the mixture.
So as to the holster where you got a major, it matches George Zimmerman, is that correct?
Correct.
Did you then also examine fingernail scrapings from Trayvon Martin taken at the medical examiner's office?
I did.
Your Honor, may I approach the witness?
Yes, you may.
Sir, I'm going to show you what's been, thank you, Your Honor. State's exhibit number 191, and I ask you if you recognize State's exhibit 191, sir.
I do. The outside packaging has my Florida Department Law Enforcement case number, barcode label, my initials, and the date. The two internal packages also have my initials and the date.
And these are not, at least when I look at them, they don't appear to be Q-tips in terms of a little swab at the end. Is that correct? What are these?
It's a wooden scraper stick. It has one pointy edge, and that edge is used to scrape down in between the fingernail and the skin to try to obtain any kind of foreign DNA that might be present under someone's fingernails that might have happened during an encounter or a struggle.
Okay. And so as the State's Exhibit 1, I'll get the right number here, 181, I believe. I'm sorry, yes, 191, excuse me. This would have, you can identify it as coming from the fingernail scrapes from medical examiner's office, Trayvon Benjamin Martin. Is that correct?
Yes.
Okay. Your Honor, may I publish these to the jury?
Yes, you may.
And even though you don't have a swab, how do you remove, if there is any DNA from this? What do you do?
I take a swab and I swab the pointy end to try to obtain anything that is on that pointy end that came from under the fingernails.
And let's, if we could, talk about your findings as to that specific exhibit, sir. I gather there's a right hand and a left hand, is that correct?
Yes, there were 2 envelopes inside the main envelope. One contained the right hand, which I labeled A, and the left hand was labeled B.
Okay. And if I could, I've put it up on the screen here. Tell us what your findings regarding your DNA analysis of the right-hand fingernail scrapings of Mr. Martin.
The right hand, the stick from the right hand had some red-brown staining on it, so I performed the chemical test for the possible presence of blood, and it tested positive. The DNA profile I obtained was a single-source profile, and it matched the DNA profile from Trayvon Martin. In a sample like this, I call this an intimate sample because it's collected directly from an individual's body. So when you collect a sample from an individual's body, their DNA profile is expected to be seen on that swab or on that sample. So what I'm looking for on an intimate sample is anything foreign to that person. And in this case, because the DNA profile matched Trayvon Martin, that means there were no DNA foreign to him on that sample.
In other words, from the right fingernail scrapings of Trayvon Martin, you did not find any of George Zimmerman's DNA there. Is that correct?
No, there was nothing foreign to Trayvon Martin.
If we could move to the second part, which I believe would be the fingernail scrapings from the left hand. If you could tell us your findings as to that, sir.
Yes, the left hand stick was not tested for the possible presence of blood. It did not have any staining on it whatsoever. I swabbed that, performed the testing, and I did not get any DNA results from that swab.
I believe you also examined some swabs, possible DNA swabs from the Skittles bag and also from the flashlight. Is that correct?
Yes.
Okay. If I may approach the witness again, Your Honor.
Yes, you may.
Sir, I'm showing you State Exhibit 169, and I ask you if you recognize State Exhibit 169, sir.
I do. The outside as well as the inside contain my initials and the date. The outside also contains my barcode, FDLE barcode label.
And are these 2 exhibits the swab from the Skittles and also from the flashlight? Yes, sir.
Yes.
Okay, and are they labeled as such? Does one say a bag of Skittles and the other one say flashlight on it?
Yes. Each box was labeled, and then I took and labeled them A and B.
Your Honor, may I publish that to the jury?
Yes, you may.
In other words, the box itself has labels as to where they came from. One says Skittles and the other one says flashlight. Is that correct?
Yes.
If we could, I want to ask you about your results or findings regarding those 2 exhibits, sir. Specifically, let's talk about the, thank you, Your Honor. Let's talk about the swab from the Skittles bag. What were your findings regarding that, sir?
The swab from the Skittles bag gave a positive result for the possible presence of blood. It was a single source DNA profile. It was a partial DNA profile, meaning I got less than the areas. These 2 samples, I tested 15 areas. It's 15 loci as opposed to the 13 on the rest of the samples in this case. So I got results at less than the 15 locations. However, that partial DNA profile did match Trayvon Martin, and the probability of finding that DNA profile at random would be 1 in 100 quadrillion Caucasians, 1 in 160 trillion African Americans, and 1 in 18 quadrillion Hispanics.
I want to move now to the swab from the flashlight recovered at the scene. If you could, what were your findings regarding that exhibit?
The swab from the flashlight gave a negative result for blood, and I was not able to obtain any DNA results from that swab.
Sir, I now want to move to some analysis you did of a sweatshirt or hooded sweatshirt, do you recall doing analysis, and I'm showing you for the record, State's Exhibit 118, a photograph. Do you recall doing analysis on that exhibit, sir?
Yes, I do.
Okay. With the court's permission, may we turn on the lights for, we're going to show the actual exhibit. So, thank you, Your Honor. And just to go, the court's permission, step down, Your Honor. Yes, We're going, let me, if I could, let's try this. Stand over here, just keep your voice a little loud, so let me, let's back up just a little bit. Make sure the court reporter can, you got that. Obviously, we've got the photograph up there, but what number is that, Mr. Guy? Is it on the back? 155. 155, do you recognize it, sir?
Yes, I do.
And how do you recognize it?
It has my tag, which is located right down here with the date I examined it, as well as my initials, case number, and exhibit number.
Okay. Now, there appear to be some circles right here and some numbers or letters or something. How did they get there?
Those are the stains that I saw during my visual examination of the item for possible blood. I performed the chemical test for blood on those items, on those stains, and I labeled them A, B, and C.
And we're going to get the photographs, and then we'll also, let me turn this around. You're showing the backside. Did you examine the whole thing itself?
Yes.
Okay. Now, this cutting, did you have anything to do with this cutting right here?
No, that was intact when I examined the item.
Okay. And there appears to be on the backside of this some writing here and some, I would refer to them as holes, but can you explain that, sir?
That would be my stain C that I examined, and those are the cuttings that I took to perform the DNA testing. So for this one, for example, I took 3 small cuttings, put them in one tube, and tested that sample.
So in other words, as opposed to the prior exhibits where you got a swab, you're actually looking at the exhibit yourself and making cuttings?
Correct.
Okay. There also appears to be on this exhibit, I can't testify, so tell me what this means right over here.
That would be stain B. Stain A was on the front bottom. Stain B is right here. And then this is stain C. Those are the 3 stains that I examined.
So from the hooded jacket or sweatshirt recovered from Trayvon Martin, you found 3 separate stains, is that correct?
That's correct.
Okay, and you've labeled them as B, C, and then I think on the front is A, is that correct?
That's correct, yes.
And does this accurately show the area where you made a cutting in order to determine whether that was DNA or not on there?
Yes.
Okay. And how can you say that actually occurred? Did you take photographs of it too? Did you document it somewhere other than obviously looking at it and you can see there's letters there?
It's all documented in my notes. I do have a photograph, which is on the screen up there, the photograph I took, but it's all documented in my notes, what I did and when I did it.
Okay. Your Honor, may he return back to his seat? Thank you. Gorgon, let's talk about the findings regarding the hooded jacket recovered from, or that Mr. Trayvon Martin was wearing. And I'm showing you State's Exhibit 119. Can you show us where there's a stain there, or appears to be a stain there?
That would be stain C, which was on the back of the sweatshirt.
Am I circling it right here?
Yes.
Okay. So in addition to actually making your cuttings, you're photographing what you do so that if you had to come and explain it to somebody or testify about it, you would be able to say, this is exactly where I got this cutting and this is where I got this result?
Correct. This is a photograph of before I did any testing. Obviously, there's no cutting taken there yet, but in my notes I describe chemical test for blood, the result, cutting taken, cutting not taken, and so on.
State's exhibit, I'm going back to 203, I believe it is. I want to ask you about the results. Let's talk about stain A that you've shown the jury already. Tell us what your findings were regarding that, sir.
Stain A gave me a positive result for blood, for the possible presence of blood. I obtained a single source profile, so no mixture. It was a partial DNA profile at less than the 13 locations that I test, and it matched the DNA profile from Trayvon Martin.
And I believe you stated stain A from the hooded jacket from Trayvon Martin was in the front, is that correct?
It was in the front lower part of the jacket.
Okay. Let's talk about the stain B, which I believe you stated it was one of the sleeves, is that correct?
Yes, stain B was on the sleeve, the left sleeve.
And if you could, tell us what your findings were regarding that, sir.
Stain B tested negative for the possible presence of blood, and I performed no further testing on that stain.
And the stain C, which I believe was in the back of that hooded jacket, what were your findings regarding that, sir?
Stain C gave me a positive result for the possible presence of blood. However, I was not able to obtain any DNA results from my testing.
I believe we have one more. Tell us, if you can, what your findings were regarding that specific exhibit.
In addition to the 3 stains that I tested, I was also asked to swab to see if there was any foreign DNA on the cuffs or the lower part of the sleeves of the sweatshirt. So I collected, well, first I did the test for blood on a rubbing from the entire cuff and lower part of the sleeve. I considered the lower sleeve from about the elbow down to the cuff. So I tested that whole area for the possible presence of blood, which tested negative for the right cuff and sleeve. I swabbed that area to see if there was any DNA foreign to Trayvon Martin, since it was his sweatshirt, so I can expect to potentially see his DNA profile there. And it was not, there was no DNA foreign to Trayvon Martin on that right sleeve.
And did you also do that to the left cuff or lower sleeve?
Correct. That was about the same results. It was negative for the possible presence of blood, and I was not able to obtain any DNA foreign to Trayvon Martin from the left sleeve cuff swab that I collected.
I want to make sure the jury understood that. Are you saying that as to the hooded jacket from Mr. Martin, right cuff and left cuff? Let me, Mr. Guy, would you help me with this exhibit? I want to make sure we're talking the same thing. Make sure the jury understands. Just go to where the witness is. When we approach the witness, Your Honor. Yes, you may. And for the record, I'm showing you State's Exhibit. Mr. Guy, it's on that side. 155. Okay. Mr. Gorgon, when you're talking about the sleeve, how much of the sleeve are you rubbing? If you could just, when the course may he stand up?
Yes, you may.
Tell us how much of the sleeve you're actually trying to get DNA from.
I swabbed the cuff and lower sleeve area, and I considered that from the elbow or midpoint of the sleeve forward. So I did the chemical test for blood from about here forward in the cuff, which tested negative, and I was not able to obtain any foreign DNA.
And did you do that also from his left sleeve?
Yes.
Okay. And when you're doing that, are you doing both sides or one side, or what part of the sleeve are you doing?
All the way around, so the front and back of the outside surface.
And then you said you're also tell us about this, what you're doing here at the cuffs?
The same thing. It was all collected with one swab, the cuff area to here.
Okay. And there was nothing foreign to Trayvon Martin. In other words, you didn't find another person's DNA on those, either one of those.
Correct.
Thank you, Mayor. Ma'am, take it back. Thank you, Your Honor. Did you do then examination or analysis on the sweatshirt that Mr. Martin was wearing underneath that hooded sweat jacket?
Yes, I did.
Okay, and do you see before you a photograph of State's Exhibit 120, sir?
Yes,
And did you perform or attempt to perform analysis on that exhibit, sir?
I did.
Okay. I'm showing you State's Exhibit 121, which I believe covers the bottom part of that sweatshirt, is that correct?
Yes, that's the bottom front surface.
Okay. And there appear to be, I'm circling as best I can, some numbers, or I'm sorry, some letters with some circles. How did those get there?
I put those circles there when I was visually examining the item for any red-brown stains that could possibly be blood, other than the large red-brown stain around the hole in the upper left-hand side. Those are any stains other than that. I circled to perform the chemical test and then possibly do DNA testing on those stains.
Mr. Gorgon, let me go back to State's Exhibit 120. When you say you did not do anything around this area that I'm circling right here where it appears there's a hole, is that correct?
Yes.
And why was that, sir?
I was requested to not touch that area. We needed to preserve that area for future testing in another discipline, in another department in my lab, the firearms section. So any disturbance that I cause in that area with my cuttings and rubbings and stuff could affect their future testing, as well as the fact that, you know, around the potential bullet hole there, we're pretty sure we know whose blood that is, and it's not as important as maybe the peripheral stains on the sweatshirt.
Let me then go back to 121. Now, why is it that you put a letter as to each one? Why do you put A, B, and it appears D right here, and then C? Why do you do that?
Just to have a unique identity to that stain, so I can refer back. Stain A was positive, stain B was positive, you know, or so on, as opposed to just circling them and you know, getting confused as to which stain. This way, I know what stain A is, I know where stain A is, and I know where stain A is located, and I know what I did to stain A and what the results were.
Okay. Let me show you, and let's talk now about your findings. And I apologize, Your Honor. Can we turn the lights back on? I'm going to show them the actual exhibit. Mr. Guy. We're going to try it up there. We approach the witness, Your Honor?
Yes, you may.
State Exhibit 156. We're good. If I can get you to look at this exhibit. Do you recognize this exhibit, sir?
Yes, I do. That has the white tag up towards the collar area, has my initials, as well as the date, the exhibit number, and the FDLE case number.
And can you point to the area that the jury just saw from the photographs in terms of A, B, and C?
Okay.
Yeah, I apologize, Your Honor. May he stand up?
Yes, you may. Go ahead.
Here, stain A is located in the lower right-hand portion. Right? Yeah. Right hand. Here is stain B.
Oh, I'm sorry. My fault. I'll tell you what, let me get Mr. Guy to assist us. And with the court's permission, may he just step down? We'll do it easier for you. I don't want you. Mr. Gorgon, let's go ahead and step down and let's use that table. And I apologize. My fault. Go ahead.
Stain C is located here. Stain D is a large stain in the middle here. And stain E is kind of on the side of the left-hand side.
And let's turn this around and make sure whether there was anything back here or not.
There were no stains located on the back that I performed testing on.
Okay, all right. Thank you. Thank you, sir. May we resume the seat, Your Honor?
Please be seated.
right, let's talk about your findings, sir. The gray sweatshirt from Trayvon Martin, stain A. Your Honor, we have assistance with the lights. I apologize. Tell us, if you could, what your findings were regarding stain A.
Stain A, which was located on the lower left-hand side, it tested positive for the possible presence of blood. I was able to obtain a single source complete DNA profile, which matched George Zimmerman, and the frequency occurrence of that DNA profile was 1 in 11 quadrillion Caucasians, 1 in 1.5 quintillion African Americans, and 1 in 57 quadrillion Southeastern Hispanics.
So, are you saying that in the shirt, gray sweatshirt, assuming Mr. Martin was wearing this, that was underneath the hooded jacket, that you found the defendant's DNA on there? Is that correct? On stain A?
Yes, the complete profile matched the profile of George Zimmerman.
Okay, let me backtrack a second. And stain A would be, believe you said right here, is that correct? I'm showing you
Yes.
for the record, States Exhibit 121.
That would be stain A, yes.
Let's talk about stain B from the gray sweatshirt of Trayvon Martin, sir.
Stain B also gave me a positive result for the possible presence of blood. I was able to obtain a single source complete DNA profile from stain B. It matched the profile of Trayvon Martin, and the frequency of occurrence for that complete DNA profile will be 1 in 3.9 quintillion Caucasians, 1 in 3 quadrillion African Americans, and 1 in 290 quadrillion Southeastern Hispanics.
So if we could talk about stain C from the gray sweatshirt, sir.
Stain C tested negative for the possible presence of blood. I did no further testing on that stain.
All right. I believe you also had a stain D, is that correct?
Yes.
Okay, tell us what your findings were regarding that.
Stain D tested positive for blood, for possible presence of blood. I was able to obtain a mixture of DNA from that exhibit. The mixture was not resolvable, meaning I was not able to determine which DNA profile in that mixture was a major contributor or a minor contributor. So in that instance, as I explained earlier, I take that entire mixture, all of those numbers at those locations, and compare the known standards to see are those individual DNA profiles represented amongst those alleles, those numbers. And I was able to determine that both George Zimmerman and Trayvon Martin were included as potential contributors to that mixture. And then the relevance of that is it's called a combined probability of inclusion, meaning if I pulled a random person off the street, tested their profile, what would be the probability that they would also be included as a potential contributor to that mixture. So the combined probability of inclusion for this mixture from stain D was 1 in 4 million Caucasians, 1 in 2.1 million African Americans, and 1 in 6.4 million Southeastern Hispanics.
And as to that mixture there, you've notated there, it's been notated defendant and Trayvon Martin included as possible contributors, is that correct?
Yes, they are included, both of them.
Okay. I want to talk about stain E from that gray sweatshirt, and what were your findings regarding that, sir?
Stain E tested positive for blood. I was able to obtain a complete single source profile from that, which matched Trayvon Martin. And then
Go ahead, I'm sorry. You've already covered in terms of the probability statistically. Stain E, where would that have come from? And stain D, where would those have come from, sir?
Stain D was the large stain that was in the middle of the front surface. Stain E was the smaller stain that was on the right-hand side, kind of like on the side of the sweatshirt, towards the bottom.
Let's talk about what's been described as the gray sweatshirt from Trayvon Martin, right cuff, lower sleeve. Tell us what your findings were regarding that, sir.
In the same fashion as the dark gray hooded sweatshirt, I did do the chemical test for blood on the lower half of the sleeve and cuff area for this sweatshirt, and the right sleeve and cuff tested negative for the possible presence of blood, and the DNA profile showed nothing foreign to Trayvon Martin.
If I could, did you do the same thing for the left cuff and left lower sleeve?
Yes.
And what were your findings regarding that, sir?
The left cuff and sleeve also tested negative for blood, and the DNA profile I obtained was a mixture. So when I have a sample where I can expect an individual's DNA profile because it was his sweatshirt, I can make that assumption and look at what was foreign to that individual. So there was foreign DNA to Trayvon Martin on that sleeve. However, it was too limited for me to be able to match it to any individual. I was able to potentially exclude if I felt a person could be excluded from that mixture as a foreign contributor. However, with my comparison, George Zimmerman's profile to that foreign DNA, I was not able to exclude him.
I want to then go to State's Exhibit 109, a photograph. I believe this is jacket that Mr. Zimmerman was wearing. There's some letters and circles. Tell us, if you could, what this photograph shows. And we'll actually show you the actual exhibit, but just briefly tell us the photograph.
This is a picture I took of the jacket represented as being worn by George Zimmerman. And I did the same visual examination on this jacket for potential red-brown stains that could be blood. And those were all circled. I was able to visually see 17 different stains, red-brown stains, that I wanted to test for possible blood. Those were labeled A through Q on this jacket. Here you can see Q and N and R. They're all throughout the jacket and the sleeves. I used an alternate light source because the color of the jacket and the red-brown stains kind of blended in together. So I used an alternate light source, which is different light bulbs of different wavelength that bring out the fluorescent property of certain bodily fluids. Semen fluoresces, saliva has a little bit of fluorescent property. Blood does not fluoresce. However, the different wavelengths of different light help you see the contrast sometimes between the potential blood stains and the color of the jacket. So using that alternate light source, I located 14 additional stains for a total of 31 stains. Those additional 14 were labeled stain R through stain EE.
Okay. Let me move to State's Exhibit 110. Is that the back side of that jacket, sir? Photograph
Yes.
of it?
Yes.
And State's Exhibit 111, what does that photograph show, sir?
That's the same jacket that was to stain A is located up kind of on the inside of the collar of the jacket. So I wanted to get a good picture of that so I can remember where that stain was located. It wasn't visible in the other pictures.
And am I circling another stain that you located?
Yes, that would be the last stain, which would be stain EE.
And State's Exhibit 112, what does that photograph show, sir?
That's the same jacket. That would be the back side of the right-hand sleeve.
And how about State's Exhibit 113, what does that photograph show, sir?
That would be the front side of the right-hand sleeve.
And State's Exhibit 114, what does that photograph show?
That would be the back side of the left sleeve.
And State's Exhibit 115, sir.
That would be the front side of the left sleeve.
Your Honor, with the court's permission, may we show the witness and exhibit? And this time I'll ask Mr. Gorgon to step down.
Yes, if you'll please step down.
Showing State Exhibit 151, sir. Gorgon, if you can just kind of show the jury what this exhibit shows, and I'm assuming you identify it by your markings.
Yes, this tag here contains my case number. There are my initials, the exhibit number, and the date that I performed this examination.
And for instance, right here on his right sleeve, there's some writing here in a circle and then some cutting. Do you use the same technique that you talked about earlier?
Yes, I visually examined and used the alternative light source to go through and circle any stains of interest. And then I performed the chemical test for possible presence of blood. Anything that was positive, I took on for DNA testing. Anything was negative, I'd stopped right there.
Now, when you're making all these cuttings from this exhibit, the jacket, do you kind of just put them all in a little bag or a little tube and then just kind of mix it together? Or do you keep each cutting that you make, each specific stain that you've labeled, you keep each one separately, or do you kind of just throw them all together?
No, every individual stain that I'm going to perform DNA testing on that gave a positive result, I cut a portion of that out and put it in its own individual tube. And that's the tube that I actually go on and perform the extraction and the quantitation and so on.
So you do, as to each particular stain, you do a separate analysis, is that correct?
That's correct.
Okay. Let me just show the jury the backside if we could. I'll trade with you. What does this part of State's Exhibit 151 show, sir?
It's the backside of the same jacket with more stains that I located.
Okay. So each one of these, now some holes apparently appear to be bigger to me visually than some other ones. Is there a reason for that?
It just depends on how concentrated the stain is. If the stain is very, very light, and I think I might have some difficulty with the amount of DNA present, I take a bigger cutting. And there are times where I even take multiple cuttings from the same stain, if it's a very big stain, and I put those all into one tube as stain B, for example, with this one here. Some are bigger because I thought I needed a little more sample. I try to determine about what I'm going to need to take in order to get a complete DNA profile. Because if it's a very dark blood stain, I don't need a huge cutting to be able to get a DNA profile. So I'd rather take a small cutting as possible so that there's more of the stain left in case I need to go back or someone else needs to go back and do testing on that.
And if you take like 2 cuttings out of this stain that I believe is labeled, is that a B there?
That's a B.
Okay. In other words, those would be, because it's in the same circle, those would be in the same tube, is that correct?
Yes, that's correct. If the multiple cuttings are in the same circle, part of the same stain, I put those in one tube and call it stain B. However, a stain B tube is separate than a stain D tube. Those are 2 separate tubes, 2 separate tests with different results, or potentially different results.
All right, Mr. Gorgon, resume the seat. Thank you. Let's, if we could, Mr. Gorgon, talk about your findings here. Let's talk about stain A. What were your findings regarding that as to defendant's jacket?
Stain A gave a positive result for blood. I was able to obtain a complete single source profile which matched George Zimmerman.
Okay. Let's talk about stain B from that jacket, sir.
Stain B gave the same result, positive for blood, matched complete single source profile matching George Zimmerman.
And I gather in your analysis here, if you would have found evidence of Trayvon Martin on there, you would have documented. Is that correct?
Correct.
In other words,
if I determine that a profile I obtained from a stain is from a single source, meaning there's no indication of a second person's DNA in that sample, then I compare it to the standard. If that matches, then that's a single source profile matching a known sample, and there's no foreign DNA. If I see some foreign DNA to that single source profile, then that's when I would indicate that I have a mixture of DNA.
Now, in terms of the stains you're looking at, are you looking just for blood, or are you just looking for, in other words, does blood, can there be other stuff other than blood there that would be DNA of foreign to somebody?
Yes, well, these stains tested positive for blood, and I took those cuttings that we were looking at, put them in a tube, and tested it. As far as what my results are from, I mean, if I have a blood stain, it's a pretty safe assumption that that DNA, or at least some of that DNA in that sample, came from that blood stain. But there's no way for me to tell, if I get a mixture of DNA, there's no way for me to tell, okay, this major came from the blood and this minor came from skin cells from someone touching the jacket or from saliva that's on the jacket. My DNA results, I can't tell exactly where those came from as far as the blood, semen, saliva, whatever bodily fluid I'm looking for on that item.
But so far as the stains A and B, they're both matching the defendant, and in other words, Trayvon Martin is not on either one of those stains, is that correct?
Yes, the profile in those two match the defendant.
Stain C from defendant's jacket, sir.
Stain C gave the same results, positive for blood, a complete single source profile matching George Zimmerman.
Stain D from defendant's jacket, what were your findings regarding that, sir?
Stain D tested negative for blood. So that was as far as I went with that one.
Okay, Stain E from defendant's jacket, what were your findings regarding that?
Stain E gave a positive result for blood. So I brought that on to DNA testing. It gave me a mixture of DNA. I was able to resolve out a complete DNA profile for the major contributor to the mixture, and that matched George Zimmerman. The minor, I was not able to determine any DNA profiles for the lesser contributors or minor contributors, and I was not able to make any determination as far as if Trayvon Martin was included or excluded to that mixture.
And is that because you didn't have enough there to be able to say it is Trayvon Martin or it isn't?
I was able to make inclusions or exclusions to that mixture. However, when I made the comparison, it was in that in-between stage that I talked about, where I didn't have enough of his information to say he's definitely included in this mixture, and I didn't have enough absence to say I believe for sure that he could not have contributed to the mixture.
And do you recall Stain E where it was on defendant's jacket, sir?
I would have to look at the picture again.
Okay. We can go back to the exhibit, but go ahead if you need to look at the picture.
Stain E was located on the back right shoulder of the jacket. So right about here, the back of the right shoulder.
I'm sorry, the back right shoulder of the jacket, is that correct?
Yes.
Let's move on to Stain F from the defendant's jacket.
Stain F tested negative for blood, so no DNA testing was performed.
Stain G.
Stain G gave me a positive result for the possible presence of blood. The DNA testing of that item gave me limited results, so limited that I was not able to make any kind of interpretations on that result.
Stain H from defendant's jacket, sir.
Stain H tested negative for blood.
Stain I.
Stain I gave me a positive result for blood. The DNA testing showed a mixture of DNA. I was able to resolve out a partial DNA profile for the major contributor to that mixture, which matched George Zimmerman. And the statistical analysis over here is on that partial profile for that major contributor. The minor, I could not determine a DNA profile for any of the lesser contributors to the mixture. However, in my comparison, Trayvon Martin was excluded as a possible contributor to that mixture.
So in other words, there's no way that was Trayvon Martin. You excluded him completely.
Yes, that was my determination.
Stain J, from the defendant's jacket.
Stain J gave a positive result for blood. The DNA testing gave me a complete single source profile which matched George Zimmerman.
Okay. Defendant's jacket, Stain K, sir.
Stain K gave a positive result for blood. I obtained a complete single source profile matching George Zimmerman.
Stain L from defendant's jacket, sir.
Stain L also gave a positive result for blood. The testing was the same, complete single source profile matching George Zimmerman.
Stain M from that jacket, sir?
That would be the same result, positive for blood, single source complete profile matching George Zimmerman.
States N?
Stain N gave a positive result for blood. I obtained a mixture of DNA. The major contributor and the DNA profile for the minor contributor in this sample were both resolved.
And
Meaning-
what were your findings?
The major contributor matched George Zimmerman, and the minor, which was a partial profile for that minor contributor, that matched Trayvon Martin.
And when you say a partial profile, what do you mean?
Meaning I was able to determine the minor, lesser contributor's profile at less than the 13 locations.
Okay. And do you recall where stain N was on defendant's jacket, sir?
Stain N is on the front right upper part of the jacket. So the kind of the front of the right hand shoulder.
Stain O, sir. What were your findings regarding that?
Stain O tested positive for blood. I got a complete single source profile matching George Zimmerman.
Continuing defendant's jacket, stain P, sir. What were your findings regarding that?
Stain P gave a positive result for blood, a complete single source profile matching George Zimmerman.
Stain Q?
Excuse me. Stain Q was negative for blood.
Stain R?
Stain R was also negative for blood.
Stain S?
Stain S also negative for possible presence of blood.
Stain T?
Stain T was also negative.
Continuing defendant's jacket, stain U, sir.
Stain U gave a positive result for the possible presence of blood. I obtained a mixture of DNA that I was not able to resolve into any single source major or minor contributors. When comparing the two DNA standards to the mixture, I determined that Trayvon Martin was included as a possible contributor to the mixture, and then the statistical analysis is over here for anyone who could potentially, probability that you could potentially be included in that mixture. That would be 1 in 83,000 Caucasians, 1 in 10,000 African Americans, and 1 in 67,000 Southeastern Hispanics. And the comparison of George Zimmerman to the mixture, I was not able to make any determination as far as whether he was included or excluded.
So in that particular stain, Trayvon Martin is included as a possible contributor. Where was that stain on the defendant's jacket, sir?
Stain U was located on the cuff of it was kind of on the bottom of the right hand cuff. There's like a Velcro part, I guess, to tighten the cuff, and it was on that piece of Velcro on the bottom of the right
Can you
hand cuff.
demonstrate that in terms of what you're saying, the
Right hand cuff, right about in this location.
so that would be the defendant's, assuming he was wearing that jacket, that would be in his right side, right near his right hand, is that correct?
Yes.
Okay. Thank you, sir. State's exhibit, defendant's jacket, stain V.
Stain V gave me a positive result for the possible presence of blood. The DNA results were too limited for me to be able to match to anyone. However, I was able to possibly exclude people if I felt they could be excluded from that limited results. However, I was not able to make a determination on either George Zimmerman or Trayvon Martin, so I was not able to exclude either of them.
State's exhibit, defendant's jacket, stain W, sir.
Stain W was negative for blood.
And stain X from defendant's jacket, sir?
That was also negative for blood.
Stain Y, sir?
Stain Y was negative as well.
Defendant's jacket, continuing stain is Z like in zebra?
Stain Z gave me a positive result for blood. However, the DNA testing was too limited for me. The results were too limited for me to be able to make any kind of interpretations.
Defendant's jacket, stain AA, sir.
Stain AA was negative for blood.
Stain double B, sir.
Stain double B was positive for the possible presence of blood. I received or obtained a mixture of DNA. I was not able to resolve that mixture into any kind of major or minor single source profiles. George Zimmerman was included as a possible contributor to the mixture, and the probability of inclusion for that mixture was 1 in 58 Caucasians, 1 in 41 African Americans, and 1 in 57 Southeastern Hispanics. I was not able to exclude or include Trayvon Martin to the mixture.
Do you recall where stain BB or double B was in the defendant's jacket?
Stain BB is on the back surface of the jacket. It's on the left hand shoulder on the back, kind of towards the middle, so almost below the neck. It looks like it's about 6 or 7 inches from below the neck on the back.
Stain double C on defendant's jacket, sir?
Stain double C tested negative for blood.
Defendant's jacket, stain double D.
DD tested negative as well for blood.
And finally, defendant's jacket, stain double E.
Stain double E was negative for blood.
Sir, I'm going to now move and show you State's Exhibit 116. I believe that was identified as defendant's shirt underneath the jacket that he was wearing. Do you recognize that photograph, sir?
Yes, I do.
Okay. Did you perform some DNA analysis on that exhibit, sir?
I did.
All right. And we're going to show the jury the actual exhibit with the court's permission, but I'm circling what appears to be here some kind of holes or circles or something. Is that the same kind of analysis you did in terms of cuttings?
Yes, I performed a visual analysis of this item, and I was able to obtain or to visualize all red-brown stains that I was interested in potentially testing. They were labeled A through P on this one. There were 16 total stains.
Stage Exhibit 117, is that the backside of that same exhibit, sir, or item?
Yes.
Photograph of it? Okay. With the court's permission, may we show the witness and may Mr. Gorgon step down again?
Yes, sir. Please step down. Okay, we have a paper change, so
Just, you can move with the exhibit, but just wait to speak.
Mr. Gorgon,
Hold on.
I apologize.
Okay.
Sorry.
Done now. Okay.
You ready, Madam
Yep.
Court Reporter?
Thank you.
Sir, I'm showing you Stage Exhibit 153. It's been identified as gray shirt worn by George Zimmerman under that jacket. And if you could just tell briefly the cuttings. I apologize, Mr. West needs to.
That's fine, go ahead.
If you could just tell us what this shows.
This is the shirt represented as being worn by George Zimmerman, and these are the stains that I performed the chemical test for blood. A through H is located on the front, and then J is up here on the top of the back of the neck, and there are more on the back.
Yeah, we're going to show you
I
that.
believe stain I is here on the cuff of the right hand.
All right. So this would be the front side of the shirt, is that correct? Long
Yes.
sleeve shirt? And so you found, potentially, you made cuttings from the front side, and these are all here in the front?
Yes.
Okay. In other words, and if he was wearing a jacket, these are still, in other words, if the jacket was closed, this is still underneath the jacket, I'm assuming. In other words, this shirt, if he was wearing it like you would wear a shirt, is that correct?
I would assume the shirt would be underneath the jacket.
Okay. And let me show you the back side of this exhibit. And tell us what that shows there, sir.
This is the back side of that same shirt. Here's my tag with my initials, the date, the case number, the date that I examined it on. There are 2 K and L, stains K and L are on the back of the neck, and then M through P are here in the middle of the back.
In your honor, may Mr. Gorgon resume the seat? And we move this back.
Please take your seat, sir.
Mr. Gorgon, I'm going to ask you about your findings regarding the defendant's shirt. Let's talk about stain A first. What were your findings regarding that, sir?
Stain A gave a positive result for blood. I obtained a complete single source profile matching George Zimmerman.
Stain B from that shirt, sir?
Stain B also gave a positive result for blood. I obtained a single source profile matching George Zimmerman.
Stain C from the defendant's shirt?
Stain C gave a positive result for the possible presence of blood. Also, single source complete DNA profile matching George Zimmerman.
And so at least these three stains, you're finding that it's positive in terms of blood, correct, versus just regular DNA?
Yes, they were positive for blood.
Okay. States Exhibit D?
The same result for stain D, positive for the possible presence of blood. Complete DNA profile matching George Zimmerman.
Stain E from the defendant's shirt?
Stain E would be the same result, positive for blood. Complete single source matching George Zimmerman.
Again, defendant's shirt, stain F?
Stain F gave the same result.
Stain G from defendant's shirt?
Stain G was negative for the possible presence of blood, and no further testing was performed.
Stain H from defendant's shirt?
Stain H was also negative for possible presence of blood.
Stain I from defendant's shirt?
Stain I was positive for blood. It gave a single source complete profile which matched George Zimmerman.
Stain J from defendant's shirt?
Stain J gave the same result, complete, a positive for blood, complete single source matching George Zimmerman.
Stain K from defendant's shirt?
Stain K gave a positive result for the possible presence of blood, single source matching George Zimmerman.
Stain L from defendant's shirt?
Stain L gave the same result,
Meaning matching
meaning
George
positive for blood matching George Zimmerman.
Stain M from defendant's shirt?
Stain M, same result, positive for blood, complete single source matching George Zimmerman.
Stain N from defendant's shirt?
Stain N, same result, positive for blood, complete single source matching George Zimmerman.
Stain O from defendant's shirt, sir?
Stain O was the same exact result, positive for blood, complete single source matching George Zimmerman.
And stain P from defendant's shirt, sir?
Stain P, positive for blood, single source, complete profile matching George Zimmerman.
We're through for the light, Your Honor. Thank you very much. If I may have a moment, Your Honor?
Yes, you may.
I don't have any further questions. Thank you, sir.
Okay, thank you. Cross?
May we have a short recess?
Yes, we may. Ladies and gentlemen, we'll take a 15-minute recess. Please put your notepads face down on the chair and follow Deputy Jarvis. Please be seated. Mr. Gorgon, you're free to walk around for the 15-minute recess, but you're not free to discuss your testimony with anybody, and that includes the lawyers. Okay? Cool. Yes, you may. Court will be in recess for 15 minutes. The jury back in? Mr. West, you ready, sir?
Yes, Your Honor.
Okay, thank you. Let's go ahead and bring him in. Please be seated. Mr. West, you may proceed.
Good afternoon.
Good afternoon.
Do you have this chart in front of you?
I do.
Okay, so if we refer to that, you've got a reference?
Yes, I have my reports as well.
When you say reports, you're talking about the summary findings?
The 3 reports I issued with all the results
Right.
that
and-
are in this chart.
Okay, and do you have your notes with you if need be?
Yes.
Great, okay. The chart, thank you. The chart is exhibit number 203. Is that what yours says?
Yes, it has a 203 on it.
Okay. What I'd like to try to do is sort of track through the evidence a lot in the same order that was just done, so sort of keep that sequence and that frame of reference.
Okay.
But before, let's talk a little bit, Joe, generally about the DNA work that you do. It sounds like a lot of the analysis that you did was based upon evidence collection that someone else did. For example, swabs from other items.
That's correct.
So you would have played no part in collecting whatever evidence may exist from that flashlight, for example.
Correct. I don't actually go to scenes and collect evidence. I've actually never been to a scene and collected evidence. I first see the evidence when it comes in to the laboratory and brought to me in a sealed envelope or a sealed paper bag, and I take it from there. Sometimes it's a swab that someone else collects. Sometimes, as in the jacket and sweatshirt, sometimes it's the actual item.
But it's always gone through someone else's hands first.
Yes, that's correct.
And in this instance, there were swabs of the firearm of 4 different sections of the firearm.
Yes.
So you don't make any determination, then I take it, where DNA should be and isn't, for example. You just report what you find.
Correct. In that instance, I just test those 4 swabs and report my results from those 4 swabs.
For example, it's not in dispute that George Zimmerman fired the gun, but there was no DNA on the trigger. You don't try to figure out why that might be.
That's correct. I just report out that I was not able to obtain any DNA results from that swab from the trigger.
Sometimes you can touch an object and there not be any DNA left behind.
That's correct.
Sometimes if there might even be blood, it could be wiped off.
Yes, that's correct as well. Items can be washed and cleaned, wiped, washed, and that could affect my ability to get any DNA from touch evidence or blood evidence on an item.
That might include environmental factors, whether or not it's raining, for example.
Yes, moisture, heat, humidity, all those environmental factors can degrade DNA, meaning it chops the DNA up into pieces. The DNA is a long chain with letters, and those letters, segments of those chains, those are those 13 loci that I test. So if those segments are degraded, those short segments are degraded and in pieces, that affects my ability to amplify and make copies of those short segments and be able to see any results that I can make any kind of comparisons with.
You're suggesting that humidity, specifically rain, can do that?
Moisture, which involves humidity and rain.
And of course, it's possible, I suppose, on a gun, for example, that because it's a hard surface, it could just be wiped off because someone handled it.
That's correct, yes. A gun is a hard surface, so any touch DNA or skin cells is going to be on that hard surface. There's no medium for any skin cells to soak into it, as, for example, in a shirt. Sometimes if I'm trying to determine who's wearing a shirt and I'm trying to get skin cells from like the inside of the collar or the armpits that come in contact with that individual, that shirt could soak in those skin cells. on a hard surface like a gun or a knife or a pen. I'm trying to get what's on that surface. It's a hard surface, and it's not good for collecting and retaining touch DNA.
So, for example, on 21C, the pistol slide that we talked about a minute ago, your conclusion was that there were limited DNA results, and you were not able to make a determination regarding Mr. Zimmerman or Mr. Martin.
Yes, 21C from the slide. That's correct.
Which means that there was some DNA that you could identify through analysis.
Correct. There was some information present from my testing of that item. It was not enough information for me to be able to match it to any one individual. I can't tell if it's a mixture or single source because a lot of that information that I need is missing. But there was enough information for that specific sample for me to make comparisons and make an exclusion, potentially. And I wasn't able to exclude either of the two individuals.
So what that means, bottom line, is that in some situations you have limited DNA, but you have enough to say it could not have come from someone.
Correct.
Whereas in this case, you had a limited amount, but indeed the DNA could have come from either George Zimmerman or Trayvon Martin.
I wasn't able to exclude them, so I can't say that there's no way that they could have contributed to that very limited sample.
Mm-hmm. Of course, the slide of the gun is also a hard surface that would be subject to not only the same environmental effects that you talked about, but perhaps handling, the way the evidence was packaged or secured even.
Correct.
Similarly, with regard to the holster, you did indicate that you were able to identify a profile that matched Mr. Zimmerman.
Correct. There was
So you're confident then that Mr. Zimmerman's DNA is on the holster?
The major DNA profile from the holster matched George Zimmerman.
And you wouldn't know from what part of the holster, for example?
No, I don't know where on the holster they swabbed. It was represented as coming from the holster, so I don't know if that means the entire holster, the inside, outside, or what.
Just somewhere on that greater surface, there must have been some of George Zimmerman's DNA somewhere.
Yes, the major profile matched George Zimmerman.
And then insofar as the holster from Trayvon Martin, you had limited information on a minor contributor?
Yes.
And you were not able to exclude or specifically include Trayvon Martin as a contributor to that DNA?
That's correct.
When you say exclude, you mean could not possibly have been in your world. In the scientific world of DNA statistics, when you exclude somebody, you're saying with those kinds of numbers, it really couldn't have been that person.
No, I'm saying there's enough of an absence of their information that they could not have been part of that data. That data that I'm seeing, that mixture of DNA, if I exclude someone, I'm saying they could not, I don't think they contributed to that data. Does that mean they never touched or came in contact or have seen that item? I don't know. I know from what I tested on that swab and my results, if I exclude someone, I'm saying I don't think that they are possibly part of that data that I obtained from that swab.
And when you say you've excluded them, it's based upon that probability statistical model that you talked about?
Not necessarily.
No?
I'm saying I don't feel that their information is not represented enough that I feel there's no way that they could have contributed to that data. I performed the statistics for the inclusions and matches to show relevance for a match or an inclusion, but an exclusion is just, I don't feel that that person could have contributed, and that's the end of it.
Not enough data. Well, of the data that you have, it simply doesn't match in any meaningful way the person that you've excluded.
Exactly. The data present does not enough of that person's profile is present in that unknown sample for me to say they could have possibly contributed to it.
Does the ability to conduct reliable, meaningful DNA analysis sometimes also depend on the way the evidence is collected and packaged.
Yes.
So, for example, if the collection was just not a good job, there could be DNA that was missed, and you wouldn't know that.
Potentially, if an item is collected and not stored properly or packaged properly, it could be exposed to those environmental factors that I discussed earlier, like heat, humidity, bacteria, microorganisms. All of those can degrade DNA on a sample, on a gun or a knife or whatever sample we're talking about. And once that damage is done, once that DNA is degraded and in pieces, that's going to affect my ability to see results when I look at that DNA profile.
It's very difficult for you to be able to figure out how much damage was done. It's hard to know what you don't know, in other words.
Correct. The first I see of the evidence is when it's brought to me in the laboratory, the package. I don't know when that was collected, how it was stored, how long it was sitting in an office or wherever before it was submitted to our laboratory.
I think the next item that you talked about were swabs that were collected. I'm sorry, these little Exhibit 169 are the swabs from the flashlight that had no DNA results, correct? And also the swab from the bag of Skittles candy?
Correct.
And similarly, you received the swabs, someone else swabbed the item itself and gave this to you, and you did your analysis.
Yes, I never saw the bag, the Skittles bag or the flashlight.
Now we have Exhibit 191. Those are the little wooden sticks that you talked about that in your training and experience are used for fingernail scrapings.
Yes.
And what your understanding of the procedure is that the small stick is scraped under the edge of the fingernail to see if whatever's under the fingernail that might have some biological component is gathered on the stick and then submitted to you.
That's correct.
So I take it could be blood, but it could be other stuff too?
Well, if I see red-brown staining on the item, I do test it for the possible presence of blood, which I did with the right hand, the stick collected from the right hand, and that gave me a positive result.
Yes.
So,
I'm sorry, I didn't mean to cut you off. You actually saw something on the stick that made you think it could be blood?
Yes.
And then you did the presumptive?
Yes.
And then you got a positive, so you did the DNA?
Yes.
And you indeed were able to confirm that that was Trayvon Martin's blood?
Yes, the profile matched him, which means nothing foreign. I did not find anything foreign to him on that stick.
And then on the left, I don't want to confuse them. Which one was negative?
The left hand, I did not test for blood. There was no staining on the stick collected from the left hand, and I was not able to obtain any DNA results from my testing on that stick.
So even though you didn't see what in your mind might be blood, you tested it anyway?
Yeah, well, I'm not necessarily looking for blood. A lot of times when fingernails or fingernail scrapings are collected, there's going to be blood present. A lot of times that person is bleeding, touching that area that they're bleeding from, and their own blood a lot of times is going to be present. I'm more interested in anything foreign to the person whose fingernails they are. So I'm more interested in any maybe skin from the other person or other people involved in the incident that might have scraped off underneath the fingernails of that individual. It could be blood from that other individual. If there was a fight and that other person was bleeding, there could be blood from both people. underneath the fingernails. But I'm more interested in anything foreign to the blood from that person.
Insofar as the blood on the right hand from Trayvon Martin, you would have no idea when that blood may have come in contact with his fingernail.
That's correct.
Whether it was during whatever incident took place or after, if he touched his own clothing that had blood.
That's correct.
Or transferred from during the process of delivery service, for example. In other words, you just don't know.
That's correct. I just know whatever was on that stick when I swabbed it, that's when those are the results. I don't know when whatever DNA got underneath those fingernails. I don't know when that happened.
And on the left hand, there was no DNA of anyone, not even Trayvon Martin.
That's correct.
Did that surprise you?
No.
Because there just wasn't? Is that what it boils down to?
I mean, it's a very small stick, and you're scraping underneath fingernails. I can expect to see the DNA from that person whose fingers they are. However, it's not a guarantee that I'm going to get DNA from them. Most of the time, you see at least some kind of DNA profile from that individual, but it doesn't surprise me if I get no DNA results. It's a very small stick that I'm swabbing in a very small area that they're trying to collect DNA from.
That's something that you've seen before, where there just hasn't been any DNA on the fingernail scraping stick.
That's correct.
So in other words, the absence of evidence isn't particularly significant to you in that instance?
No.
Have you, I take it that you were not present when that process was done?
I was not.
So you didn't see anyone do any scraping, and I take it you never saw Trayvon Martin's fingernails?
No.
You don't know if they were long or short or whether there was anything at all visible?
No, I have no idea.
There is something curious here, though, that I wanted to ask you about. There's only one each, one for left and one for right. Do you think in evidence collection that all 5 fingers on each hand would have been scraped with the same stick?
Yes, generally speaking, that one stick would be used to scrape all 5 fingernails from that hand.
So you would take the stick and you would pull it underneath one fingernail, and then you would take the same thing and pull it under the other, and then likewise for each hand?
I've never done that process. I've never worked in the capacity where I'd be collecting that type of evidence, but I would imagine that that's how they would be doing it. But again, I would just be guessing because I've never done that.
Oh, I'm sorry. So you sort of just, in your mind, common sense would tell you that one stick would be used for all 5?
Yes.
As opposed to maybe only one fingernail was scraped on each hand?
I mean, that's certainly a possibility. However, they represented that from being the left hand. So in my mind, they scraped all 5 fingernails from that left hand and from that right hand with those 2 sticks.
If this matters to you, on the packaging it says fingernail left and fingernail right, as opposed to fingernails. Does that mean anything to you?
No.
You didn't participate at all in the collection of this, as you said. Well, we can talk to the people that did.
Yes, that's how they chose to label and type it out and put that label on there.
I noticed, though, just curiously, that each part of the gun was swabbed separately. Do you remember that?
Yes.
So there's a swab that relates to a slide, a separate one for the grip, a separate one for the trigger, and then a separate one for the holster.
Yes.
So that would tell you where, at least from what part, more precisely, any DNA was located.
Yes.
So, for example, on that that right hand, I guess, where Trayvon Martin's blood was, you would have no idea under which nail or where that was actually collected.
That's correct. Somewhere on the right hand, that blood was present, at least under one of those fingernails.
According to the packaging.
Yes.
All right, let's talk about the hooded sweatshirt for a moment. I believe that's Exhibit 155. That's represented in Exhibit 118 in the picture. Let's talk about the packaging of this particular item, or in fact, well, first, did you do any processing for DNA of any sort on Trayvon Martin's pants?
No.
Never saw those?
No.
So your DNA analysis was based upon two articles of clothing, the hooded sweatshirt and then the underneath shirt?
As far as what Trayvon Martin was wearing?
Yes.
Yes.
Mm-hmm. So as far as those particular items, you talked a little bit about packaging. Packaging that can, by virtue of how it's packaged, cause degradation of biological samples?
It could potentially, yes.
You're familiar with NIST? Do you know the acronym NIST?
National Institute of Standards and Technology.
Right. That's an organization that helps standardize such things as evidence collection techniques and such.
Yes. NIST is a government organization that issues standards. We actually have the standards for like calibration and stuff like that as a reference to make sure that your instrumentation works. We actually have NIST standards in our laboratory that we're required to run annually, and sometimes more than that, depending on if we get a new instrument or any new chemistry, to make sure that we're obtaining the right results from these standards.
And is NIST part of the accreditation process for the lab?
No.
Then you mentioned that the lab is accredited.
Yes.
But that's a different set of standards than the NIST standards that you were talking about?
That's correct.
Explain that just a bit.
We are accredited by ASCLD Lab. That stands for the American Society of Crime Lab Directors Laboratory Accreditation Board, and it's an organization made up of forensic laboratory directors from all over the country, and they come out and they do a thorough inspection of your facilities, your standard operating procedures, your case files. They interview your personnel, and they make sure that you meet the FBI's quality assurance standards in order to maintain or get accreditation. That inspection takes place every 5 years. We had one in 2010, just 3 years ago now. And in between those 5-year inspections, we're required to maintain accreditation. We're required to undergo an internal audit every year and an external audit every other year.
And in addition to that, for the lab, you also yourself have to undergo regular proficiency testing?
Yes, that's part of the accreditation process that every analyst or forensic technologist that wants to be proficient in DNA testing needs to undergo those proficiency tests that I discussed at the very beginning of my testimony. Tests from outside companies that I run. It's a set of samples that I run as if it were a case, and I send the results out, and then they send a notice back saying I passed or I didn't pass, and that I do every 6 months. Everyone in the lab is required to do that every 6 months.
Sounds like at least then 10 times each 5-year cycle that you yourself have to go through proficiency testing.
Yes.
When we're talking about standards and we're talking about biological evidence in particular. Is biological evidence sort of a broad term for what may contain blood, fluids, DNA, and that sort of thing?
Yes, it is. I work in the biology section, so we don't call it the DNA section, we're the biology section. It encompassed not just DNA. At one point, back before DNA testing, there was other testing done on, it's called biological fluid.
And it's well known that handling and packaging wet evidence that may have biological evidence on it is how it should be done. I didn't say that at all.
Can you repeat the question?
Yes, it's well known in the process of collecting and preserving biological evidence how you should handle wet evidence.
Correct.
In fact, wet evidence that's believed to contain biological material is supposed to be air dried.
Yes, anything wet that might have blood or any kind of biological material on it should be dried down, because if it remains wet, that moisture, if you package it, that could get trapped in, and you could develop microorganisms, bacteria, mold, whatever, and all of those things degrade the DNA that might be there.
In fact, it's recognized that there's a high probability that biological material will be destroyed by bacterial growth, which could potentially preclude the generation of DNA results if wet material isn't air dried.
That's correct.
So that brings us to the sweatshirts. Were you present at the time they were received by FDLE or soon thereafter?
The first time I saw the sweatshirt was when the package was brought to myself.
Had it been opened already?
Yes.
Who opened it?
Alvin Guzman, who is an analyst or forensic technologist in the trace evidence section, had already opened that package and done his examination, and then sealed that back in the package, and I got a transfer from him.
Trace evidence is another section of your lab?
Yes.
Just generally, that's where the evidence might be inspected for stuff. Whatever little stuff might be clinging to it, it would be collected and packaged and then perhaps submitted to someone else to analyze?
Yes. Trace evidence looks at like small fibers and stuff like that.
And when you got the evidence of the two shirts, were they repackaged and sealed in the same packaging that they were submitted to the lab?
Yes.
And what was that, please?
The outer container was a... May I refer to my notes?
Of course.
Okay. Both sweatshirts, the light gray one and the dark gray one, they were both packaged. The outer container was a sealed brown paper bag, and then inside that sealed brown paper bag was a red, what I call a biohazard bag. It's a red plastic bag that's usually used for putting biohazardous material in. And that biohazard bag was not sealed with tape necessarily, but it was knotted, sealed with a knot. And then inside that red bag was the sweatshirt, both sweatshirts, individually in separate packages, not in the same package.
It's common for you to receive evidence in brown paper bags, correct?
Yes, brown paper bags is ideal for packaging items because the paper bag lets the item breathe. So if there's any moisture in there, it'll dry out.
Unfortunately, in this situation, while the exterior packaging was brown paper, the interior packaging was plastic.
Yes, it was a red biohazard plastic bag.
Mm-hmm. And even though you didn't see it when Mr. Guzman opened it, you're saying that he tied it back up before he gave it to you?
Yes.
And then when you opened it to begin your inspection, you detected quite an odor of mold or ammonia. Is that
Yes.
correct? It struck you that it smelled bad.
On one of the sweatshirts, the dark gray hooded sweatshirt. The light gray sweatshirt did not have the same odor.
And that meant to you that it maybe wasn't as wet?
Correct.
I take it your assumption, your professional assumption was this smell is associated with evidence that has been packaged wet and then stored for a period of time.
Correct. The items, both sweatshirts were still wet when I opened the package. The light gray non-hooded sweatshirt was damp, a little damp. It wasn't really that wet. The dark gray hooded sweatshirt was more damp. It was wet, and it had a very pungent odor. Ammonia, mold. I'm not exactly sure what the odor was. But something along those lines. I noted in my notes.
Did you ever find your gym bag in the trunk after a couple of weeks? That kind of odor? You know what I'm talking about? Kind of a strong ammonia, mold, this dirty laundry that's been sitting around a while?
I've had sports equipment that have smelled like that before, yes.
What should have been done, if I hear what you're saying, is that the clothing should have been air dried before it was packaged, or at least packaged in paper bags.
That's correct. Ideally, yes, you'd like to air dry anything you collect, especially items of clothing that are wet. You'd like to air dry them before you package them. And on top of that, we encourage our agencies not to put things into plastic bags because those don't allow the evidence to breathe, and that'll trap in any kind of moisture.
And that would be a red flag to you as an analyst that there's something going on with this evidence that places the biological evidence at a risk of degradation.
Correct.
The things that you were talking about before, how the strands break up and such?
Yes, that's correct.
And I take it would be impossible for you to be able to quantify precisely how much degradation there was.
And that's correct. I mean, you can tell by the testing you do, maybe you expect more results than you got, and you can say, oh, there was probably some degradation. However, I mean, that's a hypothetical situation. If the evidence were allowed to dry down and package properly, would I have gotten more results? Potentially, but I don't know for sure, and that's a hypothetical.
That's an unknown factor in this case.
Correct.
You don't know what you don't know.
Exactly.
So, did you dry the evidence at that point?
I left it out to dry as long as I could. However, I needed to transfer that item to a firearms examiner, Amy Siewert. So I can't, when we transfer from one section to another section, I just can't take the sweatshirt and hand it to her, say, here you go. That needs to be put back into the original packaging for the transfer. So I did package that back up, and it was still wet when I packaged it back up. But that transfer from Alvin Guzman to myself to Amy Siewert took place in a matter of hours, not days or weeks.
Had you taken your cuttings and finished your photography and done your swabbing before you passed it on to Ms. Siewert?
Correct. I took everything I needed. I did all of my analysis because I knew that was going to be transferred on. And once another section gets a hold of that and they're testing it for latent fingerprints or firearms exams or whatever they're doing to it, that could potentially affect my ability to get results. There's always an order at which the evidence goes from section to section.
So the way the sequence went in the lab, Mr. Guzman started with the trace.
Correct.
And he wouldn't apply chemicals for that sort of thing.
No.
It's more of a visual inspection and then collection of fibers and such.
It's called sweeping, what he does, and I've never done it. I'm not trained in how to do it, but I have observed him doing it, and he's basically brushing the item to collect any kind of trace evidence, any kind of fibers or small strings or outside grass debris, whatever was on that sweatshirt, and packaging that into a small paper fold for any future examinations or testing.
And then it goes to you, and you don't do any chemical application to the fabric itself, or do you?
No. I perform that chemical test for the possible presence of blood. I rub a piece of filter paper and then test the filter paper. And if that's negative, I take a small cutting from the stain and I test directly on the fabric from that small cutting. I never actually drop any kind of chemicals onto the actual garment itself.
So you do a very careful inspection, no doubt, but it's to look for something that may be blood in your mind, or
Correct.
some biological evidence of some sort.
Correct.
And when you see it, you then use the filter paper, and then you may test the filter paper.
For the blood test, yes.
And that would give you the presumptive test that, hey, this is blood?
It gives me positive or negative result for the possible presence of blood.
If you get the negative, I think, as you've talked about on some of these items, you're satisfied that it's not blood, so you don't do any more testing typically.
It depends on the scenario and the item, but if I'm looking for blood stains on an item and something tests negative, then I'm not going to go on and do DNA testing on that stain.
And there are a number of items or number of spots or stains where when you got a negative with the rubbing, that was the end of your analysis as far as that spot was concerned.
Correct.
And then when you get a positive, you know it's positive for blood, but that then, in the sequence, you'll then do the DNA analysis on that spot. Do you go back and swab the spot, or do you test the filter paper?
No, I take a small cutting. I take a scalpel and I cut out a portion of that stain. As we were looking at the items down below before, you saw little squares missing from those stains. Those are the portions I cut out and put into a tube in order to do my testing.
I think I heard you say that the size of the cutting is somewhat proportional to how much surface area you think you need to get a good result?
Yes, in order to get a complete DNA profile, what I think I need.
So it starts with the visual, goes to the rubbing, and then to the cutting. Is that correct?
Correct.
And then when you do the cutting is when the DNA part comes in. That's what's processed for DNA.
Yes.
Can you describe briefly what that is? What do you do at the point that you've got these cuttings?
What do you mean?
What do you do with them?
I store them until I'm ready to start the first step, which would be the extraction process.
How does that work?
I'm applying heat and chemicals to the cutting in that tube in order to break open all the cells that are in there and expose the DNA molecule. And then I'm trying to wash away all that cellular debris and everything that's in there besides the DNA. I'm trying to get nice isolated DNA from that stain.
I know this sounds silly, but you can't see any of this, right? We're talking truly DNA.
No, I can't see DNA, but I can see a tube and I can see the chemicals in the tube. It's a small tube with a little bit of usually clear liquid. Various different chemicals are used.
And then when you go through your process, you at the other end get results. And then you're able to interpret those results as to whether you believe it's from a certain individual, maybe a number of individuals, and then whether or not you can make some sort of opinion as to who it's from.
Yes.
And that would be the process that you would have used for all of the samples for which you did DNA analysis.
Yes.
So on the hooded sweatshirt, could we concentrate on your findings there just for a moment?
Yes.
Stain. I suppose we should look at the shirt itself, if we could, for a moment. Would you be able to correlate the stain that's marked on the shirt and just say what you found as to each of those stains where you were able to make a finding?
Yes.
Well, let's do that then, if we could get some help. Let's start with the hooded sweatshirt.
this? Where do you want to be?
Not leaning against the door. Down there would be fine.
Can we sit it on the table again?
Front to back.
Front?
You got it?
You got it? Yes, thank you.
You were talking about the hooded sweatshirt being one of the two items of clothing that was the wettest with the strongest odor.
Correct.
Can you tell me now, because I lost my note, where it was that the stain was that you identified as A?
Stain A is located here on the bottom, the front surface, on the front pockets.
And do you know whose blood that was?
Iris got a partial DNA profile, and that matched Trayvon Martin.
Did you exclude George Zimmerman from that?
Yes, it's a single source DNA profile, so when I match that to another individual...
I'm sorry, it's the single source DNA profile, so I match that.
when I match a single source DNA profile to an individual, that other individual is then excluded.
And you don't know, of course, how it came to be there, just that, in your opinion, that was a single source DNA sample or DNA from blood from Trayvon Martin.
When I test a blood stain, I have no way of knowing. There's nothing in my testing that tells me when or how a stain got on an item.
For example, it could have transferred from blood on some other part of the shirt, depending on how the shirt may have been positioned at different points in time.
Potentially, yes.
Let me grab that chart. Maybe that would help me better to be more precise. Was there any other blood? Stain D. Where is stain D?
There was A, B, and C on this item. B and C are on the back.
All right, that's my confusion. Is this what's known as the gray sweatshirt?
This is the hooded.
Now I'm really disoriented here. What stains are on the front, and who are they from?
A, partial profile matched Trayvon Martin. B and C are on the back.
And whose are B and C, if you know?
B tested negative for the possible presence of blood. Performed no DNA testing on that. C, I obtained positive for the possible presence of blood. No DNA results were obtained from that.
So the only stain on the outside, or the gray hooded sweatshirt that you could match to a DNA profile is A on the front?
Correct.
And were there any other stains where there might have been a partial profile that you couldn't include or exclude Trayvon Martin or George Zimmerman?
No, the only stains I got tested for DNA were A and C.
Mm-hmm.
In C, I got no DNA results. I did swab as I explained earlier, the sleeves and cuffs of this item as well.
Tell us again I know what your process was. You just swabbed it basically from the elbow down to the cuff.
Yes.
Not having seen any blood, correct?
Correct. I first used the filter paper to rub it and test that for the possible presence of blood, and that was negative on both sleeves.
Mm-hmm.
So I performed the swabbing, DNA testing, and there was no DNA foreign to Trayvon Martin on either of those.
Is that looking, though, if it's not blood, and you're pretty sure it's not blood, are you looking for skin cells or some other source of DNA, perhaps?
Yes, any foreign DNA that might be on these sleeves, which could be touch or skin cells, it could potentially be saliva. So anything foreign to Trayvon Martin, I was looking for potentially.
Frankly, then, you just didn't find much of anything on this gray hooded sweatshirt. It boils right down to it.
Just that partial profile on stain A.
That was the shirt that stunk to high heaven.
It didn't smell good, no.
Let's go to the next item if we could.
give us a moment, we'll switch out. All right. This you've described as the gray sweatshirt?
Yes.
Let me get the exhibit number, if I might, so that...
156. 156.
Oh, okay. 156. And the gray hooded sweatshirt, 155. All right, 156 has been sort of represented as the underneath shirt, correct?
And there was no representation as far as my end. They were just two sweatshirts.
But this one was quite a bit drier.
Yes.
It didn't smell as bad. It wasn't as obviously wet.
It was slightly damp.
So, same question, sorry to be so imprecise. Can you tell me where the blood is and whose it is on the front of this gray sweatshirt?
Can I get my report?
Of
So I
course.
don't get them confused.
Of course.
All right, there were stains A through E that I tested for blood.
Let's talk with, go ahead.
Stain C tested negative for blood. I did not perform DNA testing on that one. I performed DNA testing on stain A, which was
All right.
positive for blood.
Let's talk about that a second. Is that reddish brown stain on the lower right-hand side of the shirt?
Yes.
Pretty visible, I take it?
Yes.
I mean, it was obvious to you that that was a stain that would be of interest to you.
Yes.
And there's a small hole in it. Is that the cutting that you took?
Yes.
Basically, that's all you thought you would need to get a positive reading on that stain.
To get a complete DNA profile, hopefully. Yes.
Again, you don't know how it came to be there, but you know it was there when you saw it.
No, I don't know when and how.
And whose blood is that?
That I obtained a complete DNA profile which matched George Zimmerman.
Is that a single source?
Yes.
Only George Zimmerman?
Yes. There was the possibility of additional contributor to that profile in stain A, and what that means is there was a very, very small amount of potential DNA that wasn't even high enough for me to be able to interpret. So I did report out that there was the potential of additional contributor. However, that's nothing that I could ever make a comparison on. It's just a couple little blips, we call them, that I had to report out.
Okay. Continue if you would.
Stain B, I also tested, and that was a complete DNA profile as well, and that matched Trayvon Martin.
Where's B located?
B is also on the bottom, small stain.
More in the center.
Yes.
When I see that, I don't see any reddish substance at all in what you've circled there.
Yes.
Why not?
Because I cut it all out.
So you, in your cutting, you took all of what you could see, maybe blood?
Yes. If there's a very, very small blood stain and it tests positive for blood, if I feel like I need to consume that stain and cut the whole stain out for maybe to be able to potentially get a profile to do something with it, then I do that. And other examples where there's a good sized blood stain and I don't have to take the whole stain, that's what I do.
So A is George Zimmerman, B is Trayvon Martin.
Yes.
Is that a mixed sample?
No, single source.
And let's just go alphabetically. C you said was negative.
Correct.
Was not blood.
Correct.
And that brings us to D.
D was positive for blood as well. That was a mixture of at least two individuals. I was not able to resolve that into any individual major or minor DNA profiles. And both Trayvon Martin and George Zimmerman were both included in that mixture.
Can you look at the area that you're calling D, and can you still see some staining that you think may be blood?
Yes. There's still some reddish brown area there.
Like you did with A, did you just get enough of that stain to do your DNA testing?
Correct.
And there are 2 spots, it looks like. No, I'm sorry, 3 or 4, aren't there? Each of those defects from cuttings that you did?
It appears so. Stain D was a very light, spread out stain, so I took what looks like 4 cuttings and combined those into 1 tube to try to give me the best, the potential best DNA profile I could get.
All right, follow with me a second. So it's possible then, I take it, what you cut here was Trayvon Martin or George Zimmerman?
Yes. Obviously, in hindsight, you know, having a mixture of DNA, maybe I could have taken, you know, 1 cutting from here and tested that separately from the cutting from here. But I mean, that's in hindsight. I don't know at the time. It looked like one big light-colored stain, so I took several cuttings and combined it in 1 tube to try to get a complete DNA profile. Obviously, knowing what I have in the end, going back to it, maybe I could have taken those cuttings separately and gotten single source individual profiles on the separate items. It's potential, yes.
Just, for example, you might have been able to identify one or the other as from that particular cutting.
Correct.
Or from any of the others.
Correct.
But by doing them all at once, you got a full view of the DNA in those cuttings.
Correct.
And then you were able to determine that it was a mixed sample?
Yes.
And it was both Trayvon Martin and George Zimmerman?
They were both included in the mixture.
That's D. Anything else on the front?
Stain E.
Yes.
Also
That's
positive for blood.
Under the left armpit?
And that matched, complete DNA profile that matched Trayvon Martin.
I know that you also talked about the sleeves.
Yes.
You didn't see anything on the sleeves that you thought was obviously blood.
Correct.
Nothing that you would use filter on because you saw a spot.
Correct.
So tell me again what your process was?
I took a piece of filter paper and rubbed the entire lower part of the sleeve and cuff, and that tested negative for blood.
And that's separately?
Yes, both sleeves separately.
Negative.
Negative.
So what's next? What can you do next for non-blood DNA?
Just take a cotton tip swab and swab it for any foreign DNA. That would be touch skin cells or potential saliva.
So let's talk about the left and the right. Just start with the left. What were your findings there?
Left sleeve or cuff. I did get foreign DNA to Trayvon Martin. However, they were limited foreign results that I could not match to anyone, and I was not able to determine if George Zimmerman was a foreign contributor to that sample.
Is that, as you said before, you can't say he was or can't say he wasn't the contributor of that DNA?
Correct. It's an in-between state.
So it could have been, you just can't say it was.
I wasn't able to exclude him.
And how about on the right side?
I was not able to get anything foreign to Trayvon Martin on the right sleeve.
Does that mean you were able to find DNA that was attributable to Trayvon Martin?
Yes.
But you were looking really for DNA that wasn't?
Correct.
Anything else on the front?
No.
And let's just take a look at the back. I don't remember there being stains on the back, are there?
No.
Just display this for a moment, and then we'll take it back. Mr. Gorgon, looking at the back here, there's no cuttings, no markings. Can't quite help these things. Nothing here that
There were
you
no
analyzed.
No cuttings that I took from the back.
Great. Okay.
Go ahead and take one.
And I do want to talk with you, though, briefly about George Zimmerman's outside jacket, the orangish red jacket.
Yes.
Without going through all of the samples that were George Zimmerman, were there any spots on that outside shirt that were or could have been Trayvon Martin's blood?
On the orange jacket? Yes.
And let's do this one more time. You can point that out.
Yes.
Let's just have you focus on the stain or stains that were or could have been Trayvon Martin's.
The ones I matched or included Trayvon Martin on?
That you matched or couldn't exclude.
Okay. Stain E, which I don't believe is on the front. Stain N, which is on the front, located right here on the front right shoulder. That was a mixture. That was the mixture that I was able to resolve a major as well as a minor contributor. The major contributor matched George Zimmerman. The minor contributor matched Trayvon Martin.
When you say major and minor, you're talking about more from one, more blood from one than the other?
Well, more DNA from one than the other. Major would be the more DNA, minor would be the lesser DNA.
Can you still see some of the staining from N that you talked about on the jacket?
Yes.
The cutting that you took in the same fashion you'd done before was a visible stain that was positive for blood with the filter paper rubbing.
Yes.
And is representative basically of what you thought you would need to get a reliable DNA result.
Yes.
You didn't test any of the other specific spots.
The whole stain was rubbed with the filter paper for the blood test.
Right.
But
Just-
as far as the DNA testing, these were the two cuttings that I took and put in a tube. There's one clearly visible, and there's actually one on the interface, so to speak, between the two colors.
So sort of like stain D,
Yes.
I think. Looking back, you may have chosen to make separate cuttings within the larger stain, but in this case, the DNA results were a combination of both of the cuttings.
Correct. It's possible that one cutting was one, could have been an individual profile in this one, but it's possible they both would have been mixtures, regardless of whether I tested them separately or together.
But there's no question in your mind, as an FDLE DNA analyst, that that was a mixed stain that contained both the DNA of George Zimmerman and Trayvon Martin.
Both profiles matched the two individuals.
Anything else on the jacket that relates to that it was Trayvon Martin's blood or that he was not excluded?
Stain U, which is right here, if you can see on the bottom of this cuff. That's stain V here, but on the bottom is stain U. That was also a mixture.
The right cuff, am I correct?
That is the right cuff. That was also a mixture of DNA that Trayvon Martin was included as a possible contributor. And I did not make any determinations on George Zimmerman to that specific stain.
Same sort of technique, you rubbed it and
Yes.
then made cuttings?
Yes. Stain V, which is right next to stain U. That one was too limited for me to be able to make a match. However, I was not able to exclude either of the two individuals.
V could, from the limited information you had, could have been Trayvon Martin. You couldn't say it wasn't, but you can't say it was.
Correct.
V is represented by this larger circle with the 3 separate cuttings?
Yes. That's it for the front.
Okay. Maybe just flip the exhibit. Now we are looking at the back of the jacket in Exhibit 151.
There were two on the back. I was not able to make a determination if Trayvon Martin was present.
Excuse me a moment, I'm just going to pass. Thank you.
All right.
Thank you, go ahead.
Stain E, which is right up here on the back of the right shoulder, the right-hand shoulder, with the 2 cuttings. That one was a mixture where I was able to resolve a major. I matched that major, complete major, to George Zimmerman, and I was not able to make a determination or exclude Trayvon Martin. And then the last one was stain double B, which is also here in between the 2 colors. That one was also a mixture. That George Zimmerman was included in that mixture, and I was not able to make a determination on Trayvon Martin or exclude him.
Okay. Is that it?
That was it.
We'll put this back. You may take your seat, please. Thanks.
Your Honor, if I may have just a moment, I'm nearing completion here.
Yes, ma'am.
Thank you, Mr. Gorgon.
Thank you. Redirect.
Yes, Your Honor. What's been identified as the defendant's hooded, or, I'm sorry, jacket, the red jacket, red and black jacket?
Yes.
The one you just talked about. You mentioned exhibit stain U, I think it was,
Yes.
and you mentioned that you said the right cuff, right? Did I get that right?
It was on the right cuff, the bottom of the right
Okay.
cuff.
And you said Trayvon Martin could be included as a possible contributor, correct?
Correct.
Okay. May I approach the witness, Your Honor?
Yes, you may.
Okay. Let's assume I'm wearing that red jacket, correct?
Okay.
And so you're saying on the right side, right here, some of Trayvon Martin's possible DNA is there, right?
Potentially, yes.
Potentially. I'm just saying he's included as a possible, correct?
Yes.
Okay. So if you're Trayvon Martin, may I approach the witness, Your Honor?
Yes,
And I promise I won't hit you.
I'm sorry, there's an objection.
To a hypothetical with the witness beyond the scope of cross that is asking this witness to
speculate about an area for which he said he has no expertise. He's a DNA analyst, not a...
Okay, that's a speaking objection.
Yes, ma'am.
So if you want to approach, you may do so.
Right jacket. You're saying on the defendant's jacket or George Zimmerman's right jacket, correct?
The right arm.
I'm sorry,
yes.
right arm on the cuff, you said there could be Trayvon Martin's DNA, correct?
Correct.
Okay. And so that had to have, if it was Trayvon Martin's potentially, it had to have come into contact with Trayvon Martin, correct?
Objection.
This witness is not qualified to answer that question because of all sorts of
Okay,
other...
no speaking objections, but he could testify if he knows.
In other words, that had to be deposited if it was Trayvon Martin's, if he's included as a possible, it had to get there somehow, correct?
It had to have come into contact with some kind of bodily fluid
Of
from
Trayvon Martin.
Trayvon Martin or skin cells from Trayvon Martin.
Right, correct?
Correct.
And I think Mr. West asked you twice, you don't know what you don't know, right? Remember him telling you that?
I don't know, yes, correct.
Okay, in other words, there could be a rat right under this table, but you don't know, right? That would be pure speculation,
Correct.
right? Unless you came down here and looked and saw a dead rat or did see a dead rat, right?
Correct.
But what you can unequivocally say as to the defendant's jacket, that in his right cuff, or, I'm sorry, Zimmerman's jacket, there could be, potentially, there's DNA there, and it could be Trayvon Martin's.
He was included.
He was included as a possible. I apologize.
He was included in the mixture I obtained from the bottom of that right cuff.
Now, how it got there, you don't know because you weren't out there.
Correct.
Could be from all sorts of possibilities.
Correct.
But definitely, it made contact with potentially Trayvon Martin's DNA.
Objection. That's a confusing question, if nothing else.
Okay, do you understand the question?
Yes.
Then you may answer.
Please.
He is included as a possible contributor, and if his DNA is, in fact, part of that mixture, it would have to have come in contact with some kind of bodily fluid or skin cells for me to have been able to get that result from that swab or a cutting of that cuff.
And you also go, still focusing on the red and black jacket, you also said that stain U, I think? Or did I cover, I'm sorry, stain R? Did I get that right, or have I got?
No.
I'm sorry, stain U was the right cuff, if I got that right?
Stain U was the one we were just talking
Right,
about.
but it's the right cuff, meaning right here, right cuff, correct?
Right cuff on the right hand.
I'm sorry, on the right
Yes.
hand, I apologize. And I think you were also asked about the victim's, I'm sorry, Trayvon Martin's hooded sweatshirt, the one that, assuming he wore that over, the regular sweatshirt.
The dark gray hooded
Yes,
sweatshirt.
with the hoodie,
Yes.
correct? Now, did I understand you correctly that you examined that and you did not find any of George Zimmerman's DNA on that?
There was nothing that matched, or he was not included in anything from that sweatshirt.
So
Correct.
in other words, you tested, I think you said 5 different, or 3 areas, A, B, and C, and then you also tested his right sleeve and his left sleeve, I'm sorry, the hooded jacket's right sleeve and left sleeves, cut right from here to here, and you didn't find any of George Zimmerman's DNA on there, correct?
Objection, asked and answered.
Pardon me? Yes.
Right, overruled.
You understand my question, sir? I'm gonna
Yes.
repeat it. Okay. You did not find on Trayvon Martin's hooded, you didn't find, you tested from here to here, and you didn't find any of the defendant's DNA on there, correct? George
There was
Zimmerman's
nothing.
DNA.
Now it's been asked and answered, sustained.
And on the other parts, A, B, and C, you didn't find the defendant's, or George Zimmerman's DNA, right? On the other parts of the hoodie?
I didn't test B, but A and C, there was nothing that matched him. No.
And B was negative as to blood.
Correct.
Thank you. No further questions.
Mr. Gorgon, thank you. Addressing your attention to the right cuff area of Mr. Zimmerman's red jacket. States 151.
Yes.
Your testimony is that there's DNA there that you were able to identify.
Yes.
You don't know how it came to be there, I take it.
Correct.
You don't know if it was connected with the gunshot itself, or whether Mr. Martin may have had an abrasion on his knuckle.
Objection now is a speculation as to.
Oh, let me hear the rest of the question. Go ahead and continue. your
That
question.
Mr. Martin may have an abrasion on his knuckle that was bleeding, that came in contact with Mr. Zimmerman's cuff. You just wouldn't and don't want to speculate how it came to be there.
All I know about that sample is it tested positive for the possible presence of blood, and I obtained a mixture in which Trayvon Martin was included in.
Thank you.
Any redirect?
No, Your Honor.
May Mr. Gorgon be excused?
Yes, Your Honor.
Okay, thank you very much, sir. You are excused. Yes. Ladies and gentlemen, we're going to go ahead and recess for your purposes for this evening. I would like to start Friday morning at 8:30. When you're the overnight and Thursday recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves nor with anybody else. You're not to use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Okay, enjoy your evening. Have a good 4th of July. We'll see you Friday morning at 8:30. Please put your notepads face down. Please be seated. Council approach. Court will be in recess until Friday morning at 8:30.